Code under section 18.1.501, which they did with criminal negligence. They set forth a definition, and moving apart from that is inappropriate and violates the statutory premise when the legislature has the authority to define what culpable mental states mean. Further, this is a deviation from the Colgy pattern instructions, which include a definition of criminal negligence that exactly tracks 18.1.501 sub 3, which is the definition. This is also embodied in the use of force in special relationships to the extent that they want to use it. Additionally, we don't apply a separate reasonable person standard under the Luna case, and I will get the court. It's 474 P 3rd 230. This was one of the cases where they looked at whether it's a reasonable juvenile because it was a juvenile who was involved in the adjudication. And the court found that in that case, we don't use a different definition for criminal negligence. We maintain the statutory definition, and we assert that that is the appropriate thing to use in this case.
All right. The court would find that from time to time, the General Assembly looks to the civil law for certain terminology, as they have done in Colorado for the offenses of vehicular homicide, vehicular assault, careless driving resulting in death, where they specifically adopted the civil standard of proximate cause. The court would find that the General Assembly, I suppose, would be within their province to adopt different standards of negligence or recklessness specific to certain occupations if they wish to do so, but they haven't. So the court's going to follow what the General Assembly has told me I'm supposed to do. The next one I have is the is the definitional instructions, I guess. I guess we'll start at the top with administer. That is out of presumably 1818. On behalf of the defense, with respect to that.
Judge, what I'm concerned about is this whole practitioner or in the practitioner's presence by the practitioner's authorized agent or the patient at the direction in the presence of the practitioner. I don't think that that's, I think that that's an extension. And I think if you want to say administer means to apply a controlled substance, whether by injection, inhalation, ingestion, or by any other means. Oh, sorry. Whether by injection, inhalation, ingestion, or by any other means directly to the body of a patient. I don't mind going that far, but I think going past that, we're getting into, it's convoluted. I think it's clear that the paramedics were authorized to use this medication based on the medical director's authorization and protocol, but this language is cumbersome and confusing. So I would object to the second part.
Comment on behalf of Mr. Cichuniec.
Doing that as well as add that the way that it's worded without a definition of who constitutes a practitioner, and it's worded to suggest that a practitioner of a controlled substance outside the presence of the practitioner, outside the presence of the practitioner, that they have done something wrong. And there's some question as to whether any of these practitioners.
All right, on behalf of the prosecution on that one.
Your Honor, we don't have an objection to that. So what our proposal would be in that case would be having it continue with the definition that we have so far out of F09, but stopping at directly to the body of, and rather than patient, we would say another, and just ending the sentence there.
All right, might come back to this one.
Yes, Your Honor.
I don't know how what are the things that Dr. Hill approves? I thought it was like the whole big package is called something. I know that there are protocols, but I thought.
But Your Honor, the actual authority that deliver the medicine is called standing order.
All right, well, I guess we'll get back to that once we get to the affirmative defenses. We have bodily injury, which tracks the, make a note, we'll come back to page 10.
No objection to bodily injury.
Conduct?
Judge, on behalf of Mr. Cooper, we do object to that definition even being included. I don't think it needs to be defined, and I think means an act or omission. And we're going to have, I have significant argument as to anything implying failure to act or omission to act is appropriate in this case. This gets extremely dangerous. I think failure to act is error to advise any of these jurors about. There's more argument when we talk about cause, but specifically with respect to this case, Judge, at the bill of particulars, when we were having that argument, we asked specifically if what the prosecution was alleging was the administration of ketamine, was what the underlying act was. And they said yes, and the circumstances surrounding it. And I said, I want to be clear, we're talking about the administration of ketamine. And the prosecution said yes. And I said, based on that record, and the court said, that's my understanding as well. I said, based on that record, then we're not asking for further. We were not on notice. And now throughout this trial, we've listened to this interwoven theory that failing to intervene, failing to act somehow is part of the crime they're alleging. And that has never been what we've been on notice about, what we were prepared to defend against. We discussed it at the bill of particulars. We moved forward that everything was around the administration of ketamine. Now, we understand that people can argue that by failing to do certain things, you brought yourself to the wrong protocol, and therefore giving the drug is an error. But to suggest that an omission to act or an omission is somehow in any way, shape, or form appropriately an issue by itself is an incorrect statement, and it's not something we've been on notice of at all.
All right, well, let's, in a sense, we're having this discussion, go down to the definitional, it's down toward the bottom of the page, I guess, omission.
We would ask that that be removed. Judge, I can tell the court I was asking conduct, consent, deadly weapon, and drug, lawful medical or therapeutic treatment, and omission all be removed. There is no dispute as to what the drug is in this case. They don't need a definition. We all agree the drug is ketamine. But we would object to any of those 1, 2, 3, 5, 6 definitions being provided to the jury. I don't believe that.
I was just on omission.
Okay.
I wanted to stay on that.
Omission means a failure to perform an act as to which a duty of performance is imposed by law. Again, omission to act is not an issue in this case. And Judge, it's.
Well, in the court's view, first of all, omission is mentioned in conduct, and omission is the definition is the Kolji definition, but it's a duty of performance imposed by law, and I'm trying to figure out what duty we're talking about that is imposed by law.
Right.
From the people?
Your Honor, we're happy to remove the definition of omission. I know that this court has done that previously. We do believe that conduct means an act or omission, and I'd also like to correct the record regarding the notice of omissions regarding the bill of particulars. At that hearing, Mr. Slothauer represented to the court and to defense counsel that the people were charging the circumstances of the administration of ketamine from the time the paramedics arrived on scene, which included both their failure to assess and their failure to monitor afterwards. So the defense has absolutely been on notice of this since we had that discussion, and the indictment speaks for itself regarding the omissions at issue there. But we do believe that this Colgy definition of conduct is accurate. If the court would like further argument on that, we're happy to provide it, but we're also fine with removing the subsequent definition of omission.
All right. Well, the court does note that the conduct is defined by statute as an act or omission, but there are certain cases where omissions are fairly obvious, and that's where somebody might have a special duty of care. For example, a parent or caretaker in a child, placing a child in a position where posed a danger to the child's health or well-being. Clearly, that particular offense contemplates the legal definition of omission, as there are certain duties that are really imposed by law there under the child abuse statute. The court would find that, when we were there was the discussion with respect to the circumstances of the administration of the ketamine, that yes, it was discussed that they failed to, at least the allegations where they failed to do certain things, including the assessment and monitoring. But again, the statutory definition of omission is a duty imposed by law. So I'm going to agree with the defense on that one and take out or omission under the definition of conduct.
Your Honor, for the record, there's just one additional statute we'd like to point the court to, and that is 16.3.4012. Persons arrested or in custody shall be treated humanely and provided with adequate food, shelter, and if required, medical treatment. So we do believe there is a statutory definition, particularly when the paramedics were called to scene specifically to provide medical treatment to a person in custody. So we'd just like to add that for the record, that we understand the court's ruling.
I didn't look at that one. Let me take a look. All right, the court's, had the opportunity. I just went to the section that talks about charging the patients. That particular statute reads, no unlawful means of any kind shall be used to obtain statement, admission, or confession from a person in custody. 2, persons arrested or in custody shall be treated humanely and provided with adequate food, shelter, and if required, medical treatment. Anyone receiving medical treatment while held in custody may be assessed a medical treatment charge as provided in 1726-104.5. The court doesn't find the context of that particular statute is persuasive to the court in this context.
Your Honor, and I just want to clarify, so we are removing both an act or omission. So we're moving just the omission part from the definition of conduct and then the subsequent omission. Do I have that correct? From page 10?
Yeah, the way it would read is conduct means an act and its accompanying state of mind, or where relevant, a series of acts.
Yes, Your Honor, thank you.
And you really want drug out?
Oh,
That actually,
I didn't mean it.
it looks like it would inure to the defense benefit since it,
Judge, it was consent was the next one we wanted out. A deadly weapon,
okay.
consent and deadly weapon, you know,
Well, I don't have deadly weapon.
Your Honor, the people removed deadly weapon in the updated version.
Okay, yeah. I do have consent and we'll table that one for a minute.
I'm okay with leaving drug in. I was marking things up, and I'm okay with leaving lawful medical or therapeutic treatment in, I guess, in terms,
Well,
it just seems,
let me read what I have.
yeah.
Um, okay, any further record on the lawful medical treatment?
I was just looking at the statute that's cited. I don't,
It's better than my version, I can tell you that.
I was just thinking we could say, to the extent we need a definition, is a recognized form of treatment for a medical purpose in a manner consistent with reasonable medical practices. But I don't even think that that's in a manner consistent with, in this case, it would be protocols. So it's just,
I think the terms practices and protocols are fairly interchangeable.
Your Honor, if the defense is objecting to the instruction, one option might be to save this if there's a jury question. I don't know if the defense would like a definition for this or if.
Well, it's
confusion.
actually it's in one of the elementals for the
Yes, Your Honor.
drugging second degree assault. So I think we would need some guidance from the court of generally what that means. I know this is gleaned from a different statutory scheme, but it kind of makes sense. I kind of started messing with the Col G3 -4:25, and actually mine is not all that good in this context.
I guess I kind of concur with the Attorney General that I think we could, in this case, we could remove it. If there is a jury question, we can formulate one at that time. The reason being, they have a protocol submitted, so that can guide them as to the treatment, as opposed to having a broad-based general concept.
Let's table that one too, because I think that a lot of these things are going to come together when we start talking about the proposed use of force instruction. Was it 703? So, yeah, so a lot of these kind of feed into that, as well as I suppose the drugging instruction. So so I guess we'll come back after we discuss those instructions and figure out what we want to keep and what what we don't want to keep.
Okay.
All right. We have the elemental instruction for reckless manslaughter.
Your Honor, I don't think we addressed serious bodily injury.
Oh, well, yeah, I was going to give that one. But the ones that seem to have a little bit of conflict, I suppose, are consent, drug, and lawful.
There's one difference between the two proposed SBI instructions between the people and the defense. The defense had included or breaks, fractures, or burns of the second and third degree. We don't object to including that portion of the second degree assault, but because it's not at issue here, we'd removed it. Especially because there is some evidence that Mr. McClain suffered unrelated burns in the hospital due to the Gamar wraps. So we didn't want any potential confusion about burns. And there's no allegation of fractures, but we agree that the statute does discuss burns and fractures.
We can.
Well, I guess that I think I have a pretty good recollection of this trial for the last 3 or 4 weeks, but I don't recall that photograph of or a description of, because there was the x-rays. I think the chest x-ray was admitted in one of the prior trials. There was some discussion about what the things on his back were, and that I don't think that exhibit was admitted or testified about in this trial. So
Yes, Your Honor, I think it sounded like Ms. Bagan agrees with removing the irrelevant portions. Is that correct?
I don't object to tightening it.
okay, I mean, that kind of makes sense. Surplusage, I don't think is helpful. Okay.
And you're on the correct questions.
Okay. All right, so we'll come back to page 10 after we discuss some of the other ones, I guess. Okay, now we're to the elemental on page 11 for reckless manslaughter. The only difference is that I noticed is there is a without the affirmative defense of, but there is in the annotated version, the people cited to the Pickering case.
That's correct, Your Honor. And talking about if we're having the conversation about affirmative defenses here, I would note Pickering has been clarified in Pearson 2022 CO4 Colorado 2022, where what the Supreme Court has said is if a defendant admits to conduct giving rise to the charged offense, and the defendant essentially acknowledges the presence at and participation in the event, but claims they were legally justified in doing so, and that justification is sufficient to render the participant exempt from criminal responsibility, then we're in the affirmative defense land still. It's not a traverse. And it cites to Huckleberry at 768 P. 2nd 1235. So under Pearson and Huckleberry, that is the controlling. And while I note that Pickering had this, I would say, dicta in terms of the relevance to reckless and negligent conduct, what Pickering's focus was, and the reason I say dicta as it relates to this, is it's controlled by self-defense. It's all of the Pickering cases and case law interpreting it have been only dealing with issues as it gives rise under self-defense theories. And no case has dealt with it saying, do you lose an affirmative defense if you're in the land of negligence or recklessness by itself? To bootstrap that on and to block other delineated affirmative defenses that weren't at issue, weren't litigated, and have not been discussed it would dramatically impact Mr. Cooper's constitutional rights. The legislature has set forth very clear affirmative defenses that would be applicable in this situation through the special relationships, and they would be applicable to these charges as well.
Do we have a new site on that? Yeah,
22 CO4.
that's not coming up.
Colorado v. Pearson, Pearson. Justice Birkenhotter wrote the opinion.
Your Honor, we have the site
Okay, that could be helpful.
502 P. 3rd 1003.
All right, from the people.
Your Honor, I think Pickering resolves this issue when we're dealing with crimes of reasonableness or recklessness. It is still a reasonableness question, and Pickering tells us that this is a traverse. Pearson doesn't change this analysis. There it was about harassment and whether it's to harass, annoy, or alarm, and you can still defend yourself even by annoying. So this is also a self-defense case. It does not alter the holding of Pickering, and I think in this case, it is still an element negating traverse, even for the defendant's proposed affirmative defense instructions. I would note that while the pattern instruction does list the option to include affirmative defenses, there's really a very narrow class of affirmative defenses that can be used in crimes of recklessness. Some of those might include statute of limitations or involuntary intoxication, but even use of force in special relationships requires that it be reasonable. By proving recklessness, we necessarily disprove that element. It's an element negating traverse, and no instruction is required here.
All right, the court would set a chance to peruse the Pearson case and would note in the context of that case, the charged offense was harassment, and the court found that the affirmative defense of self-defense could be applied in a harassment context. But it's important to note that harassment is a specific intent crime rather than a reckless or negligent crime. So at least at this point, the court doesn't plan, but there is the instruction. I don't know whether I saw it or not, to be honest. It's the, I guess, the Pickering traverse instruction that that included in this packet?
It's not included here, Your Honor. I think it's something that we can discuss as we get to the affirmative defenses, and that's probably the most appropriate place to look at it.
All right. We might come back to 11 then. All right, the next is the bridge between reckless and crim deg.
I apologize if I can.
Yep. Yes. Sure. So will I. Form over substance, I No problem. We're discussing the bridge between manslaughter and criminally negligent homicide. I had a brief discussion with counsel for the people about trying to squeeze it onto one page, or I suppose the alternative to that would be put the last paragraph on page 2 along with, because the way that I received it, we had reckless manslaughter on page 1 and criminally negligent homicide sitting by itself on page 2. But anyway, on behalf of the defendants on the bridge.
Judge, subject to coming back, if to the extent the court adopts the defense argument and adds the affirmative defense, that'd be the only thing we would add here. So
Okay,
I would join that, Your Honor. Suggest, in terms of clarification, the last paragraph. While you may find the defendant not guilty of, I would suggest putting in. While you may find the defendant not guilty of both manslaughter and criminal homicide, may not find it.
people's thought on that. And I think, okay, yeah. Well,
I think we can add the both, Your Honor.
okay, I think that's reasonable.
I'm just trying to look at it and see if we also need a both and or to make clear to the jury that they could look at either one, but I think just both would solve it.
Okay, yeah, I think relating back to the instruction on the separate offenses and separate defendants, it gives some clarity. All right, now we're to page 14, which is the second degree assault with intent to cause bodily injury causes serious bodily injury. And that one does have a paragraph 6 in it. I suppose we'll get to the affirmative defenses, and once we get through that discussion, we'll figure out whether we need to make defense and instruction plural or not.
Yes, Your Honor.
But we can get there. But other than that, any objections from the defense with respect to the instruction for second degree assault causing? The next one is the unlawful administration, I guess.
Your Honor, in this one, we'd note that we'd remove the drugs or substance to just be drugs everywhere it's referenced, which I believe there are at least 4 references here based on the court's prior order that will follow the Colgi pattern.
So you're taking out substance?
So in the parenthetical, not in the element. So for example, on the first paragraph, it would say each defendant is charged with the crime of assault in the second degree, unlawful administration of drugs, period. And then,
Or parent?
correct, Your Honor, parent, period. And the same would be true for each of the subsequent references to the crime.
Okay, the defense's thoughts on that?
we'll stand on our prior request, Judge, where we asked to include for purposes of unlawful medical treatment.
Same here.
All right, sorry, I'm not quite following.
Back in, I don't remember, the first or second, I think it was page 2, where we had it listed as second degree assault, unlawful administration of drugs / unlawful medical treatment in the defense proposed instruction. The court had overruled that request, so we're just standing on that. So
Okay.
that's additional.
All right.
And again, the defense is or defense, depending on when we get there.
Okay, now we're to page
And I'm
6.
sorry, just to clarify. for the record. So, element 6, you're keeping those terms in there in element 6, you're not eliminating.
Correct. Just trying to stay consistent with Colgi Crim 3-212.
Thanks.
All right, now we'll move to page 16, which defines cause. And I suppose segues into the eggshell skull rule in Colorado.
And Judge, we object to the definition of cause as proposed, I would note that the definition under Black's law is that which produces an effect. I would also note that under Savage or Rodriguez, Stewart, and Hamrick, a cause which in natural and probable sequence produced the death, it is a cause without which the claimed injury would not have occurred. If it began a chain of events, the natural and probable consequence of was the decedent's death. Those are all different definitions of cause. Again, this incorporates this act or failure to act. We object to the or failure to act portion of that in the top paragraph. And in the bottom paragraph, this becomes extremely concerning, especially under the fact pattern we're dealing with here. Your Honor, in Colorado, it's kind of ironic when you look at Calvarisi and intervening cause cases. I say ironic because Calvarisi was talking about the subclavian artery being severed, and that became an issue in this trial about the subclavian artery. But what is more curious is Officer Rodima has been convicted of criminally negligent homicide. The testimony of the people's witnesses has been kind of a spattering of acidosis, hypoxia, and aspiration. Sticking just to the hypoxia and the aspiration, those occurred, the allegations from the people's own witnesses are that that occurred before EMS was even on scene. And they had no way of knowing it. They had no way of knowing that he had this mask on and thrown up in the mask and that a carotid was placed. And the evidence was that the carotid was not told to these two paramedics. So we set up this cause situation based on the fact that the officer has been convicted, based on the arguments in those trials that it was law enforcement's conduct that caused the death. And now they're turning around at this trial and trying to allege that it's the paramedics' conduct that caused the death. Now, in the prior two cases, they were able to ride both law enforcement's conduct as well as what occurs when EMS is on scene, because paramedics came to the scene and law enforcement was there the entire time and aware of what was happening the entire time. That is not the situation in this case at all. It becomes extremely concerning to suggest that you can pull in conduct that occurred when our clients had no way of knowing about it or being present at the scene, and somehow saying that conduct could underlie the cause of death. Furthermore, it's not eggshell skull in the sense that if eggshell skull would be, if Mr. McClain had some other situation that they had no way of knowing about, and that was just his reality. And their conduct, the active administration of ketamine, caused his death. But what the people are arguing here is not that. They're not saying, they're arguing that law enforcement's conduct basically softened him up and the ketamine finished him off, is kind of the argument they're setting forth. And that is, we're in a very complex situation then, because if it's the hypoxia and if it's the aspiration, those EMS was not even on scene for. The acidosis, I can understand, that's underlying the whole situation. So that's different. And that one I wouldn't have that objection to. But I think we're in a very complicated area, and I don't believe this is an eggshell skull situation. I do believe there is a situation with intervening. I honestly, in 25 years, have never seen intervening kind of work backwards. It's usually superseding and looking forwards. But in this situation, I think when you're looking at the case law says that the cause of the defendant's actions has to begin a chain of events, the natural and probable consequence of which was the decedent's death. Then you can only look at what our clients did, not what occurred beforehand, and bootstrap that into cause. So I think we either have to stick with that which produces an effect, or we can stick with a cause which in natural and probable sequence produced the death. It is a cause without which the claimed injury death would not have occurred. If it began a chain of events, the natural and probable consequence of was the decedent's death. Those are all appropriate definitions that have been accepted by the courts, but I think we have to be very, very cautious that we're not bootstrapping in this eggshell skull and commingling it with law enforcement's conduct that's previously been argued to be the cause of death. And if the court needs the cases, you probably, I don't know if I rattled them off. Saavedra, Rodriguez,
I'm familiar with.
Stewart, I think you're probably familiar with 55P third one,
Yes.
24P second, 1320.
All right, for the people, I guess, or for Mr. Cichuniec, if you have something to add.
What does it tell that it made? And this whole eggshell skull construction suggests to me that there is prejudicial error in the use to the jury. It suggests is they can take the evidence that they have heard and narrow the descending artery, this pre-existing heart condition, the pre-existing conditions that were apparent, he was apparently suffering from hypoxia, acidosis, aspiration, and simply tell the defendants it's too bad that he had those things and that he died as a result of it. No idea that he was suffering from those things, the fact that he provided him a drug designed to prevent those things and calm them down. What's causing death? Then here his hands are tied. So they have to accept him as he was not. I just struggling kind of. It seems to me that it leaves the defense causation without the ability and evidence that they had no knowledge.
All right, from the people.
Your Honor, under each of the elementals, the people still have to prove that the defendant actually caused death, that the defendant's actions caused death. This instruction doesn't change that, but it does clarify, and it conforms exactly with the definition in Archuleta, which is People v. Archuleta, 411 P. 3rd 233, Colo App at 2017, follows this exact definition, and it recognizes that in criminal law, we do take our negligence principles from torts. So the defendants do have to take the victim as they find him. Here, Dr. Sundaram certainly raised evidence of a prior condition of the victim, and it is not a defense to the defendants that he suffered from this narrowed coronary artery. However, the people still have to prove that the defendant's actions caused death. So if the jury were to find that Mr. McClain died solely from the narrowed coronary artery, that is simply a finding that there's no cause. But here, if the jury found that the ketamine contributed and that someone without a narrowed coronary artery would not have died, it recognizes that that is not a defense. The defendants must take the victim as they find him. And that's consistent with Archuleta. It's also consistent with Saavedra Rodriguez. And here, their efforts led to his death. It's irrelevant whether he was robustly healthy or weak. We still have to prove the elements. The conviction of Officer Rodima does not change this. And it is also the second paragraph of this instruction. If more than one act or failure to act contributed to the claimed injury or death, then each act or failure to act may have been a cause of the injury or death. That's entirely consistent, and it's similar to the instructions given in Officer Rodima's case, that there may be more than one cause of death. So long as the jury finds that this is one of those causes, that is perfectly acceptable under the cause line of cases, including Saavedra Rodriguez, Lopez, Calvarisi. I'm happy to talk about the intervening cause if the court would like to go there at this point, but I think we may not be quite there yet.
Okay.
And Judge, I guess I would just supplement the record that these are the court's instructions. This is not for either side to be arguing their theory of the case. So I'm very, very concerned that this whole second paragraph is prejudicial in that it's basically trying to.
You mean the third paragraph or second?
I must be working on a wrong version.
I know we must have a different version. I only have
Two paragraphs.
Oh, well, they uploaded a version sometime on the 18th. It's called the updated version or something like that.
We can email it to counsel if that would be helpful.
Just so I'm aware, what's the second paragraph you're referring to, talking about?
It says the first paragraph starts with the word cause.
Yes.
That only thing in that one was take out or failure to act. The second paragraph on the one we have says if more than one act or failure to act.
Your Honor, I believe the difference is we added a paragraph break. So the third paragraph for us begins with the word however, but is otherwise
That's the
unmodified.
Hamrick part of it. Is the,
Yeah, we just have a second to.
We're getting that. sense.
well, let me tell you what I'm thinking. In the context of the evidence in this case, the court doesn't find it necessary to give the third paragraph Hamrick instruction. However, I think the first two are really what the law is, and with respect to cause. Now, I think there's been some argument about failures to act, but in the context of this case, I suppose some of the failures to act on behalf of the defense could be attributed to the law enforcement officers who didn't relay important information to the treatment providers. Like didn't tell them that you'd been said he couldn't breathe 7 times. That could be a failure to act that contributed. It's a contributory cause, but that's my way of looking at it.
So I'm not even sure what the instruction that the court's looking at says. Because
It's the paragraph says if more than one act or failure to act contributed to the claimed injury or death, then each act or failure to act may have been a cause of the injury or death.
So again, I think the concern I have is it is clear that failure to act under Lopez is an error. It requires an affirmative action by the defendant, not an act of omission. And so here, this is the court directing, if I'm looking, what does cause mean? It sounds like the court is saying, well, failure to act can be cause, and that's not an accurate statement of the law. It requires an affirmative action by the defendant, not a failure to act by a defendant. And furthermore, Judge, there's been suggestion by the people that there was a duty to intervene, and the law is crystal clear in Colorado that there is no duty to intervene at all. And we've been forbidden from explaining changes in the law since, where a duty to intervene has now been made part of the law for certain people, but still not for paramedics. So I think having any language about failure to act is, as it relates to these defendants and the cause of death, is a misstatement of the law. You might have to take situations where underlying issues, that's the eggshell skull, the court, I won't go there again, but failure to act, I think, is extremely problematic. This requires an action, a volitional act of the defendants, and that act has to be the cause of death. And to bootstrap in failures to act as a backdoor way to argue that they caused the death is extremely not only problematic, I believe it violates our client's constitutional rights.
How would you all of those come?
Your Honor, if the court's ready, the people do have a brief response.
Okay.
Your Honor, in this case, failure to act is also an affirmative choice. It is an act. The defendants are present on scene. They administer ketamine. This is not acting out of a void. We are certainly not arguing, nor is there any evidence that the defendant simply should have come in and removed law enforcement from the scene, but they did have a duty to treat their patient. There is ample evidence of that, and that their affirmative choices not to do so and injecting ketamine under these circumstances joins into their choices and their acts. And we believe that this instruction is a correct understanding of the word cause in this case. Additionally, I would note that the defense has also just argued that they will be arguing eggshell victim, and that that is one of the defenses that they will be asserting in this case, that Mr. McClain had prior conditions that caused his death. So the people assert again that this would be an appropriate instruction, though we understand the court's order.
All right. Again, in the context of the evidence in this case, the court's going to remove fair to act and add a series of acts. So act or series of acts would replace the fair to act in paragraphs 1 and 2. And I think this kind of segues into the intervening cause instruction Ms. Began was talking about a little bit. What troubles the court is foreseeable. It seems to be looking toward the future rather than to the past, so I'm not sure how it might apply, but I'll give you a shot at it.
Judge, I have to say, we went back and forth, and as I just said, 25 years, I've never seen it apply prospectively. Frankly, I was expecting to go through and take it out. But in looking at the elements of the intervening cause, that's where it was like, oh, wait a minute. If the underlying act, again, solely talking about hypoxia and aspiration, was not reasonably foreseeable, meaning they didn't know and had no reason to know, like they couldn't have anticipated coming on the scene that this had happened and they weren't being told about it. It is a unusual way to look at it, but under our unique fact pattern, it certainly had nothing to do with their conduct. It certainly was not foreseeable by them coming onto the scene that this stuff had occurred and they wouldn't be told about it. And it by the people's own witnesses, could be the cause of death. So I agree it would be a very unique and unusual use of it, and I've never seen it, but I also felt like I had an obligation to raise it given the way it breaks out through the case law and the instruction. Judge, it would be a first that I'm aware of. So.
Okay. On behalf of Mr. Cichuniec, with respect to the intervening cause.
I would.
All right.
This case is so actually convoluted and standard experience.
All right, for the people.
Your Honor, there's a simple reason why no case has looked backwards for an intervening cause, and that's because by definition, intervening needs to come between points A and B. If we look at the Black's definition of intervening cause, an event that comes between the initial sequence and the end result, thereby altering the natural course of events that might have connected a wrongful act to injury. Under Webster's, intervening means to occur, fall, or come between points in times or events. So before a defendant's actions have started, no causal chain has begun. Under a simple definition of intervening cause, as well as our cases of Saavedra Rodriguez, there is simply no way that a cause that comes before can intervene. It doesn't come between points A and point B. Additionally, Salvador Rodriguez, pages 225 to 226, adds that an independent intervening cause is an act of an independent person or entity that destroys the causal connection between the defendant's act and the victim's injury, thereby becomes the cause of the victim's injury. Certainly, the defense is free to argue that other causes are the reason that Mr. McClain died, but this is not legally an intervening cause that has a specific definition, and this is not it.
And Judge, perhaps the easy way to do this then, I don't disagree with those Black's Law definition or Webster's definition, but I do think it's then appropriate to explain that cause in this case, or the cause that the defendant's conduct began a chain of events. The natural and probable consequence of was the defendant's death. That then we're not dealing with intervening, but we are clarifying, we're talking about defendant's conduct forward. I mean, it's just.
I guess what I would argue, Your Honor, and, kind of trying to peek out from my bodily frustration here. I mean, you could argue that when Cichuniec and Mr. Cooper arrived on scene, there was an ongoing intervening cause that had already started, which is the actions by the police. It started before the medics got there, and they continued while the medics were there.
All right. Well, the court would note that I suppose to a certain extent, as I mentioned earlier, the concept of proximate cause has been gleaned from the civil law into the criminal law. And to the degree that, in this case, I suppose the proposed instruction on intervening cause was more or less gleaned from the civil law as well. I didn't mention that earlier. But at least as it has been adopted by the case law, by our appellate courts, the intervening cause has consistently and without consistently been a cause that occurred after there was something happened after the initial events, and could be malpractice by a doctor after somebody caused an injury or something of that nature. I understand Mr. Lowe's metaphysical argument, but I will leave that to the more cerebral folks down at the car building to figure that one out. So I don't intend to give it.
Your Honor, if we could just clarify how cause reads so that we can double check that we're absolutely correct as we redo this.
Okay.
So the modified instruction will read, the word cause as used in these instructions means an act or series of acts that in natural and probable sequence produce the claimed injury or death. It is a cause without which the claimed injury or death would not have happened. If more than one act or series of acts contributed to the claimed injury or death, then each act or failure to act may have been a cause of the injury or death. A cause does not have to be the only cause or the last or nearest cause. If the act or failure to act joins in
Series of acts.
thank you. Act or series of acts joins in a natural and probable way with some other act or failure to act to cause some or all of the claimed injury or death. With that last modification, are we correct with the court's understanding?
That's how I have my page marked. All right. The next one is one that I figured, I don't know what folks' perspectives are. I know, and I have been told, but it was brought up today, other trials. And at the bench, I was told that other trials shouldn't be my considerations. But I guess fundamentally, the way the evidence was presented in the first two trials, we have what the acts of the officers, the carotid control, failure to position and things of that nature. And that was, there, the jury was given a complicity instruction, and they don't have to state on their verdict form whether it's principal or compliciter, I suppose. I see this case a little bit differently when it comes to complicity. I'm having trouble, as we talked about with intervening cause, attributing acts of law enforcement as a complicitor to the acts of the defendants in this case. If you're not following me, I think they could be complicit with one another, but not going backwards.
Your Honor, perhaps we could clarify that the defendants can only be complicit with acts that occurred once they are there, so that it's abundantly clear that we're not referencing back to the carotid control hold.
Well, I think what's conceptually for me, really what the defendants here are, the act that they're, the offending act, I suppose, is the administration of the ketamine. And there is evidence in the record that they cooperated, or that's probably a bad word to use, but jointly facilitated the administration of the ketamine. That's about as far as I see it going.
Yes, Your Honor, that really is primarily the people's theory, that it's the actions between Mr. Cooper and Mr. Cichuniec with each other. I would note that during the administration of ketamine, law enforcement is holding Mr. McClain prone or semi-prone. So there's some argument that the officers are somewhat complicit in the defendant's actions. But I think we could probably come up with a crafted instruction that goes towards the joint administration. I might ask for a little bit of time to submit a modified instruction on the complicity. And I think we could come up with something that would probably address the court's concerns.
Yeah, and that's, since I was kind of waiting for all the evidence to play out, now it has, I suppose, to see if there's anything else that I've missed, but I don't see how we can attribute the complicity backwards, just like the intervening cause, but I don't know. What do you think?
We had the same concern, and we were trying to tool with how to, for some reason, the internet's not working on the laptop, so I have to go off the phone. So complicity, I don't know if we were able to say, because there's going to be a few of these, but basically with respect to each of them, for manslaughter, Mr. Cichuniec or Mr. Cooper may be either a principal or a compliciter with each other. And then just making it tightened to just those, and that way complicity is not a separate crime, rather is a theory by which one. And then again, for Mr. Cooper or Mr. Cichuniec to be found guilty as a complicitor, they must prove, but then I think instead of saying another person, they'd have to say each time. I think we just need to be very clear with each other. They don't have to tell us whether they think Mr. Cooper's principal and Mr. Cichuniec's principal, but that the complicity is between the two of them.
Well, and I was trying to come up with a reasonable alternative, at least for me, and I'm a little slow in the uptake sometimes. If I were reading instructions and I were to get a separate instructions, that the complicity instructions only relate to the interrelated actions of the defendants, Mr. Cichuniec and Mr. Cooper, something like that.
Certainly, and then maybe we just add to each of the complicity instructions, see instruction number blah. I mean, how they do it back, that's a bit redundant, but normally you can just put one right before the next.
Well, you're going to get 100 minutes in your close, so you can certainly bring that up. This one applies. You can stick it up on the board and say this one applies to all the complicity instructions. I think, and I don't think anybody's going to object, and I'm not going to say anything. So I think that's good enough.
Yes, Your Honor, we just want to make the record clear that we're that we do still intend to argue that the defendants acted in concert with law enforcement, but we agree that the complicity instruction at this point, particularly when they did not enter the scene, arguably at the request of law enforcement. So I think that argument is still proper, but we agree to a modified instruction on this. But certainly the parties are still free to argue the evidence as it was presented.
That's fine. I just wanted to make sure that the jury was clear with respect to complicity, who we were talking about, because conceivably we could throw in the Falk people, the other paramedics or the EMTs rather that were on scene. And it would, I think, become terribly confusing if that were what the theory was. But I'm not going to foreclose your arguments, but I think it's just important. And you asked for some time to try to put something together. I'm going to give it to you. So.
Yes, Your Honor. And is the court's preference to do it individually in each of the complicity instructions?
No, I was just discussing with Ms. Began, my preference would be an instruction that says this applies to all of the complicity instructions with some explanation that's between the two defendants. I
Yes.
haven't come up with the,
And maybe with a cross-reference to the instruction numbers, since it may not be abundantly clear to the jury what the complicity.
well, as I was explaining to Ms. Began, I think, as I said, I was explaining that they have 100 minutes for their closing arguments. So I would certainly post that one up on there and say, this applies to all of these.
Yes, Your Honor.
That would take like a minute and a half, I think, to do that. Because I think if we, where I run into problems is referencing instructions and we end up with one number wrong. And it's,
I understand, Your Honor. That makes sense.
and by the way, if I'm on pages 17 and 18. So again, I'll ask if there's some way you could format it into one page.
Yes, Your Honor. And I think especially once we remove the citations, that shouldn't be too much of a problem. If we just address the paragraph spacing a little bit, I think that'll make it work.
However you make it work, I couldn't.
And again, our only other potential to revisit is depending on affirmative defenses in the court's ruling would be. Right, or did it?
Okay, yeah, I suppose it conceivably could be plural.
And Your Honor, just for the record, for page 17, this is the recklessness. So of
Oh,
course,
okay, yeah.
people would object to the affirmative defense.
Yeah, so I've already ruled on that, but there's some ones coming up in the future, I suppose.
And our objection is just noted then.
And join that, Your Honor, as well as just to complete the record on behalf of Mr. Cichuniec. I'm just going to go and say, based on all of this discussion, it seems to me to object to it. And so I'll close the record on that.
All right. The court's heard the evidence in this trial, and again, it's within the province of the jury to figure out what they believe and don't believe, and what is, I suppose, determine what is said and what is done on the body-worn cameras. But the court would find there is sufficient evidence that a reasonable juror could make a finding beyond a reasonable doubt based on something other than conjecture or speculation that there was complicity in this case.
And for pages 20 and 21, we'll also try to get that onto one page, Your Honor.
Yeah, just as best as you can, because again, when reading through sometimes you just can't get the whole instruction on one page. In that case, what I typically do is if I'm on instruction number 24, I have instruction number 24. In the next page, I would have 24A or something like that. I have occasionally gone into the jury room after a trial, and sometimes the jurors choose to take the staples out of their instructions. So,
Yes, Your Honor. That makes sense.
And as to 20 and 21, we'll stand on our Pickering objection. I'll just label it that way.
all right. And for 23 and 24, I'm assuming same objection.
Well, but that's the assault, so that has the affirmative defense.
Yes,
It is the only issue.
yes. Now we're on 26 and 27, which are the
Second version of assault, so, is that right?
again, it potentially could be pluralized for element number 5.
So I'm looking, are you on page 25, Judge? Okay, I got confused. It looked like it was SBI twice, but maybe that was just, oh, that was just the follow-up. So we're on page 26, correct?
Yes.
Yeah, that was the only thing I noticed.
And Your Honor, on page 26 and 27, we'll also remove the or substance from the description of the charge.
Okay, I think that's appropriate to maintain some consistency.
And we'll do a search through all of the instructions to just make sure that we've removed it from the parentheticals, but not from the elementals.
All right, and the court understands, and I think the record's been made that the defense is objecting to the complicity instructions in total, but the court's made its findings on that. The next one I have is 29, which is the sentence modifier, I guess, for the special interrogatory. The court it was complicated, and I'm not sure I fully understand it, but I did review the BD case. Interestingly, I guess it was my view, because the case, I think the case law has always kind of followed that a complicitor could be found guilty of the sentence enhancer. I don't make these decisions. I'm glad somebody else does. But as I read the complicity statute, it applies to offenses, but the people down at the car building don't agree with me. Kind of stuck with it.
And Judge, we'll stand on the fact that we objected to complicity in general. We incorporate our arguments asking the court to strike this sentence enhancer altogether. Understanding both of those, I think it would be appropriate to add a third or a second question. Did the defendant and or principal break it apart, cause serious bodily injury, question mark, yes or no? Did the defendant and or principal cause death, question mark, yes or no? I think that protects and further will supplement the as applied equal protection argument that has been set forth. I understand that this is the way the statute reads, but again, we're in a very unusual and complicated situation where SBI envisions that you can potentially cause death, but here we have an allegation that somebody caused death. So it's just to protect that argument. That's all.
All right, if I understand, I'm trying to interpret, it's a unanimity sort of issue
Yes.
that I suppose if I bought off on it, it could be explained in the interrogatory for the people.
Would Mr. Cichuniec?
Oh. Okay.
Your Honor, under the statute, as well as the pattern instructions, this is a disjunctive, so the jury doesn't have to decide. It's did they cause serious bodily injury or death? As the court's well aware, they don't have to agree on the brute facts. Here it's either or, and the jury doesn't have to tell us which one they agree on. We object to a separate interrogatory that is non-pattern and inconsistent with the statute. And this court's already heard ample evidence on the equal protection issue, and we would rest on that record.
All right. Well, the court's gonna, the court understands the logic, I suppose, of the defense's argument, but I'm gonna keep it as we have it for the time being. The next four, I think, pages 30 through 34 are fairly,
Your Honor, we'd added in page 32, I apologize, page 31, news coverage of this case or any related information, in part based on the other cases, since this is the third trial. We're interested in the defense's position. We are not set on that or particular language, but because this case and certainly the co-defendant's cases may be at issue, we don't want the jury basing their decision on news coverage of that either.
And Your Honor, we certainly don't want the jury basing their decision on the related cases or on the news that broke over the weekend surrounding Mr. Perry and all the news related to that and his death. So I do think there needs to be something from the court regarding or any related information, just more strongly as opposed to just this case.
okay, that makes sense. So as I understand things at the moment, we're going to have 6 verdict forms and 2 special verdict forms.
Correct.
Your Honor, the special interrogatories may actually end up on the verdict form. I think it depends on how that verdict form looks, so I don't know that that would be a separate sheet or if that would be on the verdict form.
I think unless they've changed it, the Colgy it's a separate page, isn't it?
Right now,
I've seen it smashed into the instruction, but I think I've communicated my preferences on multi-page things.
in Colgy, it is on the same page. For
Is
this
it?
one. Yes, Your Honor.
Is it for this one? Okay, if you could fit it on there and it makes sense, I think there's some, there's some language in there that separates the guilty, not guilty part of the offense. It looks like somebody's pulled it up. And then there's an explanation. If you have found the defendant not guilty, then skip this part. If you have found the defendant guilty, then you need to answer the following question.
Yes, Your Honor. In our current draft, we have it on one page. The only thing we'd ask is to just be clear that the defense is not asking for any lesser included or lesser not included before we can complete any verdict forms. So that may also impact the number of verdict forms at issue.
Okay. Suppose it's a good time to address that.
We aren't.
Okay.
That should make it clear, and we'll update that instruction based on what the total number of pages actually looks like.
Okay. Let's move to the affirmative defenses. Let's start with execution of public duty. On behalf of the defense.
Is there an objection to this that we need to respond to, or?
Well, I guess I should ask them first.
Yes, Your Honor. We also filed this at the beginning of trial in what I believe is P-195, execution of public duty. We object to this defense being given. If the court would like us to argue the issue first, we're happy to do so. If the defense would like to argue, it is their burden to present an affirmative defense, so we would prefer to do responsive arguments, and we believe that's the appropriate burden of proof.
That's fine.
Getting it in front of me, Judge. I get there? So Judge, public duty in this case, I think it's pretty clear that these two individuals, Mr. Cooper was working at all times in his capacity as a public servant, as a paramedic for the Aurora Fire Department. In that capacity, he is a public servant, and he was there in his official capacity and was providing treatment in his official capacity. The case law is clear. We have to raise a scintilla of evidence regarding that to justify an affirmative defense, and it is our position that we have raised way more than a scintilla of evidence regarding that. I don't believe there's been anybody contesting he wasn't there in his official capacity, that he wasn't working as a licensed paramedic for the city and county of Aurora, and he didn't show up on the fire truck in that capacity. The argument is whether or not the people's theory is that he should not have administered ketamine. And that is a jury question, but that is not, that does not take it out of the fact that we are articulating and arguing he was acting in that capacity.
On behalf of Mr. Cichuniec,
Join under that, Mr. Cichuniec.
on behalf of the people,
Yes, Your Honor, under 18-17012, this is an insufficient demonstration of execution of a public duty. That statute does not apply to uses of force. So it simply doesn't apply to the charged offenses in this case. The statutory language reads, unless inconsistent with the force provisions in 18-1702 through 18-1707. The specific instructions control the general. This is a general defense. I would also note, much like omission, the defense has not identified a statutory basis or binding judicial order in Colorado that provides the basis that their conduct is legally authorized. An execution of a public duty does not create a blanket governmental immunity for anyone who acts in their official capacity. That's simply not what this statute does. If we look at some of the referencing cases, including Neckel, 2019 COA 69, which is also 487 P3rd 1036. That's the process serving case, that when you are serving process pursuant to a court order, violating a no trespassing sign does not create criminal trespass, because you are actually acting pursuant to a lawful court order. And in that case, you are certainly executing a public duty. The same would be true if someone tows a vehicle off of I-25 at CDOT's direction because it's blocking traffic in violation of state law. They haven't committed motor vehicle theft. Or if along those same lines, we have that someone who seizes property pursuant to a valid warrant has not committed the crime of theft. These are not force offenses for any of those examples. And this statute does not apply to uses of force, nor have the defendants identified a particular statute or lawful court order that immunizes their conduct. And I think if we look at the instruction itself, it's clear that this does not apply, particularly to the uses of force here. And we also briefed this in P195.
I've read it.
Judge, just in response, and I'll be candid, I have not read P195. I put on the record before, and I'll put on the record again, we are a two-person unit, Mr. Fellow and I have been focused on being in a very, very long trial, and witnesses coming in and leaving. I am here, the court's probably aware, I'm here the second the door opens in the morning, and I get home at about 9 o'clock, 10 o'clock at night. I have not. That being said,
I could tell you that my read of it was the people's argument in a nutshell.
and Judge, our position is the paramedics in the state of Colorado, as we heard from Dr. Hill, operate under his license. They are licensed by the state. The state certifies them as paramedics. The state gives them a license to act under a medical director who has to be a physician, who sets forth the protocols and the orders upon which they can operate under. And as paramedics, it's the protocols and the orders by which they can disseminate medication. Paramedics cannot prescribe. They cannot write a script. Their orders come by virtue through the CDPHE and through the licensing department of the state and through the medical director. So he is acting under the orders of the state, giving them authority to work in confined areas and administer medication in confined areas. To suggest that somebody is not protected when they're operating in that capacity, it removes all protections for paramedics ever administering medication. To call it force simply because they are administering medication that has to be administered through an intramuscular injection buttresses the whole argument of a paramedic being able to do their job. If we're now going to put paramedics in the position that to administer a medication with the use of a syringe means they're using force, and that they're operating without the protection of the law, because even though they're within their license and they're under their medical director's purview and their medical director's authorization, they are completely not on notice that that conduct would violate the law. This is certainly applicable in this case. It is our position, not only is it applicable, it is controlling in this case.
All right. The court would find that execution of public duty, there's not a great deal of case law in Colorado. It differs a little from the model penal code and the provisions of some other states. But on the first prong, it's not whether you did your duty right or wrong. It's whether or not there's a provision of law or a judicial decree that directs you to do this specific act. And the court find is a linchpin matter that I've been provided with no provision of law that would require the administration of ketamine by a paramedic or a judicial decree directing them to do so. So the court would find that, and also there is the case law, it's a little bit dated, but where there was a conviction for the unlawful administration of a controlled substance, where the trial court found that that amounted to force or violence, and that was upheld by our Court of Appeals. So the court will decline to give the instruction on execution of public duty. Okay, now let's talk about H10, I guess.
Yes, Your Honor, it may be helpful to start with the people's objection so that defense knows
Yes.
to respond. So we have two objections to this instruction. Well, pardon me, three objections to this instruction. One is that it's not an affirmative defense to reckless manslaughter or criminally negligent homicide. I know that the court may be considering a traverse instruction, but our position is, of course, that that would look different than this one. Second, in numbered paragraph 1, he was a duly licensed paramedic. We agree that Mr. Cooper and Mr. Cichuniec were duly licensed paramedics, but the statutory provision is actually one acting under the direction of a licensed physician, and we believe the statutory language is more appropriate here. And then finally, under sub 3, we object to the treatment was administered in an emergency when the paramedic reasonably believed that no one competent to consent. That does not track the statutory language. But because this is the defense requested instruction, we would defer the floor to them. But we did want, for the record, to know that we don't have an objection to giving this instruction generally, but we do have an instruction to giving this specific. We do have an objection to giving this specific instruction in its current form.
All right, from the defense.
Should we adopt and stand on our prior arguments? We believe Pickering does not control or apply, but we understand the court's ruling, so that's just for the record. With respect to, and we would be requesting then a traverse instruction as it relates to the charges that the court is not allowing this affirmative defense to apply to, because it's our position it applies to all of them. Now, under prong 1, he is a duly licensed paramedic. The statute gets much more convoluted and wordy, but it's a duly licensed paramedic acting under the direction of a duly licensed physician. That's what's applicable in this case. It's not a nurse, it's not a physician's assistant, it's not somebody else. That is what's at issue. And same with under prong 3, in an emergency when the paramedic, again, he is the paramedic. So adding in all this extra verbiage versus just calling them by the title that the jury has heard them the entire case referred to as, versus injecting another, I shouldn't use that word, inserting another issue into the case that's unnecessary when it encompasses the spirit and the intent of the legislature is the defense position. This is the cleanest and most straightforward way to instruct a jury.
All right, so I'm clear. Is the, I'll start with, or go next to counsel for Mr. Cichuniec.
I would do this.
All right, and what's the offending language according to the people?
Yes, Your Honor. So numbered paragraph 1, he was a duly licensed paramedic. That's not what the statute provides, so we don't have a strong objection to this, so long as it does retain acting under the direction of a duly licensed physician. Paragraph 3, we do, however, have a very strong objection to the use of the word paramedic there because they are effectively creating a statute that does not exist. So under 18-1703, 1E, the provision in the statute reads, the treatment is administered in an emergency when the physician or advanced practice nurse reasonably believes that no one competent to consent can be consulted and that a reasonable person wishing to safeguard the welfare of the patient would consent. And if we contrast this with sub E, where it says a duly licensed physician, advanced practice nurse, or person acting under his or her direction, the legislature did not include person acting under his or her direction in the emergency treatment portion. And Colorado's statute is different than many states on this point. So if we take a look at the Alaska statute and the Arizona statute, for the Alaska statute, it's Alaska statute section 11.81.430 sub 5. And for the Arizona statute, it's section 13-403 sub 5. In both of these statutes, they say, in an emergency, if the person administering the treatment reasonably believes that no one competent can be consulted. Colorado's statute could have included this, but it did not. When the legislature makes a specific decision in defining affirmative defenses, then it is the legislature's sole prerogative to define the scope of that affirmative defense. We cannot deviate and omit words from the statute or inject words that the legislature has not injected into the statute itself. We would invade the legislature's province and create an affirmative defense the legislature has not seen fit to adopt for Colorado. Adding the word paramedic here is inconsistent with Colgi, it's inconsistent with the statute, and it violates the very basic principle of who defines affirmative defenses. So we have a strong objection to the word paramedic. Under both Colgi and under the statute, it should read, if the treatment is administered in an emergency, when the physician or advanced practice nurse reasonably believes that no one competent to consent can be consulted. So in this case, certainly the defendants are free to argue that under Dr. Hill's consent protocol, they have that authority, but we cannot change it to the person administering reasonable belief. That would be creating a different statute than Colorado has adopted.
Judge, if I may respond when the court's ready.
Okay.
To read it the way the Attorney General is suggesting makes the entire first portion of subsection E irrelevant. You read the statute in total and you carry it over. So a duly licensed physician, and if they want to change it to have this language, a duly licensed physician, comma, or a person acting under his or her direction, comma, may use reasonable and appropriate physical force for the purpose of administering a recognized form of treatment that he reasonably believes to be adapted to promoting the physical or mental health of the patient. If, subsection 2, the treatment is administered in an emergency when the physician or advanced practice registered nurse, you refer that back to paragraph E where they said, comma, or a person acting under his or her direction, then reasonably believes that no one competent to consent can be consulted, and that a reasonable person wishing to safeguard the welfare of the patient would consent. Judge Dr. Hill was very, very clear that the training and the eons of protocols and education and licensing in Colorado, paramedics work under his license. They do implied consent under his license. That in pre-hospital care, this is all completely under his license. They are at his discretion. At his direction. If you try to now take out and say that, oh, well, the first part applies, but the second part doesn't, you make that first clause completely irrelevant. And it also leaves, again, paramedics who have been trained, educated, and taught that this is the way that they are to act, and it's protected. Again, now you're in a mistake of law and you're in a mistake of fact situation where you heard from the medical director himself that this is how they're trained and what the law is as they understood it and has been taught to them. And most importantly is what their direction is, that they are a person acting under his or her direction, and that they can proceed under implied consent, that no one competent to consent can be consulted, and that a reasonable person wishing to safeguard their welfare would consent. If you take that out, there was no purpose for the legislature of having in the clause or a person acting under his or her direction.
And Your Honor, we disagree. The legislature certainly has the ability, and it has specifically included the clause or person acting under their direction above. It did not adopt that into sub 2. And in this case, the defendant's ability to authorize under implied consent is through Dr. Hill's authorization. So certainly they can argue that under Dr. Hill's consent waiver, they were operating under implied consent, but it's not a subjective belief of the paramedic in the field. Otherwise, Dr. Hill's protocol on implied consent would be irrelevant. We're not saying the protocols don't apply. Instead, we're absolutely saying the protocols do apply, but that is under Dr. Hill's authorization for the implied consent. The paramedic's subjective belief is not included in the statute. Had the legislature intended to do so, they would have said under the reasonable belief of the person administering the medication. They did not do so, and we consider that to be a strategic choice. We cannot read words into the statute, and more importantly, we cannot read words out. Here, the statute says physician or advanced practice nurse. It does not include person acting under their direction. It's also not consistent with Colgi to add that modification, and the Colgi tracks the statutory language much closer than this instruction does.
Judge, I would again cite back to the fact that if we do what the people are suggesting, there is no relevance at all for the legislature to have said, or a person acting under his or her direction. It's all one encompassed clause. There's a colon, there's a sub 1 and a sub 2.
Let me look at it.
Certainly it doesn't apply to sub 1, so we're under sub 2.
And Your Honor, it's the person acting under direction that is doing the act, but it is ultimately up to the physician to determine implied consent. Actual consent under sub 1 would be a different situation, but the defense has not requested that actual consent be included, and we agree with that.
All right. The discussion has been with respect to the use of physical force in special relationships. The court agrees that we don't need, we can just use paramedic in paragraph 1. Really, the argument, if you will, is the language in the third paragraph. That it's in 181703E Roman 2. But section E is the duly licensed physician, advanced practice registered nurse, which I don't think we really need to have that in there because there's no evidence of an advanced practice nurse. They use reasonable and appropriate force for the purposes of administering a recognized form of treatment that he reasonably believes to be adapted to promoting the physical or mental health of the patient. If, and the paragraph that is relevant here is 2, Roman 2, the treatment is administered in an emergency when a physician or advanced practice registered nurse, which we're going to take out, reasonably believes that nobody is competent to consent or can be consulted, and a reasonable person wishing to safeguard the welfare of the patient would consent. I would agree with the people that statutory language links the reasonably believes to the physician. But reading E and E Roman 2 in paramateria, the court would find that the language of a physician or one acting under the direction of a physician would be appropriate under this set of facts.
Your Honor, could we then modify sub 3 to be the treatment was administered in an emergency when the paramedic acting under the direction of a duly licensed physician, so that that
Yes.
works there? And Your Honor, in the below part, our objection to the references to reckless manslaughter and criminally negligent homicide in the paragraph beginning with after are the same. So we'd argue that those go to traverses and not to the affirmative defense.
And the court agrees with that.
And we would just incorporate our prior record.
Well, I say that with less confidence than I would 2 months ago when the Supreme Court took cert on Make My Day, one of my cases, but I said, I'll let them figure that out. Okay, what we left with, I think, stake of fact and implied consent. And quite frankly, I think the special relationship instruction that the courts approved really covers this.
I think it does too, Your Honor. We weren't sure, mistake of fact. I think it's also appropriate to argue if in the prohibited conduct under mistaken belief, to wit, that the patient had excited delirium and due to the mistaken belief did not form the particular mental state to intend to harm anybody, did not intend to administer medication for any reason other than a medical lawful treatment, and certainly did not, well, the court, for traverse purposes, based on the court's prior rulings, that there was no gross deviation from standard of care and no reckless mental state. So the mistaken belief we would be focused on is the presence of excited delirium.
Okay, on behalf of Mr. Cichuniec or the people?
Your Honor, we believe this is encompassed under the special relationship and by proving the elementals themselves. Additionally, under People v. Walden, 224, P3rd, 369, Colorado Court of Appeals, 2009, mistake of fact instruction need not be given if the proof of the mens rea necessarily requires proof that the defendant was not operating under a mistaken belief of fact. They're essentially adding an element that the people would have to disprove that does not exist, and we object to providing this as an instruction. We believe it's covered in the other affirmative defenses and in the elementals themselves.
And the court agrees. And I don't know if this was a segue, but the court also received on behalf of the defendants an implied consent based upon emergency. And again, I think it's encapsulated in the affirmative defense instruction that the court's authorized.
I think that's, I'm just making sure there was nothing additional in that one. I think it is encompassed as well, Your Honor. The only addition I see is a reasonable paramedic in Aurora, Colorado. So I think tightening it up to their duly licensed physician, I think is fine. So I think it is encompassed.
Okay.
Agreed on that, Mr. Chairman.
Very well. So I guess what that means is we don't need a plural, because the defense that will be, or the affirmative defense and the traverse defense, if you will be applicable based upon the culpable mental states stated in the offenses. How quickly do you think we can get these put together?
We think half an hour. Maybe it might be a little faster.
Okay.
Your Honor, we need to revisit the definitions instruction.
Oh yeah, we do. It's number 10, right?
That's correct.
And Your Honor, have you made a decision as to that we are giving a traverse instruction, or that we'll address that once we've provided a draft of what that traverse would look like?
Well, I think that there's kind of a Colgi version of the traverse, is there not?
What I was just trying to find.
For self-defense, there isn't one for special relationships, but we can work off of the self-defense traverse.
Okay. All right. Well, what are we left with? Are we still in disagreement about the definition of consent?
I think now it would become even more confusing. I would just ask we remove it, Judge. I think that, again, that's encompassed in the affirmative defense, and I think it also has a common understanding. I don't think we need to explain it. If they have a question, they can send out a question.
I agree.
And so do the people, Your Honor. We think we should remove it here.
Okay, and we talked about drug.
It is in the elemental, Your Honor, which is why the people included it here.
That's fine.
I think there could be some questions, but if the defense would like to modify this, we're certainly open to modifications.
I think it's the definition that's it's fine to keep it, Judge.
Okay, as I mentioned, some of the language in there, I think might be important for the defense as well as the prosecution. What about the lawful medical or therapeutic treatment?
Ask that that be removed, Your Honor. And again, if they have a question, we can deal with it at that time. If the court feels it has to give something, I do object to what's here. I would say is a recognized form of treatment for a medical purpose. I mean, but I don't think we need to give it. I think, especially under the facts and circumstances, this case, it's kind of part of what they're deciding. So.
Right.
The determiners in there, like bona fide and this reasonable medical practices is right for the jury.
For the people?
Your Honor, I think in light of the court's ruling on the affirmative defense, it's probably embodied there. So I think we can withdraw this, but again, address it if the jury does have any questions.
All right. All right. So we'll take out the lawful medical or therapeutic treatment. And just so I'm clear, I, quite frankly, over the course of the trial, didn't really get a real good chance to go through. But did this really come from the, I have Colgi 34:25 that talks about it's really unlawful sexual contact.
Yes, Your Honor. We looked through the entire, both Colgi as well as the Title 18, and that was the only place that we found it referenced. We wanted to propose it in case the court believed it was appropriate, but we don't have an objection to withdrawing it at this point. It's just, it really is a pretty narrow set of circumstances. It looks like both unlawful administration, and then that provision of sexual assault appear to be the only areas in the criminal code that address it. So while I don't think it's an improper instruction, I do think that the affirmative defense probably covers it. And in light of the court's ruling, we agree to withdraw it here.
All right. Yeah, I suppose if the jury has a question under Leonardo, if appropriate, we'll try to put something together.
Are we at administer, bodily injury, drug, and serious bodily injury? Is that right?
And conduct without omission.
Oh, conduct means an act or series of acts and its accompanying state of mind, or where relevant, a series of acts.
Yeah, I don't think we need to put the series of acts in there twice since it's there at the end, but I never think, well, I rarely think redundancy is bad.
And I apologize, Ms. Fagan, I didn't hear, did you also say serious bodily injury at the end?
Serious bodily injury, yep.
We agree.
Okay, let's get together in about 20 minutes or 25 minutes, and hopefully we can.
Your Honor, I have one other question about a possible instruction. I know just given the length of trial and the number of times we've used transcripts, I didn't know if the court would like to consider a prospective instruction that transcripts will not be available to the jury. And I'm curious to the defense position if we wanted to give that instruction to avoid a question.
I would object to that actually, because I think it might invite them to this.
Well, I guess what under one of my position always wonders how much the jurors absorb when I'm speaking to them. But in the court's introductory advisement to the jurors, I tell them about their ability to take notes if they want to. And I specifically say that I often have jurors ask for the transcript of witness A, B, or C. And the bottom line is, you're not going to get them.
You did that in this case.
Yeah, I mean, that's just kind of my normal spiel, if you will. So my hope is one or two of them might remember that. But if they have a question, I'll send them the same explanation.
Thank you, Your Honor.
Judge, I was going to let the court know this isn't related to instructions, but we had two things we wanted to talk to the court about whenever the court thinks it's appropriate. One was a discussion about the alternates, and the second was a discussion about when the exhibits go back, body-worn cameras and defendants. I think those have to be treated in order.
What?
Body-worn cameras in the defendant's interviews. So when all the exhibits go back, I think under the case law, those get treated differently. So just.
I don't think so. I think under Real are pretty much the same. They're the events of the allegations that are related to the allegations and the statements of the defendants. They're normally go back with unfettered.
Are you saying where things develop and Fresco were overruled?
To the extent, well, there's Real, and then the one other case that talks about the defendant's statements. I don't have that on the tip of my tongue. It says that those fall into different categories.
Okay, I'll take a look. Then maybe we won't have to have that discussion.
And the people agree with the court, Your Honor. Under Royale, no, there is no requirement for limitations, and unfettered access is appropriate. The one thing we did want to address is if the court wants to give the physical evidence directly to the jury, or if the court would like a request on that.
I was planning on, hopefully we have it all bagged up nicely. And yeah, I was going to bring it back to them, maybe put it in the corner or something. And if they want to get rid of it, we can take it back out and put it in the closet. And we will bring back, if they're not already there, some gloves and sanitizer.
Yes, Your Honor, and we intend to provide the people's exhibits on a clean laptop. I don't know, we can talk to the defense about possibly providing it all on one laptop. For the record, our IT was unwilling to do it completely without a password because of security. The password is jury in all caps, which we hope the jury will be able to remember. But we can talk to the defense about making a plan so that it'll be easy for them to view all of the BWC. And I believe that the hot seat vendors have exchanged exhibits. So we do have the exhibits and we can talk about.
You have all the defense exhibits?
I believe so. And I think we should confer to make sure, but we will double check that. It may take us a moment, but hopefully we could do it over the break between instructions and the exhibits to get everything here.
Okay.
Judge, we would have no objection to the laptop, a clean laptop with a password like that, going back as long as it has everything, since it appears to be coming from the court. I wouldn't want them to go back, here's the people's and here's the defense. I think that would be, I wouldn't like that. But as long as they're all together, I don't, that's.
Yeah, the only thing that I might suggest is, I don't know if anybody has this, like there's a bunch of, I forget it was 275 through 290 or something like that. One of those was actually admitted. I'm assuming those aren't in there because they were conditionally admitted. And there are a bunch of like photos of injuries and such to, and Mr. McClain being treated at the hospital.
They were actually not admitted.
Right, they weren't, yeah. I want to make sure those things are not in there. The other thing is, I think it's really helpful to the jury, and this is based, maybe you have this already. Is it like catalog, kind of at least a brief description of what these things are?
Yes, Your Honor, we're also working on a paper index that also includes thumbnails similar to what the defense received at the beginning and what the court received, but with only the admitted exhibits listed on that index. So there will be certainly gaps of exhibits that were numbered but not admitted. So we'll have that ready. And I don't know if the defense was planning to present a separate index, but our index does not include their exhibits.
What do we have, like 5 or 6 or something like that from the defense? Yeah, if we could get those all in one document, that would be great. And they're not gonna have to be flipping through a bunch of paperwork. Okay, the court will be in recess for a bit.
I noticed that. Nice to meet you.
And once I get through reading these instructions, I'll come back in. Shouldn't take me too long.
Mr. Cooper to step out while he. Stick around.
That's totally up to him. You've heard a bunch of what we've been talking about. It's kind of esoteric stuff, but this is your trial, so you certainly have the right to be present during all of it. And if you choose to skip this part of it, that's totally up to you. What do you think?
I think I'll confer with you.
Okay, well, I need to let you know is nobody can force you or put pressure on you to be here or not be here, but you certainly have the right to be here. But I need to be assured that whatever decision you make will be your decision and be a voluntary decision. You willing to do that? Assure me of that? Okay, well, I'm going to step out for a few and just get through reading through these, and we'll let the jurors know what the plan is.
Okay.
your decision and a voluntary and knowing decision, folks?
Yes, Your Honor.
Okay, very well.
Your Honor, there's one thing we'd ask the defense to put on the record while the defendants are still present,
Okay.
and that is that they are not seeking a theory of defense instruction.
Yeah, thanks.
Correct.
Okay,
Thank you.
thank you. All right, I've had a chance to go through the instructions. I've just numbered the actual instructions. I haven't put in the reference numbers quite yet. I will get to that, but I have instruction number 1, and I'm assuming counsel is incorporating their prior record during the jury instruction conference earlier this morning. Is it still morning? Yes, it is still morning. So first one I have is just the introductory instruction. Any problem with that?
Mr. Cooper.
Mr. Cichuniec.
2 is the charges are not evidence, and it kind of is a mesh between the defense proposed and the people's proposed with the dates put in for the appropriate offenses. Is that one okay? Okay, we have the presumption of innocence and burden of proof. The court notes that the defense objected to this, which I guess we'll refer to as the new instruction. But other than that, any further objections? Here we have the credibility instruction. That's a mesh of the expert and lay witness as well as the number of witnesses. Number 4 is how I have it numbered. Any objection to that? Direct and circumstantial I have as number 5. Any objection? 6 is judicial notice of the time, I guess. All right. 7 is the combination of separate offenses as well as separate defenses. Any objection?
On page 8.
I'm on page 7 right now.
7 for me is. So does it start in this case, separate offenses are charged?
Yes.
Objection.
Objection.
Yeah, I think I got a new version or something. All right, now I have instruction number 8, page 8, that defines voluntary act, culpable state of mind, that has the statutory definitions of intentionally or with intent, reckless, and criminal negligence, noting the previous objection to the definition of criminal negligence. Any further objections?
Prior objection.
Same, Your Honor.
Okay, number 9, we have defined, at least as we discussed in the instruction conference, the terms administer, bodily injury, conduct, drug, and serious bodily injury. Any objections to those?
The recognition. That's the conduct we follow.
All right. And that was modified to an extent. 10, we have the reckless manslaughter instruction. The court notes that the defense argued that we should have an affirmative defense in there with special relationship use of force instruction that the court denied. But other than that, any objections to page 10, instruction 10?
Incorporating the prior objections, Judge, what I would say is if, depending on how the court deals with the traverse, court accepts the defense traverse instruction that's been prepared, I would just ask that it come right after, either right after the reckless or after.
Okay, so you're asking me to renumber them, essentially. No, that's, I use a pencil for a specific reason. All right, so I think we can probably deal with 10 and 11 together, which are the elemental instructions for manslaughter and the bridge to the criminally negligent homicide, with the difference being that the defense is requesting the traverse to be after those first 2. Any objections from the defense?
Prior objection.
Same, Your Honor.
All right, and the prosecution's thoughts about, there was a judge when I first started practicing that would always comment to us, the lawyers, that he had never been reversed based upon the order of the instructions, but anything that the people would like to add with respect to that request?
No, Your Honor, we don't have an objection to the placement of the traverse. We do have an objection to the traverse, and we'll address that when we get to it.
Okay. So. Okay, I've got 13 with the affirmative defense and instruction, whatever. Instruction 14, it's the somewhat modified cause and, well, cause instruction, I guess. Other than the prior record, any objection to 14, page 14?
I'm on a different, the one that I had as final has, it had the second degree. So
Yeah, I have, page 12, instruction 12 is the elemental for intent to cause bodily injury, causing serious bodily injury with paragraph number 6 referring to the affirmative defense. 13 would be the elemental instruction for second degree assault, unlawful administration of drugs, again with paragraph number 8 with the direction to the affirmative defense instruction.
So as to the two second degree assaults incorporating the prior record,
Same, Your Honor.
The people also note our prior objection to this cause instruction.
Okay.
we're on the cosmic. Okay. As to cause, Judge, I would note the prior. The only thing I would ask is just to reiterate again, is just that we say from their point of conduct forward. But I understand made that reference. I'll stand on the record and no.
All right, I noted that reference was specifically made with respect to the complicity. Once we get into those. All right. And then now we're there. I have page 15, instruction number 15. And again, I'll rearrange the order a little bit if need be, but it reads as follows. You may find that Mr. Cichuniec and Mr. Cooper committed the charged offenses as a principal or as a complicit or as both. Mr. Cichuniec and Mr. Cooper are alleged to be complicit with each other's actions, not the actions of law enforcement before Mr. Cichuniec and Mr. Cooper arrived on scene. Following complicit or liability instructions should be considered in this light.
If we would object to this, create the act, not the act, law enforcement. And Mr. Cooper are alleged to be complicit with actions, not law enforcement. Period, or not the actions of law enforcement. Period. The following complicit or liability instructions should be considered in this light. As we talked about, they are not complicit or accused of being involved. Other Aurora Fire with law enforcement, they're accused of being complicit with each other.
And Your Honor, we did try to follow the court's order on this one. We would also note our objection for the record that we believe that the more appropriate instruction would be to have the second sentence read, Mr. Cichuniec and Mr. Cooper are not alleged to be complicit in the actions of law enforcement before Mr. Cichuniec and Mr. Cooper arrived on scene. We did propose this instruction based on the court's order, but we do believe that that instruction would be more accurate to the circumstances of this case. And they are alleged after their arrival on scene to be complicit with the police officers, particularly with the restraint prone position, semi-prone position, which we made in the earlier record. And we would object to the defense modifications as well.
All right, if I wasn't clear in my order, the court finds that based upon the specific facts in this case, that the court will grant the defense. I'm going to strike before Mr. Cichuniec and Mr. Cooper arrived on scene with a period after enforcement. Okay, order 16, which is the principal complicity instruction for, what is it, manslaughter.
Sorry, sir. I might not have followed what you said on 15. What will that second sentence read in instruction 15?
I'll read the entire instruction. You may find that Mr. Cichuniec and Mr. Cooper committed the charged offenses as a principal or as a complicit or as both. Mr. Cichuniec and Mr. Cooper are alleged to be complicit in each other's actions, not the actions of law enforcement, period. The following complicit or liability instructions should be considered in this light.
when judge no objection incorporating the provisions.
Okay, so 16 and 17 are pretty much linked. I just need to put the right numbers in once we get the instructions numbered. Once I do that, I'll provide copies to the parties. Okay, 18 is the crim neg, and 19 is the, connects to that, I suppose, with respect to principal and complicit or liability.
Again, adopting the prior objection. Additional record.
We're to number 20, that is assault in the second degree, intent to cause bodily injury causes serious bodily injury. Again, this has paragraph 5 in the first set of paragraphs. It would refer the jurors to the affirmative defense. The court has approved. And it does. I numbered these with my pencil, of course, as 20 and 20A. But I'm probably going to end up changing them once I.
Yes, Your Honor, we put a continued in the parenthetical at the instruction number, just so that the jury would be very clear that it's not separate if they do, as the court noticed, remove the staple.
Yeah, I appreciate that. And I just added the 20A because, as I said, I find that sometimes they take the staples out and there's more than one continued. So I just wanted to keep them on track. So and 21, of course, attaches to that. 22 is the unlawful administration of drugs, second degree assault version. Again, with paragraph 5 referring to the affirmative defense. Again, taking into account the prior objections to the complicity instruction, this goes on as a continued also. I numbered them, and again, I'll change them as 22 and 22A for pages. Okay, and 23 is attached to that. Again, I need to put the right numbers in there. Oh, the next is the instruction as to the special verdict form, noting the numerous objections to the special verdict itself. It appears to track the Colgy instruction. Anything else? Okay, and here in 25, we have the version that the court approved of the affirmative defense. Oh, no, this is the
People's proposed traverse.
traverse. Okay.
Would object to this, I think, some, especially you are further instructed that with respect to manslaughter, so I'm in respect to manslaughter, reckless, and not to have an additional burden to disprove the use of physical. You're instructed, though, that a person does not act recklessly is justified. It just feels, it looks so similar to the other, that it looks very similar to the affirmative defense one, and I think it's much cleaner to have defense instruction that just talks. I took the language for the proposed defense instruction from a case I'm very familiar with, People v. Justin Brendan Martinez, 22 COA 111 or 19 CA 1881. At the bottom of page 7, I just incorporated, they were incorporating this court's verbal, that sounded like, instruction, written instruction that into instruction. The proposed defense instruction is very straightforward and streamlined into the record.
That's the one Mr. Pello sent me.
Says the evidence presented as defense of physical force for special negotiation.
All right.
Charge of reckless manslaughter, or the lesser. Is the prosecution's burden to prove each element of by law, Mr. Cooper and the could not act recklessly nor
All right, on behalf of Mr. Cichuniec, from the people.
Your Honor, we object to the defense proposed traverse instruction. We believe that ours more clearly matches the Colgi pattern H10, which relates to self-defense, but is the format to be followed for traverses. It accurately reflects what the Supreme Court told us in Pickering. Additionally, I'll cite the court to People v. McClelland, 2015 COA 330. Oh, I'm sorry. It's a 2015 Court of Appeals case. The citation is 330 P. 3rd 976. And in that case, they disapproved of an instruction similar to the one that the defense has proposed here. It is not truly a traverse. It is far closer to an affirmative defense or almost a directed verdict. The people would object to it and believe that the one that we have provided is the appropriate language for a traverse.
All right, the court would find, based upon Colgi as well as the case law that followed, the court will find that this is an appropriate instruction. I will, however, move it up into the numbers so it goes right behind the reckless manslaughter and criminally negligent homicide instruction. Then there'll be a number of other instructions. And then the affirmative defense, the actual affirmative defense instruction will follow the second-degree assault counts. So 26 is what I have now for the moment anyway, but it's likely to change the actual affirmative defense instruction that the court has approved. Now I have instruction number 26, page 28.
The only other change later in the instruction where it referenced which offenses it related to, we removed the reckless manslaughter and the criminally negligent homicide and conformed the second-degree assault to both reference consistently amongst the other instructions. And that is in the paragraph beginning with after, as well as, or both paragraphs beginning with after.
With that record, Judge, no additional record.
And the people also stand on their prior record, Your Honor.
Okay, very well. 27 hopefully won't be controversial. It's members of the jury, you may discuss the case in the jury room. Any objection? 28, everybody, I believe, agreed to. That includes press coverage as well as related information, assuming that's okay. 29 is, and this is page 31, I should say. And I have it numbered at the moment as instruction number 29. That instructs the jury what to do if they have a question. Any problems with that? Okay. And then the final instruction. And by the way, I took out the one that was in order. I think it preceded this one about for the alternates. I generally don't tell them prior to the closing arguments who's going to be the alternate, or they might shut it down. So I give that after we're ready to send the 12 back. And with respect to sending the 12 back, the court's, what I plan to do is release the jurors, not totally release, but excuse the jurors in seats 11 and 12. And the remainder will be our jury. I will instruct them to, as recommended, I think, by counsel. I think it's a good idea not to speak with anybody about the case. And once we decide we don't need them anymore, we'll let them know.
With respect to the court's proposed handling of that, go on
I don't have time to copy them. What's your record?
Judge, I just wanted to make a record as to 50 and number. During the first days, I don't, once we started. There was a juror that nodded off, but once we speak for. But I did know. Yes, he's been nodding.
And juror number 11 is not an alternate. The alternates would be the jurors in, at least at the time being, in seats 11 and 12. Yeah, it was 7, 11, 12, 7's gone already.
Yeah, 7 went up in, right?
Yeah, 7 would move up. So for the juror who used to be in seat number 5 would be conceivably
The juror number,
okay.
juror number, and the two that I've been noticing. Front row. And then juror number 50 is in the back. And I will tell the court that I've noticed, I've counted days. That's just concerning, and it was in both sides of the case. Have alternates, my request would be those two be the alternates. They're the ones who portions of the testimony. That would be my.
Okay, on behalf of Mr. Cichuniec.
I would join those. Your Honor.
For the people.
Judge, with regards to juror number 50, since that issue first became raised in the first week of trial, we've tasked some of our team members in the audience with paying very close attention to all the members of the jury. And as soon as they see anybody nodding off, they send a message to us over Teams, and we take a Teams break. I think it would be fair to say that juror number 50 has probably not missed more than a couple of minutes of testimony total, because it just ends up getting caught really quickly since that first week. So I think that he is on the jury panel. He has been very attentive, except for those brief moments that have been quickly caught by the court and the court staff. And I think that the remedy of us taking those frequent stretch breaks has really cured any problem with regards to juror 50. He's otherwise extremely attentive and engaged. He's often leaning forward in his seat. He's paying attention to the evidence. And there's certainly no reason that he should be removed from the jury due to a lack of attention. The juror in seat 11, no prior record has been made about that juror at the bench from the defense. And I'm surprised to hear that they want to try and now, well, I'm not surprised, because I know that they strategically want to get the last juror on. That's what this is really about, is that the last alternate they think is a much more favorable juror to them than the other ones. That's what this is really about. But there was no record made about.
All right, I generally disregard those sorts of comments, but
The fundamental thing about juror in seat 11 is that no record has been made about him sleeping. I don't have any notes about him sleeping. Certainly no prophylactic steps were taken to try and fix any attention-based issues. And from my perception, since he's a juror that I can see very well from where I'm seated, he's been paying extremely close attention, sets up his hearing device first thing in the morning, and it's clear that he's been paying attention. So I don't think there's any reason to deviate from what the court already said, which is to release jurors in seats 11 and 12 as the alternates, and give them that instruction that I do agree is a very wise instruction to recommend to them that they stay far away from any media, not talk to anybody about the case, because there will be an extra temptation for them not being part of the deliberations to do so. So I think that the court's order is sound and should proceed with it.
all right. The matters before the court with respect to, I suppose, who the alternates are going to be, the suggestion made by the defense is that the juror in seat number 4, who's juror number 50, be released, as well as the juror in seat number 11, who is juror number 12 on the original list, be released. The court would note that, first of all, it has not been brought to the juror number 11 and seat number 11. That really wasn't brought to the attention of the court, but the court has tried to pay some extra attention, I suppose, would be fair to the juror, because at least a day or two in this trial, we had neglected to give him his assisted listening device. The other thing I was trying to pay attention to with respect to that juror is that they're battery powered, they're rechargeable batteries, but I wanted to make sure that he was able to hear what was being said, and that the battery wasn't dying. I figured he'd signal or something if that were the case. So I really don't find, based upon my observations, and I paid special attention to juror number 11. With respect to juror number 50 in seat number 4, the court again notes that early in the trial, when there was no request to have juror number 50 dismissed, it was brought to the court's attention, and the court then started to pay more attention to juror number 50, and I suppose to a certain degree as to juror number 20 as well. In the court's observations, I noticed that juror number 50 was looking down on a number of occasions, and I thought, well, maybe he's sleeping, and then he'd rise up and start writing. So I'm going to decline the request to alternate the alternates.
Your Honor, there's just one other matter for the people. We realized that we forgot to send the court the verdict forms, and we are sending that now to defense counsel and the court.
Okay, I was going to mention that. Well, I'm going to go back and start renumbering, and then I'll make a copy for counsel of the instructions.
And Your Honor, for the record, the only deviation from Colgi on the verdict forms is based on the special interrogatory with the principal and/or defendant, based on the serious bodily injury interrogatory that the court approved of. in
Okay.
the,
I don't think I've ever seen them, the verdict forms. But
They are coming your way soon.
okay, well, the court's going to be in recess. The jurors are hopefully coming back at 12:30, and we'll get started with the reading of the instructions and the closing arguments. I expect we'll take a break about halfway in between those things. are present. We've had a bit of a snafu in that the copy machine overheated and jammed, but we're, so I think my staff has delivered a copy of the jury instructions to the parties, as well as on the seats of the jurors. Anything before the jurors return?
Mr. Cichuniec.
Not for the people, Your Honor.
I expect, based upon our discussion, I just want to make sure that everybody understands that when we chose our lots, if you will, for the alternates, we discussed the jurors in 7, 11, and 12 are the ones that were pulled in seats 7, 11, and 12. So, okay. Okay. Here's entering. All right, our jurors have returned and are in the process of being seated. Will please be seated. And the court will recall two matters, 21 CR 2800 and 21 CR 2806. Those are people of the state of Colorado v. Jeremy Cooper and people of the state of Colorado v. Peter Cichuniec. The parties and counsel are present, the jurors are present. Apologize for the delay. I wasn't anticipating that the copy machine would jam. But you all have copies of the jury instructions that I must read to you. Feel free to read along, and you will be able to take these jury instructions with you into the jury room when you deliberate. Members of the jury, the evidence in this case has been completed. In a moment, I will read you the instructions that contain the rules of law you must apply to reach your verdict. You will have copies of what I read to take with you to the jury room. But first, I want to mention a few things you need to keep in mind when you are deliberating this case in the jury room. Until you have returned a verdict, you must not do any research about this case or this kind of case using any source, including dictionaries, reference materials, the internet, or any other electronic means. You must not communicate in any way with anyone else about this case or this kind of case until you have returned a verdict in court. This includes your family and friends. If you have cell phones or other electronic devices, you must keep the devices turned off during jury deliberations. It is my job to decide what rules of law apply to the case. While the attorneys may comment on some of these rules, you must follow the instructions I give you. Even if you disagree or do not understand the reasons for some of the rules of law, you must follow them. No single instruction describes all the law which must be applied. The instructions must be considered together as a whole. During the trial, you received all of the evidence that you may properly consider in deciding the case. Your decision must be made by applying the rules of law that I give you to the evidence presented at trial. Remember, you must not be influenced by sympathy, bias, or prejudice in reaching your decision. If you decide the prosecution has proved beyond a reasonable doubt that Mr. Cichuniec and or Mr. Cooper is guilty, it will be my job to decide what the punishment will be. In making your decision, you must not consider punishment at all. At times during the trial, attorneys made objections. Do not draw any conclusions from the objections or from my rulings on the objections. These only related to legal questions I had to decide and should not influence your thinking. If I told you not to consider a particular statement that was made during the trial, you must not consider it in your deliberations. I have asked questions of witnesses during the trial. That did not mean that I had any opinion about the facts of the case. Finally, you should consider all the evidence in light of your experience in life. Number two, the charges against Peter Cichuniec and Jeremy Cooper are not evidence. The charges against Mr. Cichuniec and Mr. Cooper are just accusations. The fact that Mr. Cichuniec and Mr. Cooper have been accused is not evidence that either of them committed any crime. Peter Cichuniec and Jeremy Cooper are charged with committing the crimes of manslaughter reckless, August 24 to August 27, 2019, assault in the second degree with intent to cause bodily injury, causing serious bodily injury, August 24, 2019, and with assault in the second degree, unlawful administration of drugs, August 24, 2019, in Adams County, Colorado. The defendants have pleaded not guilty. 3, every person charged with the crime is presumed innocent. This presumption of innocence remains with Mr. Cichuniec and Mr. Cooper throughout the trial and should be given effect by you unless, after considering all the evidence, you are convinced that Mr. Cichuniec or Mr. Cooper is guilty beyond a reasonable doubt. The burden of proof in this case is upon the prosecution. Prosecution must prove to the satisfaction of the jury beyond a reasonable doubt the existence of each and every element necessary to constitute the crime charged. This burden requires more than proof that something is highly probable, but it does not require proof with absolute certainty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If you are firmly convinced of Mr. Cichuniec's or Mr. Cooper's guilt, then the prosecution has proven the crime charged beyond a reasonable doubt. But if you think there's a real possibility that Mr. Cichuniec and/or Mr. Cooper is not guilty, then the prosecution has failed to prove the crime charged beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has proven each of the elements of a crime charged beyond a reasonable doubt, you should find Mr. Cichuniec and/or Mr. Cooper guilty of that crime. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements of the crime charged beyond a reasonable doubt, you should find Mr. Cichuniec and/or Mr. Cooper not guilty of that crime. Number 4, you are the sole judges of the credibility of each witness and the weight to be given to the witness's testimony. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. For each witness, consider the person's knowledge, motive, state of mind, demeanor, and manner while testifying. Consider the witness's ability to observe, the strength of that person's memory, and how that person obtained his or her knowledge. Consider any relationship the witness may have with either side of the case and how each witness might be affected by the verdict. Consider how the testimony of the witness is supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence when you evaluate each witness's testimony. You are not bound by the testimony of witnesses who have testified as experts. Their credibility, the credibility rather, of an expert's testimony is to be considered as that of any other witness. The weight you give an expert's testimony is entirely your decision. You may believe all of the testimony of a witness, part of it, or none of it. The number of witnesses testifying for or against a certain fact does not by itself prove or disprove that fact. 5, a fact may be proven by either direct or circumstantial evidence. Under the law, both are acceptable ways to prove something. Neither is necessarily more reliable than the other. Direct evidence is based on firsthand observation of the fact in question. Circumstantial evidence is indirect. It is based on observation of related facts that may lead you to reach a conclusion about the fact in question. Number 6, the court has taken judicial notice of a certain fact. You may or may not accept that fact as true. It is entirely your decision to determine what weight, if any, shall be given to the evidence. 7, in this case, separate offenses are charged against each of the defendants in each count of the indictment. Each count charges a separate and distinct offense, and the evidence and the law applicable to each count should be considered separately, uninfluenced by your decision as to any other count. The fact that you may find Mr. Cichuniec or Mr. Cooper guilty or not guilty of one of the offenses charged should not control your verdict as to any other offenses charged against Mr. Cichuniec or Mr. Cooper. Mr. Cichuniec or Mr. Cooper may be found guilty or not guilty of any one or all of the offenses charged. In this case, you must decide separately whether each of the two defendants is guilty or not guilty. If you cannot agree upon a verdict as to both defendants, but do agree as to one of them, you must render a verdict as to the one upon which you do agree. It is your duty to give separate personal consideration to the case of each individual defendant. When you do so, you should analyze what evidence in the case shows with respect to that individual. Each defendant is entitled to have his case determined from evidence as to his own acts and culpable state of mind, and any other evidence in the case which may be applicable to him. You must state your finding as to each defendant uninfluenced by your verdict as to the other defendant. Number 8, the crime is committed when the defendant has committed a voluntary act prohibited by law together with a culpable state of mind. A voluntary act means an act performed consciously as a result of effort or determination. Proof of the voluntary act alone is insufficient to prove that the defendant had the required state of mind. The culpable state of mind is as much an element of the crime as the act itself and must be proven beyond a reasonable doubt either by direct or circumstantial evidence. In this case, the applicable states of mind are explained below. A person acts intentionally or with intent when his conscious objective is to cause the specific result prescribed by the statute defining the offense. It is immaterial whether or not the result actually occurred. A person acts recklessly when he consciously disregards a substantial and unjustifiable risk that a result will occur or that a circumstance exists. A person acts with criminal negligence when, through a gross deviation from the standard of care that a reasonable person would exercise, he fails to perceive a substantial and unjustifiable risk that a result will occur or that a circumstance exists. Number 9, certain words and phrases have particular meaning. The following are definitions of these words and phrases. Administer means to apply a controlled substance, whether by injection, inhalation, ingestion, or any other means directly to the body of another. Bodily injury means physical pain, illness, or any impairment of physical or mental condition. Conduct means an act or series of acts and its accompanying state of mind, or where relevant, a series of acts. Drug means substances intended for use in the diagnosis, cure, mitigation, treatment, or prevention of disease in individuals intended to affect the structure or any function of the body of individuals. Serious bodily injury means injury which either at the time of the actual injury or at a later time after the actual injury involves a substantial risk of death or a substantial risk of protracted loss or impairment of the function of any part or organ of the body. Instruction number 10. Each defendant is charged with the crime of manslaughter reckless. The elements of the crime of manslaughter are: 1, that the defendant; 2, in the state of Colorado, in the county of Adams, on or about August 24th, 2019, up through and including August 27th, 2019. 3, recklessly; 4, caused the death of Elijah McClain. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of manslaughter. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of manslaughter. 11, if you are not satisfied beyond a reasonable doubt that the defendant is guilty of the offense charged, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the offense charged if the evidence is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt. The offense of manslaughter reckless as charged in the indictment in this case necessarily includes the lesser offense of criminally negligent homicide. The elements of the crime of criminally negligent homicide are: 1, that the defendant; 2, in the state of Colorado and the county of Adams, on or about August 24, 2019, up through and including August 27, 2019, caused the death of Elijah McClain; 4, by conduct amounting to criminal negligence. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser included offense that is necessarily included in the offense charged in the indictment. The law never imposes upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide the prosecution has proven each of the elements of manslaughter reckless, you should find the defendant guilty of that offense and should so state in your verdict. After considering all the evidence, if you decide the prosecution has failed to prove one or more of the elements of manslaughter reckless, then you must decide whether a defendant is guilty or not guilty of criminally negligent homicide. After considering all the evidence, if you decide the prosecution has proven each of the elements of criminally negligent homicide, you should find the defendant guilty of that offense, and you should so state in your verdict. If you decide the prosecution has failed to prove one or more of the elements of criminally negligent homicide, you should find the defendant not guilty of that offense, and you should so state in your verdict. While you may find the defendant not guilty of both manslaughter reckless and criminally negligent homicide, you may not find the defendant guilty of more than one of the following offenses: reckless manslaughter or criminally negligent homicide. Instruction number 12. The evidence presented in this case has raised the question of use of physical force in a special relationship with respect to manslaughter reckless and criminally negligent homicide. The defendant was legally authorized to use physical force upon another person if, one, he was a duly licensed paramedic acting under the direction of a duly licensed physician, and two, he used reasonable and appropriate physical force for the purpose of administering a recognized form of treatment that he reasonably believed to be adapted to promoting the physical or mental health of the patient, and three, the treatment was administered in an emergency when the duly licensed paramedic acting under the direction of a duly licensed physician reasonably believed that no one competent to consent could be consulted, and that a reasonable person wishing to safeguard the welfare of the patient would consent. You have been instructed that the prosecution has the burden of proving beyond a reasonable doubt all of the elements of manslaughter, reckless, and criminally negligent homicide, including that the defendant acted recklessly or in a criminally negligent manner. You are further instructed that with respect to manslaughter, reckless, and criminally negligent homicide, the prosecution does not have an additional burden to disprove the use of physical force special relationship. You are instructed, though, that a person does not act recklessly or in a criminally negligent manner if his conduct is legally justified as set forth above. This instruction applies only to manslaughter, reckless, and criminally negligent homicide. 13. Each defendant is charged with the crime of assault in the second degree, intent to cause bodily injury, causing serious bodily injury. The elements of the crime of assault in the second degree, intent to cause bodily injury, causing serious bodily injury are: one, that the defendant, two, in the state of Colorado and the county of Adams on or about August 24, 2019, three, with intent, four, to cause bodily injury to Elijah McClain, five, caused bodily injury to Elijah McClain, six, and the defendant's conduct was not legally authorized by the affirmative defense in instruction 26. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of assault in the second degree, intent to cause bodily injury, causing serious bodily injury. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of assault in the second degree, intent to cause bodily injury, causing serious bodily injury. Fourteen. Each defendant is charged with the crime of assault in the second degree, unlawful administration of drugs. The elements of the crime of assault in the second degree, unlawful administrations of drugs are: one, that the defendant, two, in the state of Colorado and the county of Adams on or about August 24, 2019, three, intentionally, four, for a purpose other than lawful medical or therapeutic treatment, five, caused stupor, unconsciousness, or other physical or mental impairment or injury to Elijah McClain, six, by administering a drug, substance, or preparation capable of producing the intended harm, seven, without that person's consent, eight, and that the defendant's conduct was not legally authorized by the affirmative defense in instruction 26. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of assault in the second degree, unlawful administration of drugs. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of assault in the second degree, unlawful administration of drugs. 15. The word cause as used in these instructions means an act or series of acts that in natural and probable sequence produced the claimed injury or death. It is a cause without which the claimed injury or death would not have happened. If more than one act or series of acts contributed to the claimed injury or death, then each act or series of acts may have been a cause of the injury or death. A cause does not have to be the only cause or the last or nearest cause if the act or series of acts joins in a natural and probable way with some other act or series of acts to cause some or all of the claimed injury or death. 16. You may find that Mr. Cichuniec and Mr. Cooper committed the charged offenses as a principal or as a complicitor or as both. Mr. Cichuniec and Mr. Cooper are alleged to be complicit in each other's actions, but not the actions of law enforcement. The following complicit or liability instructions should be considered in this light. 17. For manslaughter, reckless, the defendant may be either a principal or a complicitor. Complicity is not a separate crime, rather it is a legal theory by which one person may be found guilty of a criminal offense that was committed by another person. For the defendant to be found guilty as a complicitor of the crime of manslaughter reckless as defined at the end of this instruction, the prosecution must prove each of the following conditions beyond a reasonable doubt. 1, another person or persons committed the crime of manslaughter as defined at the end of this instruction. The defendant with the desire or the purpose to aid, abet, advise, or encourage the other person or persons in the planning or committing that crime. 3, aided, abetted, advised, or encouraged the other person or persons in the planning or committing that crime. 4, that the defendant was aware of elements 1, 2, and 3 of that crime as defined at the end of this instruction. For the purposes of this instruction, another person committed the crime of manslaughter reckless if the prosecution proves each of the following elements beyond a reasonable doubt. That the other person or persons to in the state of Colorado and the county of Adams on or about August 24, 2019 to August 27, 2019. 3, recklessly. 4, caused the death of Elijah McClain. After considering all the evidence, if you decide the prosecution has proven each of the conditions of complicity liability beyond a reasonable doubt, you should find the defendant guilty of manslaughter reckless. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the conditions of complicity beyond a reasonable doubt, you should find the defendant not guilty of manslaughter reckless. 18, the prosecution alleges that Mr. Cichuniec or Mr. Cooper are each guilty of the crime of manslaughter reckless as a principal or as a complicitor. You have received separate instructions regarding these two theories of liability. Instruction 10 describes the principal theory of liability, and instruction 17 describes the complicity theory of liability. You should consider the two theories separately. Your determination of whether either defendant is guilty of the above referenced crime as a principal should not affect your determination of whether the defendant is guilty of the above referenced crime as a complicitor. Similarly, your determination of whether either defendant is guilty of the above referenced crime as a complicitor should not affect your determination of whether the defendant is guilty of the above referenced crime as a principal. You may find the defendant not guilty of the above referenced crime under both theories of liability, principal liability and complicity liability. Or you may find the defendant guilty of the above referenced crime as a principal, as a complicitor, or as both a principal and a complicitor. 19. For criminally negligent homicide, a defendant may be either a principal or a complicitor. Complicitor is not a separate crime, rather it is a legal theory by which one person may be found guilty of a criminal offense that was committed by another person. For their defendant to be found guilty as a complicitor of the crime of criminally negligent homicide, as defined at the end of the instruction, the prosecution must prove the following conditions beyond a reasonable doubt. 1, another person or persons must have committed the crime of criminally negligent homicide as defined at the end of this instruction. And 2, the defendant with the desire or the purpose or design to aid, abet, advise, or encourage the other person or persons in planning or committing that crime. 3, aided, abetted, advised, or encouraged the other person or persons in planning or committing that crime. 4, the defendant was aware of elements 1, 2, and 4 of that crime as defined at the end of the instruction. Actually, it's 1, 2, 3, and 4. For purposes of this instruction, another person has committed the crime of criminally negligent homicide if the prosecution proves each of the following elements beyond a reasonable doubt. 1, that the other person or persons in the state of Colorado and the county of Adams on or about August 24, 2019 to August 27, 2019 caused the death of Elijah McClain. 4, by conduct amounting to criminal negligence. After considering all the evidence, if you decide the prosecution has proven each of the conditions of complicity beyond a reasonable doubt, you should find the defendant guilty of criminally negligent homicide. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the conditions of complicity beyond a reasonable doubt, you should find the defendant not guilty of criminally negligent homicide. 20, the prosecution alleges that Mr. Cichuniec or Mr. Cooper are each guilty of the crime of criminally negligent homicide as a principal or as a complicitor. You have received separate instructions regarding the two theories of liability. Instruction 11 describes the principal theory of liability, and instruction 19 describes the complicity theory of liability. You should consider the two theories separately. Your determination of whether either defendant is guilty of the above referenced crime as a principal should not affect your determination of whether the defendant is guilty of the above referenced crime as a complicitor. Similarly, your determination of whether either defendant is guilty of the above referenced crime as a complicitor should not affect your determination of whether the defendant is guilty of the above referenced crime as a principal. You may find the defendant not guilty of the above referenced crime under both theories of liability, principal liability and complicity liability. Or you may find the defendant guilty of the above referenced crime as a principal, as a complicitor, or as both a principal and a complicitor. 21. For assault in the second degree intent to cause bodily injury causing serious bodily injury, a defendant may be either a principal or a complicitor. Excuse me for a moment. Complicity is not a separate crime, rather it is a legal theory by which one person may be found guilty of a criminal offense that was committed by another person. For the defendant to be found guilty as a complicitor of the crime of assault in the second degree intent to cause bodily injury causing serious bodily injury as defined at the end of this instruction, the prosecution must prove each of the following conditions beyond a reasonable doubt. 1, another person or persons must have committed the crime of assault in the second degree intent to cause bodily injury causing serious bodily injury. 2, the defendant with the desire or the purpose or design to aid, abet, advise, or encourage the other person or persons in the planning or committing that crime rather. 3, aided, abetted, advised, or encouraged the other person or persons in planning or committing that crime. The defendant was aware of elements 1, 2, 3, 4, and 6 of that crime as defined at the end of this instruction. 5, and the defendant's conduct was not legally authorized by the affirmative defense in instruction 26. For the purposes of this instruction, another person committed the crime of assault in the second degree intent to cause bodily injury causing serious bodily injury if the prosecution proves each of the following elements beyond a reasonable doubt. 1, that the other person or persons in the state of Colorado, in the county of Adams, on or about August 24, 2019, with the intent 4, to cause bodily injury to Elijah McClain. 5, cause serious bodily injury to Elijah McClain. And it's 21A that follows. After considering all the evidence, if you decide the prosecution has proven each of the conditions of complicity beyond a reasonable doubt, you should find the defendant guilty of assault in the second degree, intent to cause bodily injury, causing serious bodily injury. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the conditions of complicity beyond a reasonable doubt, you should find the defendant not guilty of assault in the second degree, intent to cause bodily injury, causing serious bodily injury. 22. The prosecution alleges that Mr. Cichuniec or Mr. Cooper are each guilty of the crime of assault in the second degree, intent to cause bodily injury, causing serious bodily injury, as a as a principal or as a complicitor. You have received separate instructions regarding these two theories of liability. Instruction 13 describes the principal theory of liability, and instruction 21 describes the complicity theory of liability. You should consider the two theories separately. Your determination of whether either defendant is guilty of the above referenced crime as a principal should not affect your determination of whether the defendant is guilty of the above referenced crime as a complicitor. Similarly, Your determination of whether either defendant is guilty of the above referenced crime as a complicitor should not affect your determination of whether the defendant is guilty of the above referenced crime as a principal. You may find the defendant not guilty of the above referenced crime under both theories of liability, principal liability, and complicity liability, or you may find the defendant guilty of the above referenced crime as a principal, as a complicitor, or as both a principal and a complicitor. 23. For assault in the second degree, unlawful administration of drugs, a defendant may be either a principal or a complicitor. Complicity is not a separate crime, rather it is a legal theory by which one person may be found guilty of a criminal offense that was committed by another person. For the defendant to be found guilty as a complicitor to the crime of assault in the second degree, unlawful administration of drugs, as defined at the end of this instruction, the prosecution must prove each of the following conditions beyond a reasonable doubt. 1, another person or persons must have committed the crime of assault in the second degree, unlawful administration of drugs. 2, the defendant with the desire or the purpose or design to aid, abet, advise, encourage the other person or persons in planning or committing that crime. 3, aided, abetted, advised, or encouraged the other person or persons in planning or committing that crime. 4, the defendant was aware of elements 1, 2, 3, 4, 6, and 7 of that crime as defined at the end of this instruction. 5, and the defendant's conduct was not legally authorized by the affirmative defense in instruction 26. For the purposes of this instruction, another person committed the crime of assault in the second degree, unlawful administration of drugs, if the prosecution proves each of the following elements beyond a reasonable doubt: that the other person or persons, two in the state of Colorado and the county of Adams, on or about August 24, 2019, 3, intentionally for a purpose other than lawful medical or therapeutic treatment. 5, caused stupor, unconsciousness, or other physical or mental impairment or injury to Elijah McClain. 6, and this is 23A, the second page, by administering a drug, substance, or preparation capable of producing the intended harm. 7, without that person's consent. After considering all the evidence, we decide the prosecution has proven each of the conditions of complicity liability beyond a reasonable doubt. You should find the defendant guilty of assault in the second degree, unlawful administration of drugs. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the conditions of complicity liability beyond a reasonable doubt, you should find the defendant not guilty of assault in the second degree, unlawful administration of drugs. 24. Prosecution alleges that Mr. Cichuniec or Mr. Cooper are each guilty of the crime of assault in the second degree, unlawful administration of drugs as a principal or as a complicitor. You have received separate instructions regarding these two theories of liability. Instruction 14 describes the principal theory of liability, and instruction 23 describes the complicity theory of liability. You should consider the two theories separately. Your determination of whether either defendant is guilty of the above referenced crime as a principal should not affect your determination of whether the defendant is guilty of the above referenced crime as a complicitor. Similarly, your determination of whether either defendant is guilty of the above referenced crime as a complicitor should not affect your determination of whether the defendant is guilty of the above referenced crime as a principal. You may find the defendant not guilty of the above referenced crime under both theories of liability, principal liability, and complicity liability. Or you may find the defendant guilty of the above referenced crime as a principal, as a complicitor, or as both a principal and a complicitor. 25. If you find the defendant not guilty of assault in the second degree, unlawful administration of drugs, you should disregard this instruction and sign the verdict form to indicate your not guilty verdict. If, however, you find the defendant guilty of assault in the second degree, unlawful administration of drugs, whether as a principal or as a complicitor or both, you should sign the verdict form to indicate your finding of guilt and answer the following question on the verdict form. Did the defendant and/or the principal cause serious bodily injury or death? The answer would be yes or no. The defendant and/or the principal cause serious bodily injury or death only if, one, the defendant and/or principal cause serious bodily injury or death to any person except another participant. Two, during the commission of assault in the second degree unlawful administration of drugs. The prosecution has the burden of proof, rather a burden to prove each numbered condition above beyond a reasonable doubt. After considering the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line on the verdict form after considering all the evidence. If you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line on the verdict form. 26. The evidence presented in this case has raised the affirmative defense of use of physical force in a special relationship. With respect to assault in the second degree, intent cause bodily injury causing serious bodily injury, and assault in the second degree, unlawful administrations of drugs. The defendant was legally authorized to use physical force upon another person if, one, he was a duly licensed paramedic acting under direction of a duly licensed physician, and two, he used reasonable and appropriate physical force for the purpose of administering a recognized form of treatment that he reasonably believed to be adapted to promoting the physical or mental health of the patient, and three, the treatment was administered in an emergency when the duly licensed paramedic acting under the direction of a duly licensed physician reasonably believed that no one competent to consent could be consulted, and that a reasonable person wishing to safeguard the welfare of the patient would consent. The prosecution has the burden to prove beyond a reasonable doubt that the defendant's conduct was not legally authorized by this defense. In order to meet this burden of proof, the prosecution must disprove beyond a reasonable doubt at least one of the above numbered conditions. After considering all the evidence, if you decide the prosecution has failed to meet this burden of proof, then the prosecution has failed to prove the defendant's conduct was not legally authorized by this defense, which is an essential element of assault in the second degree, intent to cause bodily injury causing serious bodily injury, and assault in the second degree, unlawful administration of drugs. In that event, you must return a verdict of not guilty of those offenses. After considering all the evidence, if you decide the prosecution has met this burden of proof, then the prosecution has proved the defendant's conduct was not legally authorized by this defense. In that event, your verdicts concerning the charges of assault in the second degree, intent to cause bodily injury causing serious bodily injury, and assault in the second degree, unlawful administration of drugs, must depend upon your determination whether the prosecution has met its burden of proof with respect to the remaining elements of those offenses. 27. Members of the jury, you may discuss this case only when you are all present, and you may only deliberate in the jury room. No juror should attempt to discuss this case with other jurors or anyone else at any other time except when all jurors are in the jury room. 28. If there has been any news coverage of this case or any related information, you must completely disregard it. Your decision in this case must be based solely on the evidence presented at the trial. 29, once you begin your deliberations, if you have a question, your foreperson should write it on a piece of paper, sign it, and give it to the court's judicial assistant, who will bring it to me. The court will then determine the appropriate way to answer the question. However, there may be some questions that, under the law, the court is not permitted to answer. Please do not speculate about what the answer to your question might have been or why the court is not able to answer a particular question. Finally, please be sure to keep the original question and response. Do not destroy them, as they are part of the official record in this case and must be returned to me when you return the instructions and verdict forms at the end of the case. 30. At the conclusion of closing argument, the court's judicial assistant will escort you to the jury room. where you will select one of your members to be your foreperson. Your foreperson will preside over your deliberations and shall sign any verdict form that you may agree on according to the rules I'm about to explain. The verdict for each charge must represent the considered judgment of each juror, and it must be unanimous. In other words, all of you must agree to all parts of it. Only one verdict shall be returned signed for each count for each defendant. The verdict forms and these instructions shall remain in the possession of your foreperson until I ask for them in open court. Upon reaching a verdict, you will inform the court's judicial assistant, who will in turn notify me, and you will remain in the jury room until I call you into the courtroom. You will be provided with 6 verdict forms. When you have unanimously agreed upon your verdicts, you will select the option on each form which reflects your verdict, and the foreperson will sign the verdict forms as I have stated. I will now read to you the verdict forms. You must not draw any inferences based upon the order in which I read them. Verdict forms will read as follows. People of the state of Colorado v. Jeremy Cooper, jury verdict, charge of manslaughter reckless. We, the jury, find the defendant Jeremy Cooper not guilty of manslaughter reckless and the lesser included offense of criminally negligent homicide. Beneath that, there's a signature line for the foreperson. Roman 2, we, the jury, find the defendant Jeremy Cooper of, and there's 2 boxes beneath that, manslaughter reckless or criminally negligent homicide. There's further direction. It says if you find the defendant not guilty of the charged offense and the lesser included offense, the foreperson should sign only section 1 above. If you find the defendant guilty of the crime charged or the lesser included offense, the foreperson should complete only this guilty verdict by placing in ink an X in the appropriate square. Only one square may be filled in with the remainder to remain unmarked. The foreperson will then sign only section 2 above. Next verdict form, this reads the same. People of the state of Colorado v. Jeremy Cooper, charge of assault in the 2nd degree, intent to cause bodily injury, causing serious bodily injury. Roman 1, we, the defendant, find the defendant Jeremy Cooper not guilty of assault in the 2nd degree, intent to cause bodily injury, causing serious bodily injury. Beneath that, there's a signature line for the foreperson. Roman 2, we, the jury, find the defendant Jeremy Cooper guilty of assault in the 2nd degree, intent to cause bodily injury, causing serious bodily injury with signature line for the foreperson. Once again, it explains you may sign only Roman 1 or Roman 2 above. 1 if the verdict is not guilty, 2 if the verdict is guilty. Next, again, is people of the state of Colorado v. Jeremy Cooper, jury verdict, charge of assault in the 2nd degree, unlawful administrations of drugs. Roman 1, we, the jury, find the defendant Jeremy Cooper not guilty of assault in the 2nd degree, unlawful administration of drugs. Signature line for the foreperson. Beneath that, Roman 2, we, the jury, find the defendant Jeremy Cooper guilty of assault in the 2nd degree, unlawful administration of drugs. Beneath that is a signature line for the person. Beneath that, we further find with respect to the verdict question for this count as follows. The question is, did the defendant and or the principal cause bodily injury or death? And then there's 2 boxes, yes or no. And again, once again, as they all read, Roman 1 needs to be signed if the verdict is not guilty. Roman 1 if not guilty, Roman 2 if the verdict is guilty. If the verdict is guilty, then you must mark the answer you find on the question below. All right, now we're to people of the state of Colorado v. Peter Cichuniec. Roman, and this is for reckless manslaughter. We, the jury, find the defendant Peter Cichuniec not guilty of manslaughter, reckless, and the lesser included offense of criminally negligent homicide. Beneath that is a signature line for the foreperson. Beneath that is Roman 2. We, the jury, find the defendant Peter Cichuniec guilty of reckless manslaughter, or beneath that, criminally negligent homicide. As explained in the other instructions, Roman 1 would be where the foreperson signs if the verdict is not guilty. Roman 2, if the verdict is guilty, then you may only select one of the boxes, either reckless manslaughter or criminally negligent homicide if it is a guilty verdict. People of the state of Colorado v. Peter Cichuniec, assault in the second degree, intent to cause bodily injury, causing serious bodily injury. Again, Roman 1 reads, we, the jury, find the defendant Peter Cichuniec not guilty of assault in the second degree with intent to cause bodily injury, causing serious bodily injury with the signature line for the foreperson. Roman 2, we, the jury, find the defendant Peter Cichuniec guilty of assault in the second degree with intent to cause bodily injury, causing serious bodily injury with the signature line. Once again, it explains only one above may be signed, one if not guilty, in Roman 2, if the verdict is guilty. Finally, people of the state of Colorado v. Peter Cichuniec, jury verdict charge of assault in the second degree, unlawful administrations of drugs. Roman 1, we, the jury, find the defendant Peter Cichuniec not guilty of assault in the second degree, unlawful administrations of drugs, with the signature line for the foreperson. Roman 2, we, the jury, find the defendant Peter Cichuniec guilty of assault in the second degree, unlawful administration of drugs. And again, there's a signature line for the foreperson. Only one can be signed, one if not guilty, two if guilty. And beneath that is the question. We further find, and that's if there is a guilty verdict, we further find with respect to the verdict question for this count as follows. The question is, did the defendant and or the principal cause serious bodily injury or death? And then there's a yes or a no. Beneath that is signature line for the foreperson. With that, we'll start the closing argument of counsel.
Defendant Cooper and Defendant Cichuniec made a plan. Here was the plan. We're going to leave that person on the ground. We're not going to speak to him, not a single word. We're not going to touch him, not with a single finger. We're not going to get a single piece of equipment out of our bag to assess him. We're not going to put our faces near his face. We're not going to ask one question about what happened to him. We're not going to listen to what he is trying to say to us. We're just going to wait for the ambulance. And while we wait, we aren't going to do a single one of those things. When the ambulance gets here, we're going to give him the maximum amount of ketamine that we're allowed to give. And we're going to give it to him whether he needs it or not. And then we're going to leave him on the ground, prone. And once he is completely lifeless, we'll pick him up and we'll move him to the gurney, where we will continue to ignore his airway, his breathing, his circulation. And then we'll leave him at the hospital, where he won't be our problem anymore. And we'll still have no idea who he is or why we were even called to help. That was the plan. The defendants that night made decision after decision after decision. And every single one of those decisions ignored the risks to Elijah McClain. I'm going to walk you through the evidence about what those decisions were and the terrific risks that the defendants piled and piled and piled on Elijah McClain until they killed him. It was that first decision, not to do an assessment at all. Within less than a minute of the time the defendants arrive on the scene, Defendant Cooper announces what he's going to do. We'll just leave him there until the ambulance gets there.
Well, we'll just leave him. You've already been told several times to stop. I can't fix myself. Ow! Just leave him there until the ambulance gets here, and then we'll just put him down to the
I think almost every witness in this case agreed that doing a good assessment is the fundamental basis for making any good medical decision. We heard over and over again that it includes getting information from the people on the scene, talking to your patient. Remember, how can I help you? What can I do for you today? And then doing a good physical exam. You talk to your patient so you can understand what their complaints are. You can understand if they're oriented. You can understand how they're doing. You do that physical exam, you check their ABCs, you check their vital signs. You can learn so much from listening to a patient breathe, from feeling their pulse, from touching their skin. The defendants didn't do a single one of these things. And this assessment, this is what's specifically called for by the very protocol they were going under. Those first 3 boxes, they all require that the paramedic try to figure out what is going on with the patient. It tells you to try to address the patient's concerns, figure out if they've got a medical cause of what's going on with them, and then try to fix that. And that's exactly what the defendants were trained about ketamine and excited delirium. Excited delirium can have mimics. Lots of different things have similar symptoms. They were supposed to think about that. Think about what symptoms this patient actually had and try to treat them. They didn't do any of that. At the beginning of this case, I showed you this slide, and I told you that the evidence would show that the defendants failed to do every single one of these things. Didn't tell Elijah who they were, didn't try to identify him, didn't try to get his consent, didn't ask the police a question about it, didn't speak a single word to him. Didn't get a piece of equipment out of the bag, didn't kneel down to look at him, didn't lean over to look at him, didn't put a single finger on him, didn't take a single vital sign. And now you've seen the evidence. Every single witness that was there that night that you heard testify, Mr. DeJesus, Mr. Bradley, Mr. Walker, Ms. Gonzalez, Sergeant Leonard, Officer Ward, every single one of them confirmed that not one of these things happened. And of course, you guys have watched it all on the body-worn camera. We also know that the defendants were supposed to gather information from the police about what had happened. And we watched Sergeant Leonard try over and over to tell them what happened. We put him into a carotid hold twice. He went out. He's been vomiting. And it's like they put on earmuffs and didn't even want to hear that information. Here's Defendant Cichuniec admitting they had no idea what was happening at that scene.
Whose responsibility is it to gain any more information at that time? Is it yours as or who provided the most information, or how did you get any more information when you got there?
Try to find out who primary is on APD side and speak to them.
And did you speak to someone at that time?
No, it was just general, a couple of people, and I don't know which officers they were.
Okay. And general information, what did you receive? Any more updated information at that time?
Nothing that we couldn't see.
Here it is again.
Did officers tell you anything to that effect? That he was displaying excited delirium behavior or anything of that nature?
Not that I recall.
Okay. Did the officers explain to you anything that had been done to the person on the ground? Did they at any time tell you they had used any type of arrest control or force to detain him?
No.
Okay.
They knew nothing. They learned nothing. They asked no questions. They didn't care. Let's talk about the excuses that you've heard from the defendants as to how they failed this requirement so egregiously. And when you think about these excuses, I need you to bring some very basic tools to that, your eyeballs and your common sense. First, we heard them say, oh, well, a visual assessment was fine, that we just needed to look at him and that would be sufficient. And you saw some experts sit up here and look over at the lawyer at the podium and say, see, I can visually assess you. I can see your breathing. I can see you have a pulse. You're standing up and you're talking. But Elijah wasn't standing up at a podium talking. He was down on the ground. He was gasping and gurgling. He was pleading for help. A visual assessment was not enough. The next excuse they had is that they wanted to do a better assessment, but Elijah was too aggressive, or the police were too aggressive, or they worried somebody was going to get agitated, or they were trying to de-escalate the police. This is where you're going to have to watch the video and use your common sense. Elijah is barely moving while the paramedics are there, maybe wiggling at the very most. He's not too aggressive to do an assessment of. And you're going to have to watch the video too and make your judgment about how these defendants felt about the police. Were they really too intimidated to do anything? They sure looked comfortable when they came in to give that ketamine, telling everybody what to do. Comfortable. That's how I think they looked at that scene. Here was another excuse that we heard. Defendant Cichuniec told you on Monday that they couldn't assess Elijah because he wasn't their patient until he was out of handcuffs. What? They could inject him with ketamine when he wasn't their patient, but they couldn't get down and take his pulse? Again, folks, you're going to have to bring your common sense to think about these arguments. What were the risks of not assessing Elijah? I think we heard it best from Dr. Buther. He said that giving a drug is like hitting the gas when you can't see out of your windshield if you haven't done an assessment of your patient. And you heard the same thing from Mr. Ludwig, the defendant's expert. Got up there and said, you have to bat 1,000 when you do a patient assessment, because if you don't treat the right thing, you're not going to help your patient. There was so much time to do this here. So much time to give Elijah the assessment that he was entitled to. So what is the risk of not assessing your patient? You're giving them the wrong treatment. And what happened? They made their next decision. Give ketamine. Within 2 minutes of arriving at the scene and having done nothing but barely look at Elijah, Mr. Cooper announces his plan again. When the ambulance gets here, we're going to go ahead and give him some ketamine. And what was the defendant's excuse for giving ketamine to someone who was already being easily restrained by the police? Well, there was only one excuse that they could give, and that's that he had excited delirium, because that's the only thing that would justify them giving ketamine. It was the only thing they were allowed to give ketamine for. But Elijah didn't have excited delirium. He wasn't truly out of control. You saw the videos from the training and what those types of patients look like. He was responding to the police. He was crying out in pain. He was apologizing. The police actually don't look like they're struggling to control him at all. And the defendants don't observe a single symptom that's on this list while they're there. Disorientation, paranoia, hallucinations, they never speak to or hear one word that Elijah has spoken. So they couldn't possibly think that he has any of these symptoms. Tachycardia, hyperthermia, if you want to find out that those symptoms exist, you have to actually touch your patient. And they don't do either one find out either one of those things, not once. And then there's increased strength. Before Defendant Cooper announces his plan to give the ketamine, no one said anything about increased strength. Elijah's being restrained on the ground easily. But after he says ketamine, then the police jump in. Oh, he did a push-up with us on his back. Oh, he was crazy strong. They never see one piece of evidence of that with their own eyes, and they never hear anything about it until after they made the decision to give ketamine. And what was the risk of giving ketamine without having done an assessment? Well, one of the risks is that if you're treating the wrong thing, you're not treating the right thing. You heard from expert after expert that Elijah was having acidosis, hypoxia, that he had aspirated vomit into his lungs, and that all he needed to treat that was oxygen and fluids. Even the defendant's expert, Dr. Dragovich, told you that. But the paramedics didn't do that because they were determined to give ketamine, and they didn't give him those basic life-saving measures that would have been so easy to give. So they haven't assessed their patient. They've chosen the wrong treatment, and now they've missed the right treatment. And what do they do next? The next decision, let's max out that ketamine dose. Defendants were taught over and over again that ketamine was a weight-based drug. You do not deviate from that. It's in the ketamine protocol, that's Exhibit 225. And it was in their training repeatedly. 5 milligrams per kilogram, that's the dose of ketamine that you give. And you know, we've shown it, they've told over and over again, 500 milligrams is not, for everybody, is not a good practice. Defendant Cichuniec, he admits he knew he wasn't supposed to give 500. Even under his inflated weight estimate, the maximum he should have given was 425. But he said, I don't want to pick up the phone and have to call for more, because that's what you have to do if you want to give a second dose. So what did he do? He just went ahead outside the protocol and gave the wrong dose. And we've heard some excuses about this too. Well, it's really hard to estimate somebody's weight. These guys didn't even try. They were going to give 500. They didn't care how much he weighed. All the things you could have done to check on somebody's weight, ask them, ask other people what they thought they weighed, check in with your partner. They didn't do any of that. They went straight to 500. We also heard that they had to give 500 because you couldn't give less than that with the syringe that they had. This is another one where you just have to use your common sense. Of course they could have given a lower dose. Of course they could have given the right dose. And then another thing that I expect you'll hear, well, they thought ketamine was safe. But again, your common sense will tell you that if you are told to give a weight-based dose for a controlled substance that's kept under lock and key, you don't just decide to give more. And the safety margin that you heard Dr. Hill talking about yesterday, generally ketamine is safe. And what did he say? He said it's safe in that 3 to 5 milligram per kilogram range. And he said, I've even heard sometimes where they're allowed to give 6 milligrams per kilogram. But remember how much Elijah got? 7.7 milligrams per kilogram, outside of even Dr. Hill's wide safety margin. And the defendants knew the risks of giving an overdose of ketamine. This was what they were taught. Respiratory drive should be preserved with appropriate dosing, but large doses increase the likelihood of adverse effects, and specifically respiratory depression. And the defendants admit they knew about that specific risk. And the experts confirmed it. Even defendant's expert, Dr. Hurd, he admitted it's true. The more ketamine you give, the higher the risks of respiratory depression. And Dr. Robinson said it as well. When you give a higher dose, does that mean there's more opportunity for respiratory depression in the patient? Yes, it's a higher risk. There will be a respiratory compromise or depression. And again, even the defendants admit that they knew. In fact, Defendant Cooper, this was the only risk that he knew about when he was interviewed by the police. So they failed to assess. They decided to give the wrong thing. They've decided to give the maximum dose of the wrong thing, even though they know that it carries a risk of respiratory depression. Elijah is deteriorating in front of their eyes at this point, but they are not changing their plan. You can look at him and see that he has no need for ketamine. They're going to give it anyway. You heard a lot of witnesses talk about why you give ketamine to somebody who has excited delirium. It's because they're struggling so much, they're so out of control that they're going to keep building up that lactic acidosis and they're not going to stop. Elijah is on the ground, barely moving. He does not need to have struggling minimized. He's not truly out of control. You'll remember what he looks like in this time while they're waiting on the case.
We haven't even got that far yet, man.
He's like saying stuff, he's holding his arms in, and he's like, I don't know exactly what that is.
My knee's on his elbow, dude. He ain't going anywhere.
Frank, do you relief?
No, I'm good. I'm just gonna pat him down, make sure he doesn't have anything, because we haven't got to that far yet.
Our experts told you there was no medical purpose for him to get ketamine at this point. You heard it from Dr. Buther, and you heard it from Dr. Mitchell. No medical purpose. And what is the excuse that the defendants offer here? They say, well, we couldn't deviate from our protocol. Once we had decided to go down this protocol, we had to give ketamine. We had no choice. That's not true. The experts told you otherwise. Mr. Chambers and Dr. Hill said, no, if you're on a protocol and your condition of your patient changes, then you change what you're doing. You're not a robot. These are trained professionals with judgment to exercise. And of course, you don't sedate somebody who is barely moving. And what were the risks of giving ketamine to somebody who was barely moving? You're now increasing the risk of respiratory depression in a highly compromised patient. This is a person who is really sick, and now you're about to give them a drug that causes respiratory depression. And what's the next decision they make after that? Leave him prone, drowning in his own vomit, unable to protect his airway. You hear Defendant Cooper after he gives that injection to Elijah, who's laying there not moving. What does he say? We'll just give that a minute or two. Just leave him there. And the witnesses?
Just rub it right behind his ear if he fights, all right?
We'll give that a minute or two, see if that works, and once it is, we'll go ahead, if you guys are okay with it, we'll uncuff him, we'll go up with the right arm, down with the left, and we'll straighten everything. We'll give that a minute or two.
All right.
And the witnesses who were right there that night, they all confirm Elijah was left there prone, face down, unable to protect his airway after he got that injection, unable to clear the vomit from his lungs, unable to get the oxygen that he needed. Lisa Gonzalez confirmed the same thing. Did you see Mr. Cooper or Mr. Cichuniec approach the patient and address the fact that he was prone on the grass? No. All of this in direct contradiction of their training. They know not to leave people prone when they're sedated. And what was the risk of that? The risk of leaving him in that position? Can't protect his airway, can't get oxygen, can't clear his lungs. And what do they decide to do next? To ignore Elijah while he's dying. At this point, there is still a chance to save Elijah, but time is running out fast. You can hear how people, various witnesses, described how he looked at that time. Dr. Sina said, I'd call it agonal breathing, kind of breathing you do right before you die. Dr. Mitchell said, we know he is at risk of dying at this point. Dr. Buther said, we see him not breathing well at all and completely unresponsive. Elisa Gonzalez answered, was the patient doing anything, any movement? No. And even Dr. Sundaram said he goes flaccid completely. Where are the defendants? They aren't even paying attention. And that vomit is pouring out of Elijah's face. They're off, not even looking. And then he takes those two terrible breaths. And where are the defendants? Oh, there's Mr. Cooper. And there's Mr. Cichuniec typing on his tablet, completely ignoring their patient, And once again, the defendants knew these risks. They knew the risk of respiratory depression. They knew the risk of keeping him prone. And even in non-sedated patients, they are told if you have somebody in restraints, it is mandatory that you are continuously monitoring their airway, breathing, and circulation. They didn't do it. 6 minutes goes by from the time they give that ketamine injection until the first time anyone tries to take Elijah's pulse, when it is absent. What are the defendant's excuses for this? Well, the protocol doesn't say we have to start monitoring right away. But this protocol that they were operating under assumes that you've just given ketamine to someone who has been out of control, not someone who already wasn't moving. And you heard Dr. Hill the other day. What did he say? He said, you should start monitoring as soon as you reasonably can. They didn't even have the equipment there. They left it all in the truck, and they weren't even looking at their patient to monitor him. They had a chance here to try to remedy all of the bad decisions that they had made up to that point, all of the risks that they had ignored. And instead, they just stroll down to the ambulance while Elijah dies. What were the risks of that? When somebody's gone into respiratory arrest, they are losing oxygen to their brain every second. Every second counts. Dr. Buther told you it could be a matter of just a minute or two and a heart can stop. And that's what happened to Elijah. These are the decisions that the defendants made. These are the risks that they chose to put on Elijah McClain. I'm going to talk to you now about how all of that conduct relates to the jury instructions that you just received and the crimes that have been charged. The first crime that is charged is reckless manslaughter. And what that means is that the defendants recklessly caused the death of Elijah McClain. And recklessly means that there is a conscious disregard, the defendants consciously disregard a substantial and unjustifiable risk. You have seen this chart of all of the disregard they have made of all of these risks. Decision after decision after decision. And they knew the risks of every single one of those. Were those risks substantial? They were life-threatening. Of course they were substantial. Were those risks unjustified? Entirely. There was not one reason that the defendants needed to make any one of these terrible decisions. There was no justification not to assess Mr. McClain. There was no justification to give someone who is not moving a sedative. There is no justification to ignore a lifeless patient for 6 minutes before you try to take his pulse. The defendant's recklessness is proved here beyond a reasonable doubt. You're going to also hear about the crime of criminally negligent homicide. If you don't think that their recklessness has risen to the level for reckless manslaughter, then you can consider this charge. And it's simply a lower level of a mental state. It says that there has been a gross deviation from the standard of care that a reasonable person would exercise. He fails to perceive a substantial and unjustifiable risk. Again, the defendants consciously disregarded these substantial and unjustifiable risks. They certainly also met this criteria for criminally negligent homicide. We also have to show that the defendant's actions caused the death of Elijah McClain. And importantly here, a cause does not have to be the only cause or the last cause or the nearest cause. It just has to be a cause. This is another situation where you can bring your common sense. You've seen the video. You've seen Elijah laying there, laboring to breathe. He gets the ketamine, and within minutes, he is going into respiratory and cardiac arrest and dies. But we've also given you lots of experts to explain how this happened. You'll remember from the beginning of the trial when we talked about the things that were happening. Elijah was in respiratory distress. He got the ketamine overdose. He was abandoned in that prone position. And all of those things led together to his respiratory arrest and his cardiac arrest. You heard from 4 different experts, all who confirmed that ketamine was the cause of Elijah's death. Dr. Sina, the independent pathologist who happened to do Elijah's autopsy, what was his conclusion? Complications of ketamine administration. You heard from Damon Robinson, an anesthesiologist, David Buther, a pulmonary and critical care doctor, and Roger Mitchell, another forensic pathologist, who all confirmed it was the ketamine that killed Elijah. Dr. Buther testified that it was the respiratory arrest caused by the ketamine that led to Elijah's death. And Dr. Robinson, same thing. Is it predictable based on the high dose of ketamine that he received from the paramedics that he would suffer these injuries? Yes. And in addition to these 4 experts, several others all also concluded that Elijah's heart had nothing to do with his death. Dr. Moss, his treating physician at the hospital, didn't think that his heart had anything to do with his death. And even the defense expert, Dr. Dragovich, he didn't think that the heart had anything to do with his death. His opinion was that Elijah died because of the aspiration. All of them agree his heart was not involved in his death. Now, you heard from one expert, Dr. Sundaram, who came in and he didn't say the heart caused his death, but he said it might have had a role. And Dr. Sundaram talked about the theory of Occam's razor. This is the theory that the simplest explanation is usually the right one. And ironically, Dr. Sundaram seemed to think that his theory was the simplest one when it involved the notion that Elijah had died of a very rare coronary condition for which there was no actual evidence and no physical findings and no test that could reveal it. That he had had this incredibly rare coronary event right after the police had attacked him. Well, what's the other explanation for what happened here? Well, Elijah was put into a carotid hold by the police. He threw up into his mask. We know that because we have the mask. His lungs were full of vomit. We know that too because we know it from the autopsy. You watch him steadily decline after that happens, and then he's given an overdose of a drug that's known to cause respiratory depression, and within minutes, he goes into respiratory and cardiac arrest. Which of these explanations is the simplest? Dr. Sundaram had a number of problems with his opinion, but at a basic level, it just doesn't make any common sense. And no one else agreed with him. You have an instruction, many instructions in your packet about complicity. This simply means that you can be responsible if you don't do every part of the crime. You can be responsible as the principal who does the crime, or as a complicitor. Complicitor is just somebody who aids, abets, or encourages the crime. The defendants here, they both did all of these things together. You heard them say, you heard their experts say, they were acting as a team. They both decided to give the ketamine. They both decided to give 500. They both stood there while Elijah got worse and worse and did nothing. They are both responsible. The defendants are also charged with assault with intent to cause bodily injury, causing serious bodily injury. Now, here's what a bodily injury simply means, or a number of things, but impairment of mental condition. And here, of course, the defendants intended to impair Elijah's mental condition. That's the whole reason why they said they gave him the ketamine, was to sedate him. And it's important to understand, it doesn't mean that they have to intend to impair his mental condition for the purpose of hurting him. It just means that they had to intend to impair his mental condition. And did they cause serious bodily injury? Yes. They caused respiratory arrest, cardiac arrest, and death, which is serious bodily injury. Defendants are also charged with unlawful administration of drugs. Now, this contains a number of different elements. Requires that you find that the defendant intentionally, for a purpose other than lawful medical treatment, caused physical or mental impairment to Elijah McClain by administering a drug capable of producing the intended harm without consent. Okay. Did the defendants intentionally give ketamine? Yes. Did it cause mental impairment and physical impairment to Elijah? Yes. Was ketamine capable of producing that harm? Yes. So now let's talk about the two elements that I skipped over there. Was it for a purpose other than lawful medical, was it for a purpose other than lawful medical treatment? It was. Lawful medical treatment has to be a bona fide medical purpose. Here, the defendants were not operating under their protocols. There was no indication that Elijah needed ketamine, and you've heard multiple experts say that giving it was for no medical purpose. This was not for a lawful medical treatment. And then finally, we have to show that it was done without consent. Defendants here never did one thing to try to obtain Elijah McClain's consent to any treatment, and no reasonable person would consent to an overdose of a drug that they did not need. Finally, you'll see the defense of special relationship. This requires that three different things be true. That the defendant has to be a duly licensed paramedic acting under the direction of a licensed physician who used reasonable and appropriate physical force to promote the physical, which he reasonably believed would promote the physical or mental health of the patient. And that he reasonably believed that no one competent consent could be consented, and that a reasonable person wishing to safeguard the welfare of the patient would consent. All three of these things have to be true in order for the defendants to invoke this defense. None of them are true. Every single element of this is not disproven beyond a reasonable doubt. First, they were not acting under their protocols, so they were not acting under the direction of a duly licensed physician. Second, they did not use reasonable and appropriate force, and they did not reasonably believe that this would promote the physical or mental health of Elijah McClain. And finally, there was no emergency here, and there was no basis to reasonably believe that anyone would consent to an overdose of a drug they did not need. The defendants have now had a chance to tell their story twice. Once in their police interviews just a few weeks after this happened, and once to all of you just a few days ago. And in all of the things they said, they didn't say one single word that reflected any remorse for what happened to Elijah McClain. Not one. And in all of the things that they said, they didn't take any accountability for any single one of their actions. They didn't admit that there was any single thing that they did wrong on August 24th, 2019. They didn't admit that there was anything that they could have done better. They expressed zero accountability and zero remorse for their reckless and callous decisions, the decisions that killed Elijah McClain, their patient.
All right, folks on the jury, I think we're gonna take our break at this time. Again, you've received the evidence and the instructions and part of a closing argument, but it's not time to start deliberating. Don't form or express any opinions yet. Do no independent research, avoid any press coverage, let the court know if anybody tries to speak with you about the case. hopefully we can have you back up here in 15 minutes or so. Okay, the chairs have stepped out. Just a logistical matter I'd like to speak with about up here, please. Of 3738. bringing the jurors up. Anything that you need to address?
No, you're on. No, sir, thank you.
Okay, thank you. Jurors entering. Right, our jurors have returned. Please be seated. Court will call up 21 CR 2800 and 21 CR 2806. The parties and counsel are present. Closing argument for the defense.
Good afternoon, members of the jury. Prosecution would have you believe that this is a simple case, simple, straightforward case. It's not. They would have you believe that Mr. Cooper and Mr. Cichuniec planned to kill Elijah McClain. There's absolutely no evidence to support that. None. This is a very complex, complicated case in which a number of witnesses, a number of expert witnesses have been called on both sides. There have been differences and disagreements expressed between these experts, and you all as the jury are going to have to pick through those. But there are three things that the evidence in this case has surely proven. First, that Elijah McClain should still be with us. That his death is and was a tragedy. The second is that in August of 2019, there were a lot of systemic problems with both law enforcement, the practice of medicine, the practice of paramedic medicine that needed to be fixed. Third thing, that things are not always as they appear. This starts with Elijah McClain walking down the street, doing his own thing, maybe waving his arms, maybe listening to his music, listening to his headphones. He's wearing a jacket. He's wearing a ski mask. So what? So what? Maybe he's cold. Like his friend Marty said, he often got cold. Whatever the reason, a second young man calls the police. And this second young man reports that Elijah McClain is acting sketchy. And from that, both the systemic problems start showing themselves and the fact that things are not always what they appear start showing themselves. Elijah McClain's not doing anything sketchy. He's going to a convenience store to buy some things to drink. And then he's going to walk down the street and go home. Things aren't always as they appear, not as they appear to a 911 caller. The dispatcher follows her protocol, and she asks a set list of questions. She does, and she gets to the end of that. She dispatches police to the area of Evergreen and Billings on nothing more than somebody saying somebody else looked sketchy. We now have police involved. That's a systemic problem. Police arrive. Elijah McClain is ordered, stop. He doesn't. So what? Does he have to stop? He's not doing anything wrong. He shouldn't have to stop, should he?
Objection, relevance,
I'll allow some leeway for closing argument, but we need to stick to the script.
But when he doesn't stop, when he doesn't do what the police tell him to, he immediately gets put in the category of non-compliant. Non-compliant with police orders. And the whole reason for why he didn't stop is completely lost. That's a problem. And that part of what the police later tell fire is actually true. Elijah McClain did not comply with their order to stop. It's an example of a way overly subjective term being used in protocols, in training, that leaves people to guess at what it means. What does it mean to be non-compliant? You saw a video during one of the trainings. Gentleman who busts through a fence while police are trying to take him into custody is non-compliant. Technically, Elijah McClain saying, I'm going home, I'm not doing anything wrong, leave me alone, and continuing to walk on his path is non-compliant. The failure to distinguish in a meaningful way between these two situations is a systemic problem for paramedics. Why do I say that? Well, what does a paramedic do? Was Elijah McClain non-compliant? Yes. Was he non-compliant enough to check a box on excited delirium? Who knows? Who knows? How would you know? The witness called by the prosecution, Dr. Mitchell, talked about some issues of systemic problems in medicine. He talked about the opioid crisis. He talked about fixes for things that were a problem with the system, not keeping track of deaths in custody, and wanting to fix that because there were problems with the way medicine was practiced. And there are ways to fix problems, systemic problems.
Objection in court's prior order to all the systemic stuff.
All right, I think the court's order dealt with things that occurred afterwards, so he's not there yet.
The system can be changed. The paramedic system can be changed. System of medicine can be changed. Regulation, legislation, the malpractice case.
Objection, Your Honor. Complying violations of the court's order.
I'm not,
Yeah, I think we need to back off that a little bit, so sustained in part.
you don't do it by criminalizing the conduct of people.
I'll allow it.
Don't do it by criminalizing conduct of people who are attempting to comply with the protocol, with what are basically their marching orders, the rules that they follow. You saw the training that was done in this case. Saw, and I'll go back to it later in my closing argument. Emphasis upon excited delirium. The effect that can have on people. It's a major medical issue and people can die from it. That's what paramedics were taught. Not that ketamine is fatal, but that not giving ketamine if somebody had excited delirium was fatal. That's what they were trained. That's what they were taught. That's what their protocols say. 500 milligrams of ketamine is a bad practice. A large dose of ketamine can increase the risk of respiratory depression. That's what they were specifically taught and trained. Not that ketamine is fatal if you give it. Excited delirium is fatal if you don't give it. Speaking of the police, there's another problem. That's at issue here as well. Along with the word non-compliant, look at some other words. Agitated. No training, there's no definition. When do you become in the category of agitated? Paranoid. Out of control. Danger to self and others. Paramedics with much less training than doctors have are required to go in and make a very rapid judgment. To decide these subjective words and decide immediately if they apply. Because excited delirium, as they were taught, is a major medical problem and people die from it. And the whole reason the waiver regarding ketamine was undertaken is because there had been an uptick in Aurora in 2019. They were seeing more and more cases, as Dr. Hill testified to yesterday. And as it says, and I'll put up there in one of their protocols, you should address aggressively the problem of an agitated patient. Immediately, quickly, because they can die. There is no protocol in effect in August 2019 that tells paramedics, what do you do when police are all over a potential patient? How do you deal with that? See, no training on that. There's no protocol. There was testimony. There was no protocol. And they must walk a line between lots of different things. Don't make the situation worse. First off, do no harm. You're being told there was just a violent altercation between police and Mr. McClain. From what you can see, it seems to still be going. From what you can see, Mr. McClain appears to still be moving. Police are clearly still giving him commands. Stop. We told you to stop. We repeatedly told you to stop while pushing him on the ground, holding him on the ground, slamming him on the ground. This is what, and more than this is what paramedics see. Even before this starts, they get a call. Medical assist to police department. That's it. They park the engine. Where? Not anywhere real super close to Elijah McClain. About a block away. And what do they see as they walk up that's very unusual that was testified to? A great deal of police cars. For a whole block, police cars. So they can't get the engine any closer. They get up to it, and Captain Cichuniec testified to, it's unusual to see that many officers, and that many officers on top of somebody. And that's one of the things that the paramedics are seeing. Mr. Cooper, Mr. Cichuniec are seeing those things as they walk up. As they walk up, Dan DeJesus, and I implore you, watch those body cams. But when you watch them all. Watch all the way through, including in the hospital, when they're trying desperately to save Mr. McClain's life. These people who supposedly planned to kill him. As far as they can tell, from what they hear, from what they see, there has been a violent altercation between the police and Mr. McClain, and it seems like it might still be going on. They have to walk a line. Don't make that situation worse. You have a patient that is agitated, that may be creating, in fact, lactic acidosis through struggling, may have already created that situation in himself, and you can't make it worse. Also, they're told, first priority, make sure of the safety of yourself and your crew. Can't help somebody else if you are hurt yourself. What does that mean? You've got no protocol for accomplishing this. Do you have any question over who was in physical control of that scene? Prosecution wants to tell you, well, the paramedics should have been in charge of it. Mr. Cooper, apparently, when one officer, I used the word body slam. You decide for yourselves watching that video. I stick by what I described it as. It wasn't repositioning to me. Maybe there was some repositioning incidentally involved. It looked like body slam to me. You decide. You're the jury. You're the finders of fact. What is Mr. Cooper supposed to do at that point? Say, hey, get the heck off of my patient. There's a sergeant standing right there. This officer's superior officer is standing right there. Not only doesn't do anything about it, he doesn't say anything about it, he doesn't stop his officer. He later comes to court and describes that as a repositioning, not a body slam. But a paramedic was supposed to somehow intervene in this. You saw Mr. Cooper testify. You saw the kind of man he is. Mr. Slothauer would ask him something, he'd say, I don't remember, I'm sorry. That is not a confrontational individual. He was supposed to be saying, get off my patient, get off of him. That officer. And instead, he says, not once, twice, we can just leave him there. When he says it, watch the video. Both times, Mr. McClain is in the recovery position. He's not in a prone position. He's trying to say, please just leave him there in the recovery position. Away. You're not going to take him out of handcuffs. Wait till I get my tools here. He doesn't have it there. He doesn't have what he's been instructed to get. Even if he never gives ketamine, he needs an ambulance. He needs a stretcher. That's not there. The police are not letting Mr. McClain go to wait for the ambulance. Mr. Cooper comes up and says, do we know if he speaks English? Could he have said, hey, sir, do you speak English? Can I talk to you? Sure. He could have done that. That doesn't make this a crime like they want you to believe. That doesn't make this reckless. That doesn't make this criminally negligent homicide. It doesn't make it second-degree assault. It doesn't make it any crime. When he asks them, after he asks them, within a few seconds, check me, watch the body-worn camera. I believe it's within a few seconds. Elijah McClain says, I can't fix myself. If you have no context of what's going on, if you haven't seen the Shell video, if you haven't seen body-worn cameras of officers interacting with Mr. McClain previously, if you haven't seen the buildup to all of this, which these two gentlemen have not seen, that comment doesn't make a lot of sense. I can't fix it. And you could say, should have asked, what do you mean? Things I would suggest in that regard. One is what happens immediately after Mr. McClain says that. Apparently, the officer takes it in his head, he'll fix him. That's when he repositions. The second thing is, remember the video you saw with Sergeant Leonard trying to speak to Elijah McClain? And he's leaning down. And they offered it to say, well, he wasn't scared of him. But he's got a gun and a taser. Yeah, he's not scared of him. But what does he do? He says, sir, we need to know, what did you take? You're not in any trouble, sir. We need to talk to you. We need to find out. You need to try to help. We've got no answer. No answer. And so the prosecution wants you to believe, well, Mr. Cooper should have gone back and done all this, and that would have borne fruit had he done it. The first time he tried talking, even in the area of Mr. McClain, it resulted in Mr. McClain getting slammed to the ground. And B, there's evidence it wouldn't have borne fruit in any event because it didn't earlier. Another person tried that tack and it didn't work. There's another thing that's not covered in any protocols. How do you estimate somebody's weight? How do you do it? You have to, they believe, because of what they've been trained, that they see signs or symptoms of excited delirium, and what they have to do is give Mr. McClain ketamine. What they've been trained. And it's dose-based, so they have to come up with a weight Mr. Cooper said, I tried to compare him to myself. And I tried to take off about 50, 60 pounds. They're trying to make a judgment, not only just trying to estimate somebody's weight without any instruction on how to do it, but somebody on the ground in the dark. They do have flashlights. They have the laptop with the light, the shining lights on it. And the body cams have the effect of making this look bright as day, which is not the case. It's relatively dark. You're in a grassy area. Mr. McClain is on the ground, not standing up, which makes it somewhat easier to guess somebody's weight, wearing a jacket, with officers on top of him, and moving. Whoever's moving, cops are moving Mr. McClain's moving, and the officers are holding him down. It's movement going on. And they're trying to estimate a weight. They got trained. You heard about this on the 300, 400, 500. And we heard, well, that's just a starting point. Well, that's just a guideline. Well, where's the rest of it? That's a starting point. Where's the rest of the training on how somebody is supposed to gauge another human being's weight? Dr. Hill said, well, under oath on the stand, that was a miss. Yeah, that's a huge miss. Because you're asking people to administer a drug without an ability to figure out how much somebody weighs. Could you ask other officers? They're not trying to assess Mr. McClain's weight. You could ask him. Again, with that born fruit, he's been asked other questions to no result. What they're told is, you've got to come up with a way to give ketamine or this person could die. Guess wrong, they're going to charge you with a crime, contributing to somebody's death. Things are not always as they appear. It's really from the appearance. It's from the optics that the prosecution asks you to convict Mr. Cooper and Mr. Cichuniec. Because it makes us sick to watch a video, know how it's going to turn out. The sad, terrible ending to it. We all hindsight at this point. But they didn't. When you watch it and you know that somebody's going to die, it makes you feel like, why don't you do something, anything? Don't just stand there. Causes sadness, and frustration, and anger. And I talked about that in jury selection and told you it would. It does. Dr. Mitchell testifies, this young man needed help and they didn't help him. That's not true, first. It's not part of what these charges require, second. An assessment. Can you do an assessment without putting your hands on somebody else? I think that's been proven beyond a reasonable doubt. You can. Nobody really differed with that proposition. Battalion Chief Robinette assessed Mr. Slotthauer sitting over there. They put on a number of expert witnesses, doctors, including Dr. Buther, who on the stand assessed Elijah McClain's breathing rate from watching a video that was up there. Didn't have his hands on him. He wasn't kneeling down next to him. Wasn't putting his fingers here like this. And he could tell you not only Elijah McClain was breathing, but how quickly or slowly Elijah McClain was breathing. Obviously, you can do the ABCs through a visual assessment. We saw it. We saw it in action. They assessed Mr. McClain and saw that he was breathing, and he appeared to be breathing too fast. Tachypnea, too fast. One of the signs you're supposed to look for with excited delirium. So paramedics who aren't doctors, who don't receive that education or training, put that also in the box with excited delirium thing. Should it go there? Maybe not. Maybe non-compliant never should have gone there either. But it goes there. Tachypnea, diaphoretic, he's sweating fast. Sweating hard, sweating a lot can be a sign of hyperthermia, that you're too hot. So your body's trying to fix that by causing you to sweat profusely. And so things get put in the box that maybe they don't belong in that box. But it is not correct to say they are not doing an assessment. Mr. Cooper testified. He looked injuries, no obvious injuries, no blood. Patient's not bleeding. Patient is breathing. Patient has an airway. Patient has circulation going. He keeps moving. You can't move without circulation. Mr. Cooper, after initially trying to talk to Elijah McClain, decides, and you can see it. When the officer takes Elijah McClain, I refer to as body slams him on the ground. Mr. Cooper is literally taken aback. He backs up a step, and that's when he says for the second time, let's just leave him. You could disagree with his decision to not go up, try to re-engage, but he's done it once. He saw the result. You got to ask yourself, why would you go through that again? The last thing you want is Mr. McClain being in a struggle, being hurt, being slammed to the ground. When Mr. Cooper later tries to tell the police, let's take off the cuffs and get him on the gurney, they overrule that. And no, we're going to put him on the gurney first, and then we'll take our handcuffs. Watch the video. Part of what's time is spent is them getting a handcuff key and getting him out of their custody, police custody. Because Elijah was breathing the entire time, and you heard the evidence, you heard he wasn't, there's no evidence that he went without breathing for 6 minutes. Numerous witnesses testified he was breathing on the stretcher all the way into the ambulance. He stopped breathing in the ambulance. It was approximately a minute that he was without oxygen. Not 3 minutes, not 4 minutes, not 6 minutes. Approximately a minute. That's not good either. I'm not saying that's good. I'm saying there's no evidence he went 6 minutes without breathing. The entire time they're interacting, they're watching him. Mr. Cooper is standing at his head, watching him. He is breathing. There did not appear to be a need to get that equipment out of the engine, bring it up here with all the wires on it. Let's hook it all up to him. You also know that excited delirium can have peaks and valleys. People can bottom out, then all of a sudden they're up again. They don't know if that's going to happen or not. When they're training, he could get agitated again, start flailing around, start fighting again. And it's easy to say, well, you should have known better, with the benefit of hindsight. If you're that person right there, you've got to decide right away. Tried interacting with him once, got everybody agitated, he got hurt. I don't want to do that again. And I don't know how this person is going to react. If I start trying to hook wires up to him and he starts thrashing around again, what's that going to do? Wrap wires around his neck or somebody else that's trying to restrain him? I don't know how that's going to play out. And there doesn't seem to be a need for it. So they don't do it. The equipment would bring more risk and less calm to the scene. And so they continue to assess him. And he asked Lieutenant Cichuniec, call for the ambulance, ask them for soft restraints and narcs is what he said. And then they discussed ketamine and agree on ketamine. Things aren't always as they appear. Elijah McClain keeps struggling and fighting with police. If you have the benefit of body cam and you get to see where he went from to where he ended up, yeah, you're like, wow, that looks a lot different. Then you come in at 2/3 of it and you go, wow, I've got all these reports, what's been going on, and he seems to still be moving around. As Dr. Dragovich used the term, he believed he was thrashing, still moving and seemingly breathing. And that's what Cooper sees. That's what Mr. Cooper sees. All of the things, diaphoretic, breathing very fast. He does order the ketamine, and then almost immediately after, he's told confirmatory information. Oh, he showed super strength. He did a push-up with 3 of us on his back. Is that before he orders up ketamine? No. But it is true, you could back out of a protocol. He gets confirmatory information. This is what else he was demonstrating. Things that go in the excited delirium box. Hearing the police say, stop. We've repeatedly told you to stop. Firms he keeps struggling against them. Goes in that box. Mr. Cooper told you that Elijah McClain appeared to be staring off into space. He thought he might be hallucinating. That's one of the things on hallucinating. How do you document that? It's one of the things you look for with excited delirium. And it's, again, one of those subjective things that you're not given any explanation or training on. How do you determine that? Things are not always what they appear. That Elijah McClain had excited delirium. If you watch from start to finish, if they had been able to watch from start to finish, would they have still concluded that? Maybe not. Maybe not. But they did not have the benefit of doing that. And the question is, was it reasonable, given the things they saw and were told, for them to believe that's the protocol they were under? They weren't told that he said things almost immediately to police like, I'm an introvert. Why are you grabbing me? My name is Elijah McClain. Maybe most importantly, I can't breathe. He didn't get told that he had said that. Sergeant Leonard testified he wasn't even told that he said that by his own officers. So Sergeant Leonard was deprived of information as well. And what did he testify to? He thought Elijah McClain had excited delirium, and he's been trained on it. He got imperfect information too. And they've had it drilled into them. If it's excited delirium, you got to move quickly. The clock is ticking. So with inaccurate, incomplete information, with the sense of danger that maybe wasn't warranted, in an unlit grassy area, they're called upon to decide. Not after watching body-worn cameras for 50 hours, not after going back and forth and slowing down and listening to audio, not after consulting a pulmonologist or a pathologist. They've got to make the decision right there and then. Prosecution has not proven a number of critical things beyond a reasonable doubt. Well, would you put that up there? First one.
Court goes up, objects to items not evidence.
Using this for demonstrative purposes, Your Honor.
If it hasn't been admitted, we can't display it at this time.
Okay. In his initial autopsy report, Dr. Cena refers to violence of duel and a narrowed left descending artery. An LAD, left anterior descending coronary artery. That's what Dr. Cena refers to. Who else refers to that? Dr. Sundaram refers to that. Dr. Sundaram says there was a violent struggle. I believe Mr. McClain had a cardiac spasm as a result of that struggle. And because of his narrow left anterior descending coronary artery, that caused him to go into ventricular tachycardia, ventricular fibrillation, and asystole, which is your heart stops. And those are the things that Dr. Cena was concerned with. Before Dr. Cena issued his first autopsy report, as he testified, he got threats after doing that. He was visited by another prominent pathologist from out of state who came to him personally. And shortly thereafter, Dr. Cena revised his opinion. And mysteriously, it was a lot more like Dr. Mitchell's. Although there's still a huge difference. Dr. Cena testified that this is in therapeutic range. The amount of ketamine actually in Elijah McClain's system was in the therapeutic range. He said, gestured at the jury box, it wouldn't have killed any of you. Says it was an idiosyncratic reaction to the drug, which by definition cannot be predicted. Dr. Mitchell testified that Elijah McClain had aspiration, acidosis, hypoxia. He doesn't know if he would have survived the struggle with police. Like Dr. Sundaram, Dr. Mitchell opines that Elijah McClain was basically passing away before he ever got ketamine. That goes directly to the cause of death, which they must prove. That these medics caused Mr. McClain's death. Dr. Moss said it was a stunned myocardium. Dr. Dragovich said he thought it was aspiration. He couldn't comment on the heart because he hadn't seen the echocardiogram or electrocardiograms done on Mr. McClain. But he said it was not ketamine because of Mr. McClain's lungs and because that the blood concentration was in the therapeutic range. Dr. Robinson says this was aspiration exacerbated by ketamine. But it's not an idiosyncratic reaction, so he disagrees with Dr. Cena. And he is the only doctor who says that this blood concentration was not in a therapeutic range. Dr. Hurd testified and said, this amount is in the therapeutic range and it would not be expected to cause anybody's death. He was the only medical toxicologist who testified and the only toxicologist who ventured an opinion on that specific thing, including the state's own witness, Mr. Lamb. Nobody testified. There was no evidence that anybody has ever died from a single dose of 500 milligrams of ketamine or from a concentration in your blood of 1.4 milligrams per liter of blood. Ever. Now, these experts are all well educated, smart, talented, well compensated, some more than others. And they are all professionals, every one of them, and they are all over the place on cause of death. That is the definition of a reasonable doubt. Based on that, how do you know? You don't know that ketamine caused Elijah McClain's death because they have not proven that beyond a reasonable doubt. What I just talked about, Dr. Hill says a large dose is not 500 milligrams of ketamine. It's 10 to 100 times that. They have not proven beyond a reasonable doubt that either paramedic engaged in conduct that was reckless, that was criminally negligent homicide. 9 paramedics or former paramedics testified in this trial. Nobody said that deciding this was excited delirium, or the decision to give ketamine, the amount of ketamine given was outside the standard of care. Nobody. Dr. Eric Hill, Robin McKinley, Pete Cichuniec, Daniel De Jesus, Alicia Gonzalez, Jeremy Cooper, Ryan Walker, Gary Ludwig, Travis Chambers, all testified. No evidence. It was outside the standard of care. Look again at the protocols. Look at the boxes. And what do they require? Patient is agitated and a danger to self and others. As I said, how do you determine that? And that's your starting point. Assume the patient has a medical cause of agitation and treat reversible causes. They did. Excited delirium is a medical cause of agitation, and they tried to treat that as they'd been instructed to, which is give ketamine and transport as fast as you can to the hospital. Once you give ketamine, you must complete the restraint protocol first, then reassess the ABCs post-sedation and move on to your other things you need to do, including hook up the equipment as the protocol was admitted as People Exhibit 225. Excited, once sedated, patient must be placed on cardiac monitor, capnography, and pulse oximetry during transport, which is transport in the hospital, in the ambulance to the hospital. They were following their protocols. Regarding the defense, Dr. Hill testified regarding decision-making capacity and what the protocols say there. He testified if somebody has excited delirium, they are presumed to not have decision-making capacity. And from what the medics saw in the interactions, Mr. McClain wasn't saying things to people, and did not appear to have decision-making capacity. We teach them, said Dr. Hill, the medical director, to treat someone with excited delirium under medical implied consent, which is a medical term meaning if this person was rational, they would want to be treated. Under the defense, instruction number 12 and instruction number 26, Mr. Cooper was a duly licensed paramedic. He was under the direction of Dr. Hill, a duly licensed physician.
5 minutes.
Thank you. He used a reasonable and appropriate physical force, giving a shot of ketamine for a recognized form of treatment. Ketamine is that he reasonably believed to be adapted to promoting the physical or mental health of the patient, which he had been taught for excited delirium. And it was administered when the duly licensed paramedic was acting under the direction of a duly licensed physician who testified on the stand. That's what he taught his paramedics. That you can proceed under the medical idea of implied consent. And that's what they did. Doing that means they were not, by definition, reckless or criminally negligent, as instruction number 12 tells you. And doing that under instruction number 26 means they are not guilty of second-degree assault, as the instruction also tells you. The protocol does not indicate a preference for the engine equipment or the ambulance's equipment. It doesn't tell them what specifically to bring to any scene. Protocols are so vague, yet they're having to make the call. There is no evidence that either one of these defendants, either Mr. Cooper or Mr. Cichuniec, intended to hurt Elijah McClain. And that's what's required for second-degree assault. Intended to hurt, intended to do it for a non-medical purpose. They were following their training. They were following their protocols. They were instructed about the wide margin of safety. Ketamine is safe, excited delirium is dangerous. That's what it comes down to, that they were trained on. This case relies on your anger and your sadness and trauma watching that video over and over. And I ask you to remember the promises you made in the jury selection, to keep an open mind, to consider all of the evidence in the case, to consider the subtle and the nuanced options, and not just blatant and obvious things, to weigh the evidence in the light of the legal instructions Judge Warner has given you, particularly in light of the presumption of innocence and the burden of proof, and to fairly analyze in your own mind, after discussing this with your fellow jurors, whether you have any reasonable doubts about the guilt of Mr. Cooper. These charges have not been proven beyond reason. Time draws near for you to weigh in on them. Jeremy Cooper is not guilty. We implore you, do not make this tragedy worse by wrongly convicting. We implore you to find him not guilty of all charges.
On behalf of Mr. Cichuniec.
Ladies and gentlemen, attention, patience. This case, very, very important case. Case that is not only important to Mr. Cichuniec, Mr. Cooper, case that is important to Elijah McClain's family, case that is important to justice. And your job here is to decide what justice is. Justice is a case. And you've been provided a lot of testimony, a lot of evidence, and now you've just today been instructed on the law to help you make that decision. And I'm going to walk through some of the evidence and highlight some of that for your consideration as you deliberate on these very important questions. And I say very important questions because they are very important. And those verdict forms that the judge read to you are essentially questions to you. But those aren't the only questions that have been posed in this case. And I would submit to you that the prosecution, for the vast majority of this case, to the vast majority of the evidence that they've provided you, have attempted to answer the wrong question and have answered the right questions wrong. The relevant question here is not whether Elijah McClain was suffering from excited delirium. Rather, the relevant question is whether it was reasonable for these two gentlemen believed that he was suffering from excited delirium, that he was acting consistent with what their training and their protocol told them was excited delirium. As you heard from Dr. Hill, they're not doctors. They don't diagnose. They assess. They assess, stabilize, they transport. And they do that in compliance with their protocols. And that is exactly what we did. So let's look to see what they knew. Because ultimately, in order to make the decision about whether or not their judgment was reasonable about whether or not Mr. McClain could have been suffering from the symptoms of excited delirium, is we have to evaluate what did they know. Not by the whole body of evidence that we all know now. Not with the benefit of hindsight. But what did they know in that instance? That instant when they were making those critical decisions for their patient. Try and treat him to save his life. What did they know? Got 3 remotes up here, so I got to figure out which one works. Found it. First of all, what do they know? They knew from the police that the police were struggling with Mr. McClain. And they knew from the CAD notes and when they got on scene that it was a prolonged struggle. It wasn't a short struggle. They knew that the police believed Mr. McClain to be on something, as they were told that when they arrived on scene. They also knew that Mr. McClain was not answering questions by the police, as that information was provided while they were on scene. They could observe that Mr. McClain was breathing fast, that he was sweating profusely. And they were told during the call, once they had, based upon that initial information, made the assessment, hey, this sounds like this could be excited delirium. It's meeting our protocol. It's meeting the signs and symptoms that we've been trained to look for. Then they're told by police that Mr. McClain is demonstrating incredible strength, crazy strength. He almost did a push-up with 3 of us on him. That's what they know. And you've seen the protocol, and you've heard the testimony about the protocol. That information fits squarely within the signs and symptoms of excited delirium. But they're not the only ones. Think about the other evidence you have. The testimony from Dale Leonard, who is also a witness in this case and very similarly situated to Mr. Cooper and Mr. Cichuniec. Because Dale Leonard arrived on scene after the initial incident, after the initial struggle with Mr. McClain by the police. And he too is briefed by his officers about what occurred. He too has the opportunity to observe Mr. McClain breathing heavily, sweating profusely, grunting, hearing the officers say repeatedly, "Stop resisting, stop fighting us." He even takes it upon himself at one point to assist in restraining Mr. McClain by stepping and placing his foot with pressure on it on Mr. McClain's ankles. Now, he's trained through the police department to recognize the signs and symptoms of excited delirium. And he sat on that stand and he told you that he believed and was convinced, based on what he was told and what he was seeing, that Elijah McClain had excited delirium. That is why he was so concerned. Once the ambulance finally got there, you hear him say, What's taking so long? What's taking so long to get that sedative so we can get this young man on the gurney in the ambulance to the hospital? I submit to you, based on the evidence that you've seen, based on the information that these gentlemen have, in the short amount of time that they had to process it, that it was entirely reasonable for them to believe that Mr. McClain was suffering from excitement. And so they chose that protocol, and they went down that protocol. And you have that protocol in evidence. And you can read for yourself. The protocol says give heparin. Then you wait for it to take effect. Then you complete the restraint protocol, which is moving the patient to a gurney, applying soft restraints. You reassess the ABCs. You put them in the ambulance and you connect them, the monitoring, the heart monitor and the monitoring equipment, and you get that person to the hospital, because the protocol tells you that rapid sedation, the protocol uses the word tranquilization, but rapid sedation is required to treat that condition. I want you to consider the timeline of events here, and that timeline is very important. Because unlike what the prosecution wants to suggest, the ability of Mr. Cooper and Mr. Cichuniec to fully take control of Mr. McClain and undergo his treatment for suspected excited delirium is frustrated by a number of things that are out of their control. So at 10:32 p.m., you have the 911 call that is placed by Mr. Vega to police dispatch. At 10:43 p.m., officers Woodyard, Rosenblatt, and Redema confront, stop, and detain through physical means Mr. McClain. And the struggle ensues. At 10:46, after 2 carotid holds have been attempted, one apparently successfully, the police ask for fire to be started, and fire is dispatched. About a minute later, the ambulance is dispatched. And you heard testimony that in Aurora, you have the Aurora Fire Rescue, the fire department, and then they have a separate organization that they contract with, Falk Rocky Mountain, who provides ambulance services and transport. And they have their own dispatchers, and they're dispatched separately. But they're dispatched within a minute of each other. Unfortunately, AFR arrives first without the ambulance, out of no control of their own. And they arrive at 10:50. And they come up on scene, and as you heard and you know the evidence, because of the heavy police activity, they aren't able to park as close as they normally would or what they would like to. So they walk it in. About a block and a half was the estimate. And they come to this scene. And what they see is Mr. McClain on the ground being held down by not one, and not two, but 3 officers. And they repeatedly hear commands being given by those officers. Stop fighting. Stop resisting us. You've been told multiple times. At that point in time, they don't have access to their patient. It appears to them reasonably that the Aurora Police Department is still actively struggling with their patient. And then they wait. They make that assessment based upon the information they need. That reasonable assessment that this looks like excited. They're powerless to do anything about it with respect to the excited. They don't have the drug that their protocol calls for to treat that. They don't have the ketamine. It's not there yet. And even if they did have it, they don't have a gurney or the soft restraints or the ambulance to transport it. So they're left with several bad options. And what they do is what they're trained to do. They visually assess the patient. And you watch those cameras. Once AFR is on scene, there is always someone, 2 someones, 3 someones, and oftentimes 4 someones watching and observing Mr. Mahoney. Make sure that he's still breathing, which he was the entire time. That his airway is not obstructed, which it wasn't the entire time. And that he is demonstrating that he is consistent with having circulation. He's moving. He's not talking and making sense, but he's grunting, he's making sounds. They're constantly assessing and checking those ABCs. Until 10:56, 6 excruciating minutes. 6 anxious minutes for that. 6 excruciating for Mr. McClain, who was still being manhandled and restrained by not 1, not 2, 3 officers. The ketamine arrives, the ambulance arrives. Lieutenant Cichuniec goes to get the gurney, prepares the gurney, brings it to the patient's side, tells paramedic Walker, based upon his conversation with his colleague, paramedic Cooper, they need 500 milligrams ketamine. So paramedic Walker can draw that up, and he brings it to paramedic Cooper about 3.5 minutes after the ambulance gets there. They finally have the drug that their protocol tells them they need to administer to their patient. And paramedic Cooper administers that drug pursuant to his protocol so that he can hopefully end this struggle that is going on, get the police off of his patient, get his patient onto the gurney, restrain for his safety and theirs, in the back of the ambulance and to the hospital. So they wait a short period of time for the ketamine to take effect, but he's still handcuffed. He's still not completely theirs. The cuffs come off. He's moved to the gurney, and the cuffs come off at 11:02. And finally, they have full control of their patient. And you watch those videos, you watch what they do as soon as they do. They're up, Cooper's calling for monitoring, he's calling for suction, he's calling for CO2 monitoring and tidal, and they're off to the ambulance. They're not strolling, they're out for a Sunday walk, like the prosecution would like. They're moving as efficiently and as quickly as they can to get the patient into the bus and to the hospital. They are in the ambulance 20 seconds after the handcuffs come off. Kind of on the video. Handcuffs are off, he's in the restraints, they sit him up, and they're off. And they're at the back of that ambulance 20 seconds later. But all that time, between 10:43 and 11:02, Mr. McClain is in the custody and control of law enforcement, not paramedics. Now, you've heard lots of testimony and argument today about assessments. And the prosecution has been incredibly critical of the assessment that was performed by AFR on scene. Not only the assessment of paramedic Cooper and paramedic Cichuniec, but also that of DeJesus and Bradley. They seem to not want to acknowledge, despite all the testimony from the witness stand, Robin McKinley, Gary Ludwig, Dr. Hill, and others, DeJesus, Bradley, that a visual assessment by paramedics, visually assessing ABCs, is appropriate. It's within the standard of care. But don't take their word for it. Take your own eyes for it. Believe your own eyes what you saw. Battalion Chief Robinette from the stand, assessing Mr. Slothauer, his ABCs. He wasn't standing, he was just sitting there. You can see he's breathing, his airway's clear. Appears to have circulation. You saw Dr. Buther do the same thing from that witness stand. Even more amazingly, he's watching a video through plexiglass. And he managed to calculate the heart rate, the breathing rate, the respiratory rate of Elijah McClain from a grainy body-worn camera at various angles. From the stand, using body-worn camera, he's able to assess and render an opinion about Mr. McClain's aspiration and when he's aspirating. He's able to view the shell video and render an opinion that Mr. McClain, who was wearing a mask at the time, is breathing normally. Never speaks to Elijah McClain, never asks his name, never puts his hand on him, and makes 3 medical diagnoses. But they want you to believe that that somehow deviates from the standard of care. We're not done. How about Dr. Robinson? Dr. Robinson from that stand, he opined at various times in the video that Mr. McClain was suffering from hypoxia, and that hypoxia moved to lactic acidosis. All from a visual assessment of a body-worn camera video. Now, they also had the benefit of 20/20 hindsight. They had the benefit of knowing what a horrific and tragic outcome this was for Mr. McClain. Information these gentlemen have, information they desperately wish they They didn't. We're still not done with visual assessments offered by the prosecution's experts. Dr. Mitchell. Dr. Mitchell sat on that stand, and from watching the body-worn camera, he testified and diagnosed not once, not one, but 2 aspiration episodes that Mr. McClain suffered. He diagnosed at that point in time, of course, with the benefit of hindsight, that Mr. McClain was going through a slow decline, that he was likely suffering from metabolic acidosis, that he had hypoxia. 5 medical diagnoses from Dr. Mitchell from a visual assessment of a body-worn camera. They want you to believe that deviates from the standard of care, that somehow was lazy work by paramedics Cooper and Cichuniec. Ladies and gentlemen, these 2 gentlemen didn't have access to body-worn. They certainly didn't have 50 hours to pour over it, fast forward, pause, slow it down, rewind, zoom it in. They made their decisions in real time based upon what they could see and what information they had. There's a couple of, well, I want to address kind of this 6-minute argument, show you and contradict that. So another timeline for you for your consideration. Ketamine is administered at 10:59:22 based upon the body-worn camera footage, okay? At 11:01:03, paramedic Cooper says, let's get him on his side, let's take the handcuffs off, and let's get him on his gurney. He, of course, is overruled by Officer Rodimo of the Aurora Police, says, no, let's get him to the gurney first, then we'll take our handcuffs off. At 11:01:13, Mr. McClain is on the gurney. At 11:01:40, the handcuffs are removed. And at 11:02:16, they're off to the ambulance. At 11:02:32, they're at the ambulance. And at 11:04:35, Lieutenant Cichuniec advises over the radio that Mr. McClain has court. That is approximately 5 minutes from administration of ketamine to announcing the core. The core gets announced, you've heard the testimony, after Mr. McClain has stopped breathing, after they've intubated him, and after they've applied oxygen with the bag valve mask, the BVM. This notion that he went 6 minutes, was neglected for 6 minutes, or went without oxygen for 6 minutes, you know is not true. Paramedic Walker told you he's breathing all the way to the ambulance. EMT Gonzalez told you he's breathing in the ambulance. It's not until about a minute after he's in the ambulance that he stops breathing. And then the CPR protocol and the life-saving measures are instituted and initiated. Measures that Dr. Buther, the state's expert, tells you were remarkable. The life-saving efforts were remarkable. The placement of the intubation tube was impressive. Does that sound like paramedics who didn't care, who were callous, who were inconvenienced. This is the video at the hospital of those same paramedics and EMTs trying to save Mr. McClain's life, trying to get his pulse back, his breathing back, his heart rate back, all the way from the ambulance into the hospital, into the trauma room to complete their 2-minute cycle. To characterize these individuals as callous, not caring, as wanting to administer ketamine so they can just get rid of Mr. McClain so he's not their problem anymore, is not only wrong, it's disingenuous. Now, of course, we have Dr. Buther, who testified. This is National Jewish. This is where Dr. Buther works, and he testified about ketamine and his experience with ketamine, all in a hospital setting, not in a pre-hospital field setting. This is Dr. Mitchell's office, where he spent those 50 hours meticulously poring over body-worn camera to come up with his conclusions with the benefit of 20/20 hindsight. Here's Dr. Robinson's office, his pain clinic, where he did the same thing, poring over body-worn camera footage, second-guessing every move. And this is Aurora Fire Station. This is where Jeremy Cooper and Pete Cichuniec work. This is the back of an ambulance. This is their office, where they don't have the benefit of body-worn camera video and the benefit of 20/20 hindsight. This is where they work. Dark, uncontrolled scenes where safety is a priority and life and death decisions are made in split seconds. So what did they know? Well, they knew those things we were talking about. And they knew what was taught to them in paramedic school. As you heard Dr. Hill testify, the 1,600 or 1,700 hours in paramedic school. What didn't they know? Well, they didn't know tragic outcome here. They didn't know what was on the shell video. They didn't know the information and the circumstances of the initial contact by law enforcement in this case. They didn't know about the statements made by Elijah McClain that he was just going home, that he's an introvert, that he's just different. They didn't know that he claimed not to be able to breathe not once, but 7 times before their arrival. They didn't know that Mr. McClain had vomited while wearing his mask, leading to increased concerns for aspiration. They didn't know that a carotid hold, beautiful typo in it, was applied twice. They didn't know that he was believed to have lost consciousness. And they didn't know what all the people's experts knew from that 17,000 to 18,000 hours of medical school and residency to evaluate that scene. And you heard Dr. Hill talk about the standard of care that paramedics have, that's applied to paramedics. It comes from the protocols. And the standard of care is different in a hospital setting where the people's experts work and a field setting, a pre-hospital setting where Mr. Cooper and Mr. Cichuniec work. That the standard of care is different for doctors who have all this training and education and experience to apparently be able to visually assess and diagnose from a witness stand looking at body-worn camera footage compared to the 1,600 or 1,700 hours that a paramedic has. That the standard of care is different for a doctor than it is a paramedic. Yet the prosecution brings you not paramedics to evaluate paramedics. They bring you doctors to evaluate paramedics. You should take that into consideration as you deliberate in this case. I want to talk a little bit about the charges in this case. Manslaughter. The elements are that the defendant in the state of Colorado recklessly caused the death of Elijah McClain. And in your instructions is the definition of reckless or recklessly. A person acts recklessly when he consciously disregards a substantial and unjustifiable risk that a result will occur or that a circumstance exists. Well, what is the substantial risk or result in this case? It's death. So in order to be guilty, they must know of the risk and they must disregard that risk. And that risk must be an unjustified one. Well, what does the evidence tell you? Well, first of all, knowledge of the risk. What is the evidence of their training? Their training is that ketamine is safe. They were never trained that ketamine could be lethal or could kill. That there's a broad safety profile, even in dosing. That you can make mistakes in dosing and it's still safe. That the side effects are rare and that they increase with large doses, but you heard large doses are 10 to 50 times the dose applied here. But even in large doses, they increase, but they're still rare. Repeated testimony about how safe ketamine is in a pre-hospital setting. Safe at those levels. You heard evidence that the actual blood concentration levels in Mr. McClain's blood were therapeutic. Not only were they therapeutic, they were at the low end of the therapeutic level. Nowhere near the toxic levels where you see in the literature fatalities to occur. How could they knowingly disregard an unjustifiable risk if they were never trained the risk was there? Criminally negligent homicide. You also have that element in your instructions. That the defendant in the state of Colorado caused the death of Elijah McClain by conduct amounting to criminal negligence. What does that mean? A person acts with criminal negligence when through a gross deviation of the standard of care that a reasonable person, or in this case a paramedic, would exercise. That he fails to perceive a substantial and unjustifiable risk that a result will occur or that a circumstance exists. So let's talk about gross deviation from standard of care and the standard of care. Well, you know, the evidence tells you the standard of care is developed from the protocols. Okay? You have the protocols in evidence. 0030 protocol, the general guidelines tells you that the protocols define the standard of care for medical professionals in Aurora, Colorado. Okay? In order to prove a gross deviation, or in order to prove this charge, criminally negligent homicide, they have to do more than just prove a deviation from the protocol. They have to prove a gross deviation. It's not a checklist. You did this, and you didn't do this, so therefore it's a gross deviation. No. It's a gross deviation, a blatant or a flagrant deviation. They have to do more than just nitpick at the care provided here and simply put up and assert, well, they could have done better. They could have asked his name. They could have done this. They could have done that. That is not evidence of a gross deviation from the standard of care. I submit to you, they haven't even proven to you what the standard of care is. The defense brought you two standard of care witnesses. Robin McKinley, who is a lieutenant firefighter paramedic from the Memphis Fire Department with over 22 years experience and over 39,000 calls for service. And she told you and explained to you that she reviewed the AFR protocols. And she testified to you that not a single thing they did on that call deviated from the standard of care established in the protocols. Not a single thing. Dr. Hill, who wrote the protocols, explained and went through those protocols about what the intent was of the protocols, what the protocols require, what the standard is, so that you could apply that standard to the conduct and the evidence you have in this case. Prosecution, they didn't bring the standard of care witness or expert. The applicable protocols for the standard of care here are the agitated combative patient protocol and the ketamine medication protocol. Look at those protocols. Look at what these two gentlemen did, and you will see that they acted in compliance and in furtherance of the standard of care in this case. We're not done with criminal negligence, because once we address the standard of care, and I submit to you, if you find that there was not a gross deviation of the standard of care, then these gentlemen are not guilty of criminal negligent homicide. But there's a second part of it, that the individual fails to perceive a substantial and unjustifiable risk. But we just talked about that on the reckless manslaughter charge. Think of their training, harken back to their training and what they were told about ketamine, and whether or not they knew it was an unjustifiable risk to give ketamine, even to make a mistake in the dosage and give ketamine. I want to talk about cause of death. Prosecution also has to prove that ketamine caused the death in this case. And I submit to you that they have not been able to do that. Dr. Sina, the forensic pathologist who conducted the autopsy in this case, in his first opinion that was issued in November of 2019, he documented a left arterial descending artery, that LAD that you heard testimony about, the defect in Mr. McClain's heart, and he listed that as a contributing factor to his death. And intense physical exertion, also as a contributing factor. And the intense physical exertion that he's referring to is that struggle with police, that prolonged struggle and pressure and exhaustive struggle with not one, not two, but 3 officers, that contributed to his death. But he couldn't determine what the actual cause was. So he labeled it undetermined, and he labeled the manner undetermined. And that opinion stood for 18 months. In June 2020, the Attorney General's office reopens the investigation into Mr. McClain's death. In March 27th, 2021, Dr. Sina flies to Colorado, requests a face-to-face meeting with Dr. Sina, and goes to his office and talks to him about this case and Dr. Mitchell's impressions of this case. Dr. Mitchell issues a competing report on June 21st, 2021. Dr. Sina, less than 2 weeks later, issues an amended autopsy report. Now, bear in mind, there is no new medical evidence or information that has come to light in those 18 months. No new toxicology reports have come back. Hey, we messed up the first tox screen. The ketamine levels are actually much, much higher. No new medical evidence. Instead, Dr. Sina claims to have reviewed some additional body-worn camera footage. Now, we know some additional because we know when he issued his first report, he had body-worn camera footage. And in fact, you heard from 2 witnesses that nothing was withheld from Dr. Sina. Detective Ingui, Chief District Attorney Patrick Costigan. No request from Dr. Sina for additional body-worn camera footage. If he had, they would have provided it. Neither of them are aware of any information being withheld from Dr. Sina. So what changed? What changed? You heard him testify about the pressure he received, the criticism he received, death threats he received, the personal visit he received from Dr. Mitchell. Dr. Mitchell issues his cause of death in his report as complications following acute ketamine administration during violent subdual and restraint by law enforcement and emergency response personnel.
5 minutes.
Thank you, Your Honor. Dr. Sina's new opinion says complications of ketamine administration following forcible restraint. Sound familiar? Almost identical. No new medical evidence. Dr. Sina says, I was able to watch what amounts to, and you know, what amounts to about 25 seconds of body-worn camera footage of Mr. McClain. And then Dr. Sina reaches the conclusion, well, he doesn't look very good there. I think those radical breaths happened after the ketamine was administered, so it must be a coma. Nobody has proven ketamine weakness. In fact, all the evidence is that ketamine is a low therapeutic range. Correlation is not causation. Sequence, because it happened in that sequence, you all know from your common sense, that's a basic fallacy. Well, this happened after this, so this must have caused it. That's all they got. That's all they have. Cause of death. Where's the evidence? Where is the evidence that this safe drug, given in a therapeutic dose, that no one can ever document has been fatal at those levels? Where is the evidence that that killed Mr. McClain? There's plenty of evidence that metabolic acidosis, that aspiration, that the narrowed lag are all potential causes of death. Now, you heard Dr. Sundrum and you'll have to judge for yourself. But the narrowed lad and his testimony about watching Mr. McClain go from ambulatory to speaking, to making sense, to struggling, to decompensating, to not making sense, is all consistent with ventricular fibrillation, leading to a lethal arrhythmia. A possibility ignored by Dr. Sina and Dr. Mitchell because they heard that Mr. McClain was a runner. There's no evidence that Mr. McClain was a long-distance runner or incredibly disciplined. One witness says, I used to watch him run in the parking lot on breaks from work. But because someone said he was a runner, and because he went into cardiac arrest after ketamine was injected, well, it must be the ketamine. That's not proof. That's an assumption. They have not proven beyond a reasonable doubt that these gentlemen are responsible for the death of Elijah McClain, or that these gentlemen did anything to assault him or to give him ketamine for any other purpose than trying to treat him, trying to treat what they reasonably believed was an excited delirium.
Got about a half minute.
Thank you, Your Honor. More specifically, what did Pete Cichuniec that caused the death of Elijah McClain or assaulted Elijah McClain? He was the company officer. He made sure the scene was safe. He was on the radio giving directions to the ambulance to get them there. As the company officer, he tells them what tools they need: ketamine, soft restraints, gurney. When the ambulance gets there, he goes and gets the gurney and brings it to Mr. McClain's side. Then he takes the computer and starts inputting important medical information for the medical record.
Okay, your time's about up.
From his standard of care as the company officer, he didn't. He is not guilty. They are both not guilty. Thank you.
If I could have folks come up real quick. All right, we have the parties in council who are back. We'll bring the jurors in as soon as they're ready. Twenty-one CR 2800 and 21 CR 2806. The parties in council are present. The jurors are back after a short break. Rebuttal closed from the prosecution.
These defendants treated Elijah McClain like he was a problem, not like he was their patient. When Mr. Pello stood up here an hour ago and said that the police just put Elijah McClain into that category of non-compliant, so did these defendants. Because the moment that Defendant Cooper walked up next to Elijah McClain and heard, oh, here's another young man fighting with police, he put him into that category. He's a problem. And from that moment on, there was not a single thing that Elijah McClain could have done to save his own life. Because when Defendant Cooper walks up, Elijah McClain says, ow, okay. The police are hurting him. He is sensitive to pain. He's feeling pain. He is in reality. But in Defendant Cooper's mind, he's not paying attention to indications that Elijah McClain's not delirious because he's already picked him up and put him into that category. Problem. Non-compliant with the police. So when Elijah McClain, clear as day, says, I can't fix myself, Mr. Cooper, long before this body slam happens from one of the police officers, announces his plan. Well, we'll just leave him there. Because he is in that category. He is a problem because he's just another young man fighting with police. So when the police then slam Elijah down on the ground, just because he says, ow, sorry, and I can't fix myself, does the defendant change his behavior at all? No. He repeats exactly what he started saying before the body slam occurs. We're just going to leave him there until the ambulance gets here. Because if you have somebody that you think is a problem, who's just another young man fighting with police, then it's a lot more convenient. It's a lot easier if you don't get close to them, you don't look at them, and you don't try and determine whether they actually have excited delirium or not. You just leave them there, like you just announced, until it's time to max them out on ketamine. And that's exactly what you see on the video. This is as Mr. Cooper walks up.
No, no. When we tried to stop him, dude.
Come on. So, was this anything in speak English or anything like that?
He speaks English,
Yeah, he's.
but he's definitely not something. He's not.
Okay, at least once it's out. Okay, stop messing around.
Chill out.
Well, we'll just leave him.
You've already been told several times to stop.
I can't sense myself. Ow!
Just leave him there until the ambulance gets here, and then we'll just put him down to the attorney.
According to the defendant himself, when he testified on the stand, what he's doing there, and from this point on, is a visual assessment of Mr. McClain. That he's supposed to be paying attention to him. That's his whole job. He has medical control of this call and is supposed to determine what is best for Mr. McClain. So then while the police officer, Mr. Rodima, sticks his knee into Elijah McClain's back and starts cranking on his handcuffs so that in this next clip I'm about to show you, you can hear this horrifying popping sound while he does it. And Mr. McClain screams out, "Stop, please." While the defendant is supposedly conducting this rigorous visual assessment, he does nothing in response to any of that. And then, while he's supposedly conducting this rigorous visual assessment of his patient, Elijah McClain utters his last words on earth. "Please help me."
Just leave him there until the ambulance gets here, then we'll just put him down to the attorney.
Hey, I know you're busy, but I just to let you know that.
Doc.
We had a suspicious call over here on
Dude,
Bill.
chill out.
Exactly, kind of weird, nothing really criminal. My officers go to make contact with him. He starts acting crazy. They attack him. He's glad we end up trying to put a carotid on the guy. And actually.
Well, stop fighting us.
Put him out, they were ready to get him out of handcuffs, we're still struggling with him, I have fire on scene. And
"Stop, please. I'm trying. Please help me." This is all right in front of the defendant's eyes. You can even see his face looking over in the direction of the camera here. Elijah McClain is not delirious. He is responding to pain, saying he is trying and begging for the defendants to save his life and to help him. But the moment that the defendant walked up to the scene and heard another young man fighting with police, he put him in that bucket of non-compliant, just like Mr. Pello described. And what that means is that it was ketamine time, because he was not going to bother trying to figure out if this is one of the vast majority of cases where somebody has a cause of why they're agitated in custody that's just medical, that's not excited delirium. Dr. Hill told you that. He said, "I would expect a very small portion of the cases that fall under this excited delirium protocol and the agitated patient protocol to actually be excited delirium." He said there's reversible medical causes. And we know exactly what those were in this case. That Mr. McClain was hypoxic. He was short on oxygen because of the carotid hold. We know he aspirated, he threw up in his mask, and that got down into his airway. And because of that aspiration and the struggle, he's acidotic. The acid levels in his system are rising. That's why he's moving in handcuffs and trying to breathe. That is exactly what the defendant was trained to look for. That is exactly what would have been revealed if he'd done any sort of assessment besides just standing there and looking at him. These statements, "Stop, please. I'm trying. Please help me." They tell you everything you need to know about Mr. McClain's mental status. But they also tell you some very important things about the witnesses the defendants brought in here. Like the couple paramedics from Memphis, Mr. Ludwig and Miss McKinley. When they come in here and they say, "I am certain that this person had excited delirium," that tells you everything that you need to know about the credibility of their testimony. This person is responsive to pain, clearly understands exactly what's going on, and is begging for his life. He's not a naked guy crushing down a fence or lifting up a police car. He doesn't have excited delirium. Defendant Cooper has only been here for a few seconds. And he's going to decide to use ketamine in just a few more. You're going to hear, right after this, the conversation between both of these defendants in the background, where they say, "Do we want narcs or ketamine?" And when you hear that conversation, what you're really hearing is, on that agitated patient protocol, are we going to go down the left side for regular agitation, for somebody who may not be compliant for medical reasons? Are we going to figure out what's actually happening here? Because that's narcs. That's the benzodiazepines listed on the bottom there. Or are we just going to jump right over to ketamine? Because this makes it a lot easier.
That's where we're at. I just wanted to know, yeah, we did actually want to go on it tonight, so. And the other one, I don't, oh, you got him? Oh, I didn't know that. Okay, I knew he was busy. Just one other thing, we did have an officer get,
Yeah, that's all his, dude. That's what he was wearing.
used, okay. It was very minor.
So when the ambulance gets here, we're gonna go ahead and give them.
All the cops are okay.
Yeah, sounds good.
Perfect, dude. Perfect.
Far from being disgusted by this body slam, or by the officer driving his knee into Elijah McClain's back and cranking on his handcuffs so hard you hear that popping sound, the defendant is jumping right on board. Let's get him some ketamine. That'll be easier for all of us. He's been next to Elijah McClain for about 90 seconds. You have now in front of you the sum total of information upon which he bases this horrifying decision to max Elijah McClain out on 500 milligrams of ketamine. It gets worse. There's another 5 minutes and 25 seconds between this decision and when he actually injects the ketamine into Elijah McClain. There's all kinds of opportunities where Sergeant Leonard says, "Hey, make sure he can breathe," or where one of the officers leans over Elijah McClain and says, "Hey, you all right?" And there's no response. There's off-ramp after off-ramp for the next 5 minutes and 25 seconds where the defendant could take his foot off the gas in this blindfolded car. But he doesn't. Because as soon as he got on the scene, that decision was made. Another young man, and we're just going to give him ketamine. Now, this is not a situation where there is some good faith effort and just, due to their best efforts, they just made a mistake. These defendants did not even try. That's why we're here. If they tried, we're not here. They come up and all they do is look at Mr. McClain, ignore every one of his words, and immediately make the decision to do the worst possible thing. Give him a big overdose of ketamine that he doesn't need. And then after they choose to do the worst possible thing in the worst possible dose, They leave him there prone on the ground and again do nothing. They literally could have sat inside their ambulance, or excuse me, inside of their fire engine, walked up to Elijah McClain once the ketamine showed up, jabbed him with an overdose, and then gone back and sat in the ambulance until he got taken there by the police. And every single thing in this case plays out the same way. That is how atrocious this was. They didn't even try. Elijah McClain isn't delirious. And the defendants are jumping on board with what's happening here. You remember when Mr. Cooper said, oh yeah, I wanted to go jump in and help restrain his legs. When that officer said he was tired, I was going to go join in this physical restraint. But for some reason, even though he's totally fine and wants to, in fact, go jump onto Elijah McClain's legs to help with the restraint, it would just be impossible to do this. Had they even tried, done the basic ABCs, they would have found out what's really happening. Elijah McClain is hypoxic, acidotic, and he's aspirated. Even Dr. Dragovich agrees. Dr. Dragovich has a lot of problems. I mean, he accuses Dr. Mitchell of confabulating his report in a perfectly logical, completely factual sentence. And then Dr. Dragovich goes on to say things that are not supported by any evidence, like Elijah McClain was off wandering in traffic. But even he agrees that Elijah McClain has aspirated. If you just listen to somebody's lungs, put a little stethoscope there, get your ear down close. As you heard from Dr. Buther, you can hear those things. Dr. Dragovich also tells you that we would know if the ketamine caused aspiration too, because we would have seen vomit coming out of Elijah McClain's nose on the gurney. Well, apparently his poor review of the factual record extends to that, because on the video, Sergeant Nunez's camera, it very clearly shows vomit streaming out of Elijah McClain's nose and mouth. And you hear the same thing from the people who were on the scene. Now, Dr. Sundaram, there's a lot of problems with his idea that this is a cardiac problem. It's disproved by the autopsy microscopic results. It's not consistent with the video. But even if you were to try and believe what Dr. Sundaram is saying, it just makes the defendants guilty in a different way. Because of what's happening here is a cardiac arrhythmia and a fibrillation that causes cardiac arrest. There's a real easy way to have found out that there's a cardiac pulse problem. And instead, the defendants choose the worst possible thing to do, to give 500 milligrams of ketamine in this situation. As Dr. Buther said, they're blindfolded driving this car, shoving their foot on the gas. The charges in this case are reckless manslaughter, first and foremost. Despite what the defendant's attorneys told you, that does not mean they had to have a plan to kill Mr. McClain. That just means that their reckless actions killed him. You don't need to consider criminally negligent homicide unless you think that the actions are not quite to the level of recklessness, not quite to the level of conscious disregard of unjustifiable risk, but instead just represent a gross deviation from their standard of care. And then there's 2 assault charges, one for intending to cause bodily injury, injecting Mr. McClain with ketamine, but then unintentionally causing serious bodily injury, his arrest and his death. And then finally, unlawfully giving him that ketamine without his consent. Now, when you go back into that jury room to deliberate, it's going to be up to you how to proceed. The first thing you'll be asked to do is select the foreperson. Sometimes the natural thing is to select as the foreperson the loudest person in the room, but remember, you all have to return a unanimous verdict, no matter what that is. So sometimes it's best to pick a person who listens well, who can build a consensus and help people to agree on difficult issues. And then you will decide how you want to proceed with your deliberations, what you want to talk about. But let me suggest one thing. We've been in this trial for a long time. I was clean shaven most. It might be hard to remember some of the witnesses from early on in particular. And their testimony is important, as is everyone's. And before jumping into your camps of here's what I think, here's how we should vote, here's what we should do, it might make sense to go through all the witnesses. Talk about them. What was useful about their testimony? What was wrong about their testimony? Potentially most important, how credible is this witness and why? Now, there is a wide group of experts in this case who agree that Elijah McClain died first primary from a pulmonary arrest. Dr. Sina, the neutral autopsy person who just happened to catch this case. Dr. Moss, the only witness in this trial who actually treated Elijah McClain as a patient and actually evaluated him in the hospital, says that this was a primary respiratory arrest. And it was only after Elijah's lungs stopped working that his heart stopped. But then talk too about the quality of these experts. Because the people brought you some incredible doctors. Dr. Robinson, who teaches at Harvard, a preeminent anesthesiologist who uses drugs, sedatives like ketamine day in and day out. And oh man, when you saw him talk about the studies, he knew them backward and forward. He is a master of that literature of what we know about ketamine. Dr. Buther from here in Denver, world-renowned pulmonologist whose patients literally travel the globe to come see him for one specific reason. Because he's so good at figuring out what's wrong with folks. And Dr. Mitchell, who literally wrote the guidance paper that the National Medical Association uses for examining in-custody deaths. Probably the preeminent expert on trying to figure out what happened, why people died when they're in police custody. Who did the defendants bring you? Dr. Dragovich, the confabulator, a pathologist from Michigan, I don't know why, of all the counties in the United States, with no particular credential related to this case, whose bias is evident from the moment he opens his mouth. Dr. Sundaram, seems like he's a pretty good cardiac I forget even the title of his name, electrophysiologist, but he didn't even look at the microscopic slides of Elijah McClain's heart. The information he was fed was incomplete. And he doesn't even understand how aspiration works. He testified that it would have taken 2 days for somebody to die of aspiration. Even the paramedics know that if aspiration is undetected, if you have a lot of it, it can just block your airway completely and you can die almost immediately. Dr. Robinson explained a really crucial issue in this case, what it means to get what they're calling a therapeutic dose of ketamine. Whenever you heard that word therapeutic dose, what it meant was a dose you're supposed to get in a hospital with a doctor there. Because Dr. Robinson explained how the literature lays this out. There's a low dose that's sub-dissociative, so it doesn't even cause you to lose that connection with reality. That's 1 to 3 milligrams. And then from 3 to 5, there's that dissociative dose. That's that ceiling level that we heard talked about from Dr. Hurd and from Dr. Robinson, where you don't get more disassociated after that. This is also what's pre-hospitally cleared to be used. But once you get up higher to that 6.5 to 13 range, that is only supposed to be used in a hospital with a doctor there standing by, monitoring your airway, with all the equipment already attached, hooked up to make sure, ready to intubate you at a moment's notice. Because that is an anesthetic dose. It's therapeutic. We use anesthesia to help people when they go into surgery. So it is therapeutic in that sense, but it is a hospital-safe dose. It is not a pre-hospital safe dose. And with the overdose that the defendants gave Elijah McClain, he's up there. He's at 7.7 on this scale. When Dr. Hill testified that there's a wide safety envelope for ketamine, he said it was because it could be given in 3, 4, or 5 milligram per kilogram doses, and that he'd even heard in some places they go up to 6. That is a wide safety profile. That's a big range from 3 to 5 or even 3 to 6. But that's not what the defendants gave Elijah McClain. They gave him 7.7, way outside the safety envelope for pre-hospital settings. And the defendants knew that that increases the risk of side effects. And Dr. Hurd and Dr. Robinson testified to that. Dr. Hurd said it is in excess of the recommended dose for the protocol and is by definition an overdose. And I want to make an important distinction here because defense counsel has been kind of trying to mix two ideas together. That they're saying that a ketamine overdose really only occurs when you have 10 or 50 times the level of ketamine in your blood that you're supposed to. That's a toxic dose of ketamine where the ketamine just kills you because you're just so overwhelmed with ketamine. That is not what happened here. What happened here is Elijah McClain got a very unsafe hospital type of dose of ketamine that caused respiratory depression, hypersalivation, predictable, known, obvious consequences. And then because nobody was monitoring his airway and he's swallowing and breathing in all of that red vomit we see on the video, his airway gets occluded, he has respiratory arrest, and he dies. Dr. Hurd and I made this great chart on the piece of paper over here. This is the dose that Elijah McClain should have gotten, 325 milligrams. Had he weighed 220 pounds or even more, could have been a 300-pound defensive lineman for the Broncos. The maximum dose that ever would have been permissible is 500. And then, and only after you've given somebody that and they're still fighting and still out of control, the protocol would permit the paramedics to call back, talk to a doctor on the biophone, and say, we gave this guy 500 and he's still out of control. Can we give him more ketamine? And the doctor at that point in time could authorize only 250 milligrams more of ketamine. In that scenario, a 220-pound to 300-pound person who gets a max dose is still going crazy, and then you call a doctor and get permission, then you could have given that person 7.5 milligrams per kilogram. But Elijah McClain got even more than that. He got more than you were supposed to give a defensive lineman who you'd already max dosed, who you'd call a doctor for permission, and then max dosed a second time. That's how outside the range of safe, pre-hospital, and protocol consistent ketamine this was. But the real thing is that the right dose was 0. Because Elijah McClain didn't have excited delirium. Any agitation that he showed was obviously from the fact that he was having trouble breathing. There was no need for a single milligram of ketamine. Dr. Hurd, the defense's own expert, admitted to you that the side effects, the risks like respiratory depression, go up when the dose goes up. Yep. And that's in their training too. They knew about it. I want to talk and just finally put this coronary artery thing to bed. Because there are some big differences in the quality of evidence examined by Dr. Sundaram and the other doctors in the case. First, Dr. Sundaram, even though he supposedly was so concerned about what could be seen on the heart, whether it was wraparound, whether there was evidence of collateral circulation or not, he never bothered to have a conversation with Dr. Sina, who saw the heart. But Dr. Mitchell did. Dr. Sundaram testifies that you can't even die from aspiration unless it's a couple of days later. That's important because it demonstrates that he has such a narrow focus just on cardiac electrophysiology. All he does is burn little things in the heart. He doesn't understand the holistic picture here, but Dr. Sina does, or excuse me, Dr. Mitchell does, and Dr. Sina does for that matter. But most importantly of all, Dr. Mitchell, who has a concentration in cardiac pathology, was actually teaching courses on cardiac pathology as he was leading up to this trial. And he testified is currently running a study on cardiac pathology to be published in the future. He ruled this out because if the narrowed artery is causing problems downstream, if that's causing an arrhythmia or a fibrillation, it would only do that because the heart's not getting enough blood downstream. So that's why he cut the microscopic slides. And he said, I examined the ones distal or downstream from the narrowed artery, and there was no evidence of damage to those cells. So we know for a fact that this was not what killed Elijah McClain. Dr. Mitchell described it. We took more sections, we looked under the microscope, and there simply just aren't the changes that would be consistent with any major effect from that narrowing of the coronary artery. Dr. Sina ruled it out too. He said that he believes there was collateral circulation, that other blood vessels had naturally developed in Elijah McClain in order to serve his heart, which makes sense. Because like Madison Freeman said, he was out there running 3, 4, 5, 6 miles every single day, often running several miles just from the bus stop to get to work. Of course he would have collateral circulation. And when you're talking back there, I would urge you to consider witness credibility, because in this trial, you've really seen evidence of the thin red line and the thin blue line. The paramedics and the police on the scene come in, and you can see their thumbs on the scale with their testimony. And there are some ways in which it's clearly unreliable. But most importantly, there are a lot of important ways in which the defendant's testimony is unreliable. This is what Mr. Cooper says.
Okay. Where did you administer it? Patient.
If I remember correctly, it was the right deltoid, so his right shoulder area.
Okay. And while you were administering it, do you remember what the patient was doing?
Still actively fighting. Anytime that the patient would try to be placed kind of on his side, he would try to walk up the little grassy embankment, try to fight with the officers. So as he was quickly put onto his side, administered the medication.
What was he doing as you were administering the ketamine? Still resisting, trying to crawl up the grassy embankment? You can see on the video he's completely inert and not moving a single muscle. Why is the defendant so grossly misrepresenting these facts only a couple weeks after the incident? He clearly knows what happened. This was a big deal. Somebody poured out under their watch. Detective Ingoe says that he set up this interview with the defendants through their attorney like a week beforehand. They've had plenty of time to think about this incident and figure out what they're going to say in this interview. Then he's asked, at any time, does he stop resisting? And he says, no, sir.
Okay. How long do you?
And that interview is in evidence, so you can watch the whole thing. Then defendant Cooper makes up this other idea and says, I tried to get them to have the patient rolled onto his side to look at his airway and monitor his breathing. But of course, that's nowhere on any of the camera footage. He never asks anyone to move Elijah McClain onto his side until they're doing it to move him to the gurney. And he clearly knows why it's important, because he says it's to look at his airway and monitor his breathing.
I tried to get.
He's consciously disregarding the risks to Elijah McClain's airway from the ketamine and getting the ketamine in that prone position. Their protocols say don't restrain them in the prone position. They talk about why it's important because it can impair the airway and breathing. And then they tell you the technique that during the time somebody's in restraints, chemical or soft, continuous attention to their airway, circulation, and vital signs is mandatory. Continuous, mandatory, not let him sit there for 5.5 to 6 minutes and then finally check once you're in the ambulance. Their training reinforces these ideas. that they need to be worried about patients who are in the prone position because they can't expire off carbon dioxide, CO2. That means they can't clear acidosis. They're being warned and trained on the exact things that are happening to Elijah McClain. In opening, Ms. Began said to you, "Oh, look at this video. He gently reaches down and checks for the carotid, checks for the pulse there." And then Mr. Cooper doubled down on the stand and said, "I placed my hand in this region here to try and feel for his carotid pulse." That didn't happen. His hand goes down on Elijah's back, on his scapula, and it never moves a millimeter until that hand comes up and off of Elijah McClain. You can see how far down his back it is. It's way down by where the jacket's at. So why is Mr. Cooper telling you, "Oh, I took his pulse"? Why is that part of the defendant's opening statement? Because they know how crucial it is. It's literally the ABCs. Dr. Caroline tells him exactly how to do it. And Mr. Ludwig testified about why that stuff is important. Because if you don't even know the patient's pulse, how are you possibly going to figure out what's wrong with them? Mr. DeJesus agrees. Didn't look to him like anybody touched Mr. McClain's neck. Mr. Bradley agreed. Didn't see anyone take Elijah McClain's pulse before the ambulance. Alicia Ward, whose hands are in that photo because she's holding Mr. McClain's head. Did you see any of them take any vital signs? Nope, she didn't see it either. And even the defendant's own expert, the very last series of questions I asked him, he said, in his professional opinion, he is certain to a reasonable professional degree of certainty, based on his 35,000 calls, that this is not taking a pulse. The defendant is not credible. And the reason he's saying these things is to just try and give himself an excuse for doing such a horrible job and killing Elijah McClain. He is trying to cover up the recklessness of this conduct, the disregard of the risks to Elijah McClain. So instead of saying what Elijah McClain actually says, "Please stop. I'm trying. Please help me," he describes it as a lot of gibberish. And then says, a couple of times, I tried to ask him questions like a name. No, he didn't. At no point in time did he try and ask Elijah any questions. So why is he making this up? Because he knows how fundamental it is that if you think somebody is suffering from excited delirium, they are delirious and they are not connected with reality. So that's why they teach them to ask questions. It's the obvious thing to do. If I asked you with no medical training, how would you determine if somebody is delirious? Your answer would be, I will ask the person some questions and see if they are making sense. So he has to say this kind of stuff to try and cover up for the fact that he just jumped to excited delirium.
Did you have any communication with the patient?
He didn't have any communication with me. It didn't seem like he was ever forming any sentences. A lot of gibberish, a lot of yelling, things that I couldn't understand. They weren't words, they were just noises, grunts, things like that. There was a couple times that I approached the patient, tried to ask him some questions as far as a name, any kind of medical problems, but never got any kind of sensical language back as an answer.
5 minutes.
Thank you, Your Honor. A couple of times I tried to ask him his name and about any medical problems, because he knows how fundamental, how paramedic 101, how ABC those types of questions are, and he knows he never did it. And instead, he just jumped to a max dose of ketamine. If you're ever wondering whether Mr. Cooper was paying enough attention to notice, I can't even believe how silly this is, but it's true. Elijah McClain is begging for his life, saying, "Please help me." And in this video, Mr. Cooper does not even respond. And then a couple of seconds later, a cop sneezes and he tells him, "Bless you." He's clearly listening.
And actually.
Well, stop fighting us.
When they put the product on him, they put him out, they were able to get him out of handcuffs, we're still struggling with him, I have fire on scene, and that's where we're at, I just want to let you know, yeah, we did actually apply for product, right, so.
Bless you. Thank you.
And
He can hear perfectly well. Somebody sneezes in the background, bless you. But when Elijah McClain says, "Stop, please, I'm trying," and pleads for his life, no response. This is the individual that they had down on the ground. This is exactly the same clothes he was wearing, except instead of the red hoodie, when the defendants encountered him, he's got nothing on his face. You can see how tiny he is. This is a size medium jacket. It's in evidence. Go look at it. Even his shoes are in evidence. If you're wondering whether Dr. Dragovich is right that there's a heavy winter coat back there, go look at it. How can you possibly look at this person who's saying, "I'm sorry, I'm trying, please help me," and say he's 220 pounds and out of control? The entire defense hinges on this idea that they were acting within the scope of their medical license. But one requirement is that they actually have to be acting under the direction of a duly licensed physician. If they're outside the protocols, this doesn't apply. They also have to reasonably believe that they're promoting the health of a patient. But it's so clear from Cooper's statements that he is just skipping directly to excited delirium without doing anything, and that he's just treating this for convenience. And then finally, it also would have to be the case that a reasonable person would consent to the medical treatment, and nobody would agree to ketamine when they don't need it, certainly not to an overdose. There's no legitimate medical purpose for what's going on here. It's just excuses. The witnesses are all consistent about that. And the protocol that's in evidence confirms it as well. That's the standard of care. The standard of care is what Travis Chambers explained to you that they're supposed to do, how he trained them. What Dr. Hill explained to you, what they're supposed to do, how he trained them. Even Mr. Ludwig admits, I don't make the standard of care. It's in these protocols. But they didn't follow the protocols. Instead, they used ketamine as a chemical restraint, when they're specifically prohibited from using any kind of restraint as a punishment or for the convenience of the crew. Certainly, this appears to be the most convenient option. Even defendant Cichuniec admits he's not following the protocols. He says that he thinks the appropriate dose would be 425, but then goes up to 500 because of extra agitation. He admitted in that box on the right, that's from his trial testimony. That was the wrong dose. He agrees.
About 1 minute.
Thank you, Your Honor. And when they give these overdoses of ketamine, they're conscious of the risks and they're disregarding them because they're trained. That's the ketamine training slide. That appropriate dosing is what's needed to maintain somebody's respiratory drive. And large dosing increases the risk of things like respiratory depression. In this interview clip, Defendant Cooper can't remember any of the other side effects except the one that killed Elijah McClain, respiratory depression. At the end of the day, it's just like Dr. Buther said. This is reckless. It's not intending to kill. It's intending to cause pain, bodily injury, and stupor. It's not intending to kill, but it is wildly, insanely reckless. It's the medical equivalent of putting on a blindfold, jumping in a car, and hitting the gas as hard as you can. This was the worst possible care, very much in quotation marks, that Mr. McClain could have given. Like I said a few seconds ago, if they'd just stayed on the fire engine and done nothing, showed up and given 500 milligrams, the max dose they could give of ketamine, totally blind, and then gone and sat in their ambulance for the 5.5 to 6 minutes until Elijah McClain was brought there on the pram, this goes down exactly the same way.
Right. Your time is about up.
Thank you, Your Honor. And the key to this case is that's how bad it was. That the defendants didn't even try. And when Elijah McClain pleaded, "Please, help me. They left him there. They overdosed him on ketamine. They left him there again, and it killed him. And that's why they're guilty.
Do you and each of you solemnly swear or affirm under penalty of law that you will, to the utmost of your ability, keep the jury together in a private and convenient place, that you will not permit any person to speak with them, nor speak to them yourselves unless by order of the court, except to ask them if they have agreed upon a verdict, and that when they have agreed, you will return with them into court? At this time, I have to announce who the alternates are in this case. Originally, we selected 3 alternates that would serve if one of the other 12 jurors became ill or otherwise. The alternate jurors in this case are the jurors in seat number 11, who is juror number 12, and the juror who's in seat number 12, who is juror number 13. I want to remind you that I choose the seat numbers for the alternate jurors randomly before I even know who is summoned for jury service in this case. This is by no means a reflection of your performance as a juror. You just happen to end up in the seat number that was randomly designated before the trial for the alternate jurors. In just a few moments, I'm going to give those jurors 12 and 13, and seats 11 and 12, the opportunity to gather up your belongings. But importantly, and I'll stress importantly, I hope that everybody remains healthy and doesn't have an emergency during the deliberations. In that vein, I'm not discharging jurors 12 and 13 from your jury service yet. I'm simply excusing you temporarily. Please continue to follow all of the instructions I've been giving you throughout the trial, because there is a chance, and I hope it doesn't happen, that one of the deliberating jurors could unexpectedly become unavailable. I may be in a position I would need to call you to replace that juror. And as far as that goes, you may go on about your life as if you were doing before you first reported for jury service, but you must continue to follow all of my instructions until my staff notifies you that you are actually discharged from your jury service. So again, for those 2 jurors, 12 and 13, you shouldn't be forming or expressing any opinions or discussing the case with anybody until you are actually excused from jury service. Do you folks understand what I'm explaining? Okay. And what I'm going to do is I'm going to have one of my staff members escort the 2 of you out. We'll try to get some good information how to contact you in the hopefully unlikely event that one of the deliberating jurors becomes unavailable. So I'll excuse you at this time with the thanks of the court, and I'll need to instruct the 12 jurors who will deliberate a bit further. All right, at this time, I'm going to have the 12 jurors go back into the jury room. It's looks by that clock on the wall, it's a little bit after 5. The court was informed earlier today that one of the jurors has a family event that they have to be at not too long from now. So what I'm going to ask you to do is take your notebooks with you when you go into the jury room. We'll let you know that we lock the jury room door and we put a sign on the door so the cleaning staff won't go in there and mess anything up. We will be bringing you the verdict forms as well as the evidence that was admitted in this case. You should not take your notebooks anywhere else after retiring unless specifically instructed to do so by the court rather. And as I said, the evidence and exhibits and jury verdict forms will be delivered back there. It's important to bear in mind that you may discuss this case only when all 12 of you are together in the jury room and all of you are present. You should not attempt to discuss this case with other jurors or anyone else at any other time except when all of the 12 jurors are in the jury room. Again, I will caution you at this time, you should not attempt to conduct your own investigation of any facts. And that means no consultation with dictionaries, the internet, or any other sources of information. Your verdict must be based solely on the evidence admitted in this case and applying it to the jury instructions that you were read and given. What I'm going to do is just have you folks go back there and get situated. And then, quite frankly, I'm going to release you for the evening. But I would like to have you back at 8:30 a.m. We will bring you straight into the jury room. As I said, the evidence that's been admitted should be back there for you to examine. And you will likely be beginning your deliberations tomorrow morning. With that, again, I've used this example before, but it's, as far as I know, a true story. And that is a long trial, longer than this one actually, that occurred in the East Coast of the United States. And it was, again, a high-profile case. After the verdict came in, one of the sides that was in the case decided to do data mining. And actually, there are folks, IT folks, that are pretty good at it. And what they realized is during the trial, the jurors got to know each other pretty well, of course, because it was a long trial. And we're texting back and forth about the case to the tune of 7,000 text messages. So that ended up having a new trial, of course. So you need to follow the instructions. As I mentioned yesterday, there are a lot of people that are very interested in this case, and you have all put in a great deal of time and attention. So please follow my instructions. I'll ask you be back at 8:30. As I said, we'll bring you right back to the jury room to begin your deliberations. Drive safely and try to think about something else when you go home. All right, the jurors have went back to the jury room. Anything we need to talk about? All right, I would like to have counsel here at around 8:30 when they're supposed to be back in case we have some issues. All right. Thank you and have a good evening. We'll see you in the morning. Court will be in recess.